You approach the registry, they'll do the
I
needful.
have approached my.
Why? What happened? You
my-
couldn't get it listed?
In that order, my lord, on last occasion when it was posted before the dishonorable court, my lord, a wrong order was to take the matter with a different case.
Or maybe on the basis of the submissions made.
No, my lord, instead of mentioning criminal revision, it was mentioned typed as criminal petition, my lord.
Acha.
Otherwise, my lord, matter is pertaining to Jimma of fatal nuts, my lord.
Oh,
My lord. Can it be
Achha.
Monday, my lord, or Wednesday?
okay, Monday.
Apply.
May I please your lordship? My lord, same as the prior. I also beg to mention on criminal revision petition on Monday. I have
You approach the
For
registry.
orders-
There some mistake is
my
committed,
lord,
so allow.
in my case, I have approached 2 times before the registry, but the matter has not been listed.
Okay, it is in their notice,
For-
we'll get it listed.
Only for orders column, my lord. For orders, there is a delay. So the case was not numbered yet.
Acha, there is a delay. You have filed your delay condonation application.
Yes, yes,
So the appeal or whatever revision is not numbered.
yes.
Okay, it will be taken up. Registry
lord,
will list it.
Earlier, the matter was listed in the year 2024, July,
Hmm.
in the month of July 24, but yet the matter was not.
That condonation application was not listed after
No,
2024.
no, my lord.
Okay, next week, Wednesday.
Oblige.
Okay, please, lordship. Should I beg to mention item number 52, lordship?
Wait 1 second.
My lord, it is-
52.
is a criminal appeal matter. Lordship, in this
গরম
case,
লাগিছে গরম লাগিছে অকণ কেৰা চলাই দিয়া which item
52, lordship. My lord, in this-
অলপ দেৰি চলাই দিয়ে তাৰপিছত বন্ধ কৰি দিওঁ
my lord, in this-
I cannot hear 52
my lord, in this case,
this is criminal appeal.
my lord, in this case, there is a direction to prepare the paper book.
Huh.
And the paper book prepared, but there was no direction to provide this copy. Lordship, I am, your lordship.
I is also there.
Yes, lordship, we are waiting for IA, that's why, lordship, I am.
Okay, today you don't want to do it.
Lordship, today, lordship, because paper book was not provided to us. So your lordship.
It has come up for orders. Let us see what is the order.
Already the paper book prepared, I have seen the record. lordship.
But what about I? You cannot do it today.
After providing the copy, lordship, that's why we are praying for taking up the IA in the next week, lordship.
You want the copy?
Copy, lordship, copy was not provided.
Okay, as per heard Mr. M. Khan, learned counsel for the appellant. You have informed Mr. D.K. Bakshi
But I will inform you.
as well as HRA Chaudhary. His matter will also get postponed because it is tagged along with your matter.
No, lordship,
53 is along with your matter.
I will inform, because paper book was not provided, lordship.
You need not be here. We will see the order and then we'll pass the order.
This, that's why, lordship.
So you have
We are waiting for, lordship. some-
anybody appearing for Mr. HRA Chaudhary in the court.
Lordship,
You can inform him.
what is that? What is that?
Oh, yes, Mr. A. Ahmed. Item number 53 is along with 52 and he is mentioning 52.
It will- paper book will be there.
So 52, 53 will also get adjourned. What he is saying is that he did not get the copy, the paper book. Okay, he wants to go through and move the application, okay?
Lordship,
Heard Mr. M. Khan, learned counsel for the petitioner. The learned counsel submits that he has not received the paper book and that he will collect the same and would prepare and do the appeal on a later date. Prayer is allowed. List this matter on.
Next week, any date, lordship. I
List
will
this
list-
matter. Next week, there are only 2 days. List this matter on 10th of September.
But IA may be listed, lordship.
I is already there. It will be listed along with her.
Publish.
Mention for listing a fresh matter.
Please approach the registry. If they do not allow, then come.
May I please, your
There's no question of them not allowing. They will do it when the time comes.
May I please, your lordship, I beg to mention for criminal petition number 752/2026, long pending case, your lordship, so kindly listed on next week.
You approach the registry. They will do it. Because if I direct, it becomes haphazard. I mean, they have a system of listing everything. So you approach. Whoever is mentioning for listing, please approach the registry.
May I please, your lordship, I beg to mention for withdrawal on Monday, lordship.
TRP criminal 11/2026.
What? Petition, bail,
Yes, yes, on petition, not bail, TRP,
transfer
yes,
petition.
on Monday.
Okay, Monday.
Right.
Limited period, Your Lordship. Lordship, one criminal petition was listed on 25th.
I said whoever
Yes,
is
yes,
mentioning,
just
please.
one limited period, Your Lordship. It was by considering my mention memo, by order, it was listed on 25th. It was left over, Your Honor. The immediate urgency is that the NPW was issued. Now the proclamation is issued against the accused petitioner.
You have not appeared.
There was I had a reasonable ground, Your Honor, for non-appearance. I was represented.
You should have
Therefore,
told your advocate to appear.
Exactly, Your Honor. I was represented by my advocate.
Still then
Lordship.
NPW.
Yes, Your Lordship. That is the thing. Now it's a POCSO matter, Your Lordship. I had to wait for a notice to was issued to the respond number 2. Then the matter was listed again. That on 25th it was left over before this honorable court, Your Lordship. That is why. Kindly, my peers, consider.
Okay, next week, Thursday.
Kindly on Monday, Your Lordship. Kindly.
Monday, there were
If
so
the
many
proclamation
matters.
is issued, Your Honor, then now they have.
No,
for
Wednesday at best.
Wednesday. Oblige, Your Lordship.
May it please your lordship, I beg to mention item number 15 of today's daily list.
50,
15.
15 years. Why you don't want to do it today?
Yeah. Learned counsel, Mr. S.K. Talukdar is out of town, so matter may be passed.
Who is the counsel you said?
S.K. Talukdar?
SK Talukdar is otherwise not there in
I
item
think there is
15.
an error in the process.
Okay, your name please?
V. Lohe.
Miss V. Lohe, learned counsel for the petitioner.
Your lordship, if it can be fixed on next Wednesday, that is on 2nd September.
Lohe, learned counsel for the petitioner submits that the conducting counsel has some personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed. List this matter on 14th of September,
14.
next to next week.
May it please, your lordship. Lordship, with the consent of the order, said I beg to mention item number 34, lordship. Conducting counsel, Mr. P. Bordolo is out of station, lordship.
Acha. You are for respondent. You have informed the petitioner side?
Yes, lordship. We have submitted the adjournment slip, lordship.
Okay. Miss
B.S. Ojha.
B.S. Ojha, learned counsel for the respondent number 2, submits that the conducting counsel, Mr. P. Bordoloi, has some personal difficulty and has prayed for some personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed. List this matter on 16th of September.
Obliged, lordship.
My dear Lordship, Lordship, in item number 48, I have filed an affidavit of. which
Okay, you
didn't come in
can,
the-
you want to call it. Okay, give the requisition.
Praying for listing of a criminal petition.
Please approach the registry. They'll do the needful. Okay, they know how to list it. Yes, Mr. Ahmed?
I think item number 32 and 33.
Huh.
Here, Lordship, I have challenged the proceeding of a criminal case, Lordship. There is no stay, Lordship. So
Hmm.
before rising, Lordship, this matter may be heard, Lordship.
Okay, hope it reaches.
Lordship.
Because there are so many motion criminal petitions.
Before rising as last item, Lordship.
You point me out. Okay, what is item number 30?
32 and 33.
Okay. Mati dibo, huh?
I am appearing in item number 2, Lordship.
Who is there for one? You're for one. Okay, let me take one first or two first.
Yes, your Lordship, both are of the same FIR, Lordship.
Okay, two first.
Lordship, here is the FIR at page 18, Lordship.
Wait, there is a, okay, item number 2 to Dioxin?
Lordship.
Oh, yes. 2.
The gist of
Wait,
the.
there is an order what? Oh, case diary.
Case diary.
Case diary and postmortem reports are there.
Yes, my lord, case diary received, my lord.
Postmortem?
Yes, it is also received, my lord. But why it has come in the motion column, my lord, that.
This is
So
surprising.
it was
it should have
There is
come in the
already an order.
Bail hearing, my lord.
It should be for bail hearing.
the same matter, Lordship. CD has received, we are behind the bar for 47 days, Lordship.
How many days?
47 days.
40.
The gist of the allegation is, Lordship,
Where is
on
the
the-
FIR?
FIR is at page 18, Lordship.
Okay. Yes, what are you saying?
In bill 2,
No, you are saying the gist of the FIR is what?
Lordship, that on 10/7, there was a incident of allegation that I went to the house of one friend, common friend, assaulted the deceased.
Who is the deceased of the friend?
Deceased was one of our friend, Lordship,
Another friend.
another friend, a common friend. Then on the next day, I went to the house of the deceased, took him to the local hospital. Then on being referred along with this informant, we took him to the Dhubri Medical College, where he succumbed to the death.
You assaulted, you only took him to the hospital?
Yes, Lordship.
Hmm.
That is in the FIR itself, Lordship. If your Lordship goes to the page 28 of my petition.
Acha, let me see the first, the FIR.
Lordship.
Anyway, how is the translation? It is okay?
Lordship. Yes, yes,
Okay, let me read page 11 then.
Lordship. Translation part is at 11, Lordship.
I'll read it myself. You are Shyamal Roy?
No, I am Biswajit, Lordship.
Biswajit Roy.
Shyamal is the house in which the incident, alleged incident took place, Lordship.
Okay, then you are Biswajit Roy.
Lordship. And
So in fact, the dinner was at Shyamal Roy's place,
Lordship.
and these two accused person had also gone there
Lordship.
and assaulted
That is the allegation, Lordship.
you had also gone there
Lordship.
and assaulted the brother of the informant and grievous injuries.
Lordship.
Later that night, Shyamal Roy took my brother to his house. So brother came back.
Lordship.
Brother came back
Came back to his own house.
with in an injured condition.
So far his and my role is concerned, Lordship, on knowing that he is ill. On the next day, we went to the house of the Biswajit, deceased, took him to hospital. And
No,
then-
you did not take. Shyamal Roy took.
No, on the first night, on the second night.
Later that night, Shyamal Roy took my brother to his house.
Lordship.
On the next day,
On the next day,
11/7,
I'm talking of the next day, Lordship.
the below mentioned accused number one
One.
of Biswajit Roy,
Lordship.
without informing anyone, took my brother to local civil hospital. Okay, then
Then we took, along with the informant, we took him to Dhubri Medical College.
he came from Kokrajhar to so-and-so,
Lord.
and on learning, below mentioned accused now took my brother to Rupsi. Rupsi. I also went there and I found injuries on being along with so-and-so. Okay, then
Then where in Dhubri, he died, Lordship. I have a next one, cause of death certificate, Lordship, at page 28, Lordship, of my petition, Lord.
yes,
In which, Lordship, immediate cause of death,
pneumonia, alcohol withdrawal
aspiration,
seizure.
pneumonia. Subsidiary cause is alcoholic withdrawal seizure.
Alcoholic withdrawal seizure means
He did not get the alcohol for last 2-3 days. He is an alcoholic, Lordship. He did not get the alcohol, consumed alcohol for last 2-3 days.
that
Then
that
manner of
resulted
death,
in
Lordship,
seizure.
just column 3, manner of death, Lordship,
Natural.
normal.
Okay.
No injury marks found on his body. Nothing was, it is an just death, simple death, Lordship.
So you had moved an application before the trial court?
Yes,
What
Lordship.
it did? It was rejected. Where
It was
it is?
rejected. I have annexed the copy, Lordship, at
Where it
page
is?
31 onwards.
31. Witnesses have seen the quarrel between accused and the deceased.
Lordship. That CD is available before your lordship.
Mhm. Beating the deceased. Okay. So what are your grounds for bail?
Lordship, we are behind the bar for last 45 days. No cause of 302, Lordship. Nothing there, Lordship.
Mm.
It is a normal death, Lordship. Had it been even assuming for a moment, a small incident of assault that was not there, it is the death because he did not consume alcohol for last few days.
Okay, what do you say, Mr. Burma?
My lord, we have received the case diary, my lord, and as per the postmortem report, my lord, the death was due to coma resulting from the injuries sustained over the head, my lord.
Mm.
There are some head injuries, my lord. Even the postmortem report also reveals, my lord. There are some.
Acha, otherwise this injury report is by the first
That
hospital.
is the, my lord, whatever my
Dhubri.
learned friend has referred to, my lord, he has annexed, my lord. That is the, my lord, immediate certificate, my lord. There has to be a death certificate, my lord.
Mm.
That was issued by the, my lord, on the day, my lord, while he was, dead body was discharged, my lord. Thereafter, my lord, postmortem was done, my lord, and this is the postmortem report, my lord. But however, my lord, the viscera were preserved and sent for FSL for chemical analysis, my lord. Now, my lord, regarding what are the materials collected during investigation, my lord. Now, my lord, I'll just, my lord, submit one thing, my lord. This accused person, my lord, Biju Roy and my lord, Biswajit Roy, alias Kartik, my lord. They were, my lord, the deceased used to work in his house, my lord, as a laborman. This is, my lord, poor laborer, my lord. On the day of incident, my lord, the deceased and one Syamal Roy, my lord, they decided to, my lord, have some dinner together, my lord. Then while they are preparing for dinner, my lord, these two accused person, they came, my lord, and then entered the house, and they assaulted Syamal, my lord. Then out of fear, my lord, Syamal Roy fled away, my lord. Thereafter, these two persons, my lord, assaulted the deceased, my lord. Then he sustained some injuries, my lord. Thereafter, my lord, once the Syamal Roy came back, my lord, to his house, then he is found, my lord, the deceased, my lord, he was not well, my lord. So he kept his in his house, my lord. On the next day, my lord, this accused person, they came to this, my lord, house of the deceased, my lord, and took him to the hospital, my lord. And immediately, my lord, from that hospital, he was referred to, my lord, Dhubri Medical College. And before reaching Dhubri Medical College, my lord, he was declared
But
dead.
there was no intention on the part of the accused person to hit him. They in fact assaulted Shamal.
They have assaulted Syamal. After that, they have assaulted, my lord, this Ranjit, my lord. Why, my
Shamal
lord,
fled
then-
away. Maybe they were intoxicated.
No,
What happened?
whatever they may be intoxicated, my lord, this is the investigation stage, my lord. And final cause of death, my lord, the postmortem report all reveals, my lord, sustained, my lord, death was due to coma resulting from injuries sustained over the head, my lord. This is a vital part of the body, my lord. Secondly, my lord, the FSL report is yet to be, my lord, collect, my lord. So
What
that
is the stage of investigation?
but the investigation, my these two accused persons are arrested, my lord. FSL report yet to be collected, my lord.
Maybe only for FSL collection.
Yes, my lord. Then Lordship may grant some time, my lord, will produce the FSL report, my lord. What is there, my lord? Because my learned friend is
You were
submitted, my lord.
arrested for
47 days, Lordship.
both.
Both, Lordship.
Both were arrested on the same date.
Yes, Lord.
But admittedly, they had taken him to the hospital.
Yes, hospital, my lord. And after, my lord, when he was declared dead, both of them fled away, my lord. Why, my lord, then? If their intention is good, my lord, they should not. If I take a person in bona fide nature, my lord, to a hospital to save him, my lord. After he is declared a Salai, fled away, my lord, from the police.
Acha, there are witnesses who had seen
Yes,
the
my lord,
incident.
yes.
There should be some evidence that yes,
It
he
is
had assaulted,
reflected in the.
causing injuries on head.
Acha, send me the postmortem report and whether there are any independent witnesses who have seen the incident.
Independent witness, my lord, some of the witnesses said, I have heard hue and cry, my lord. There was some altercation going on, man, between the Ranjit Roy and my lord, this accused person, my lord.
Mm.
But my lord, regarding assault part, my lord, because they have heard from the outside of the house, my lord,
Mm.
where Ranjit Roy was.
No one had actually seen the assault.
Assault, my lord, assault part has not seen, my lord. That is my fair submission, my lord.
Acha, give me that, send me
Yes,
that.
ma'am.
Heard Mr. S.K. Poddar, learned counsel for the petitioner, and Mr. R.J. Bora, learned APP for the state. By this application, the petitioner has prayed for bail.
My lord, Lordship is allowing this application.
Let me see, I'm dictating thereafter, I'll decide. What?
Question is that, my lord, my humble submission, my lord, but since my learned friend submitted, my lord, he has died, my lord, there are some medical report which he has, my lord, annexed along with the bail application. That due to some, my lord, alcoholic, my lord, what he has
That's the
stated, my lord.
doctor's report. Lord.
Yeah, so, my lord, let the, my lord, FSL
I
report be
have-
called for, my lord.
Lordship,
Because this is a
my
case of, this is a case of
report.
103, my lord. This is a
Acha,
case of
we'll
103,
see
my lord.
that postmortem.
And there is a head injury, my lord, that is clear from the postmortem report, my lord.
What will FSL do? It is because of the assault on the deceased.
Yes, my lord.
Okay,
Lordship is-
by this application file and by this
Yes, yes, yes.
application, the petitioner has prayed for bail with in connection with Kajigaon PS case number 27 of 26, registered under section 103 slash 117 within bracket 2 slash 35 of BNS 2023. The FIR in connection with which the petitioner was arrested was lodged on 12/7/2026 by the brother of the deceased, stating inter alia that on 10/7/2026 at around 7 p.m., when his brother went to the house of one Shamal Roy for having the dinner, the petitioner, along with another, reached the house of Shamal Roy and assaulted the brother of the informant and caused grievous injuries. Full stop. It is further stated that Shamal Roy took, later that night, Shamal Roy took my brother to his house. It is further stated that Shamal Roy took his brother to his house later that night of assault, and that on the next day, that is on 11/7/2026, the petitioner took the injured victim to the hospital, to the civil hospital, and later on, for better treatment, the injured was taken to Dhubri Medical College and Hospital, Dhubri, along with the other accused person, as well as the relative of the deceased. Full stop. It was thereafter stated that during the treatment, the injured person died on 11/7/2026. Mr. S.K. Poddar, Learned Counsel for the petitioner, submits that it was the petitioner and the other, it was the petitioner who took the victim to the civil hospital first, and thereafter, with the help of the other accused person, as well as the relative of the deceased, relative of the victim, took the victim to the Dhubri Medical College Hospital for better treatment. The Learned Counsel also submits, also places reliance on, where is the medical certificate?
Page 28, 27 and 28.
Has also relied on the medical certificate of cause of death issued by
Dhubri Medical College.
issued by where is that? Yeah, issued by Dhubri Medical College and Hospital, wherein it was stated that the cause of death of the deceased was due to aspiration, pneumonia, pneumonia, aspiration pneumonia. And as regards the antecedent cause, it was reflected that the deceased died due to no. As far as the antecedent cause, it was reflected that the underlying condition was alcohol withdrawal seizure. And the manner of death was reflected as natural. Full stop. On the other hand, Mr. R.J. Borua, learned APP for the state, by relying on the case diary, had stated that although there were no eyewitnesses to the occurrence, but by relying on the post-mortem report, he submits that death of the deceased was due to coma resulting from the injuries sustained over the head. Acha, before that, you also write, it is also submitted by Mr. Poddar that the petitioner was inside the jail for 47 days. The learned APP further submits that that the contents of the stomach was sent to the FSL for examination, and the said report was yet to be received by the police personnel. On consideration, here their statements vagera is recorded, right? On consideration of the submissions made by the learned counsels, more so in view of the fact that the petitioner was inside the jail for 47 days and his statements and all were also recorded, and most of the investigation seems to be over, and only seems to be over with the remaining task of receiving the FSL report. This court finds it fit that the petitioner be released on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of,
CGM,
CJM
Kokrajhar.
Pokrajhar, under the following conditions. What about the next one? He is the other one.
Yes.
Biju Roy. The same facts will be there. No, there will be some difference. Okay, by this, ये तो same ही होगा. Then you write the FIR in connection with which the petitioner was arrested was lodged on so and so way hoga, was lodged on 13/7/2026. Oh no. Where is the FIR? 10th, na?
FIR is on
Same
page-
FIR.
Same FIR.
But no, it's different FIR.
Same FIR, Lordship. FIR is on page 10, Lordship. The original
But then
version is on page 18.
the way of writing the FIR is different. What?
Same page.
Same things.
Yes, same FIR, Lordship.
Okay, so and so. Acha, translation is little different.
Translation may be.
Okay. क्या बोला? They lodged on so and so by the brother of the victim, stating inter alia that same होगा, inter alia that his younger brother went to वो एक ही होगा, only that later on you say श्यामल तक तो ठीक होगा. Yes. Thereafter on the next day जो है ना 11/7/26 उसमें थोड़ा सा change होगा. 11/7/26 at around 9 a.m. Accused number 1, namely Biswajit Roy, took the victim to the local hospital, and then thereafter the petitioner, along with the other accused as well as the relatives of the petitioner, took the relatives of the victim, took the victim to the Dhubri
Dhubri
Medical College and Hospital, Dhubri, for better treatment. Okay, then you write. It is also stated that while undergoing treatment, on 12/7/2026, the victim met his death.
On 11/7, Lordship.
Mm-hmm.
On 11/7, he died.
12/7 it is written.
In forwarding report, 11/7/2026.
Acha, but your translation is wrong. Page number 11.
Yes, ma'am. Lordship, page number 21, the forwarding report, it's there, 11/7/2026 at 3:50 p.m.
Acha, 11/7/2026, he died. Okay. Mr.
PK Das, Lordship.
P.K. Das, learned counsel for the petitioner, submits that it was the petitioner who had taken the victim for better treatment to the Dhubri Medical College and Hospital, Dhubri, along with the other accused person as well as the relatives of the victim. Mr. Das had also you have also annexed the medical certificate.
No, Lordship. No medical certificate. We have just annexed the 48, Lordship, section 48, whereby they have observation, Lordship, regarding
that page?
their cooperation and regarding that they had taken them to hospital.
Okay, they had taken that too. I've written it. Any more submissions?
No, Lordship.
On the other hand, Mr. R.J. Borua ka same ही होगा. Submitted that on perusal of the case diary. So same, I think same. Upon consideration of the submission made by the learned counsel, more so in view of the fact that the petitioner was inside the jail for 47
days.
47 days, and that the investigation is almost at the completion. This court directs that the petitioner be released on bail on furnishing same. Yes. Petition is disposed of. It would be developed. Item 3, yes. Huh? Yes, Mr. Bhattacharya, yesterday's matter, right? But what is the item number? If Mr. Hajorika allows, I can take up this matter and free Mr. Bhattacharya. Immediately after that, I'll take up yours. Yes?
Leadership, my learned friend wants to file a reply to my
Oh,
IA
to your IA.
and seeks 4 weeks' time. So it may be listed on 30th of September.
Okay, fine. Right. Okay.
If that's
Sounds
convenient to,
Interim.
Interim is there.
yes, interim.
Okay. Heard Mr. A.K. Bhattacharya, learned senior counsel assisted by Mr. D.K. Bhattacharya, learned counsel for the petitioner, petitioners, and Mr. P. Chaudhary,
PN Chaudhary.
P.N. Chaudhary, learned,
Counsel for the intermediate applicant.
no, respondent, who appears for the respondent?
Respondent is sole respondent.
Myself.
And Mr. B. Sharma, learned,
Special people left, madam.
special PP for forest.
For forest.
Learned special public prosecutor for the forest department. Mr. The learned senior counsel submits that he requires some time to file the reply to the interlocutory application.
Intermediate application.
Interlocutory application filed by Mr. P.N. Chaudhary.
Milord, I'm with Miss Sabana Begum.
Okay, Mr. P.N. Chaudhary, assisted by Ms. Sabana Begum.
I'm assisting her, Milord. It's okay.
Okay, so reply to the interlocutory application filed by the
Intermediate applicant.
respondent which?
I'm not a respondent, Milord. I'm not.
Intervener.
I'm trying to be an intervener in this matter, Milord. I'm trying to assist the state. And the,
You are the informant or what?
I'm not the informant.
He is nobody.
I'm basically,
So whether the court has
Recognize-
permitted you to intervene?
Milord, we're seeking
is
the
at the mercy
intervention.
of the court.
In a previous case, I was here, Milord, when there was a killing of 5 monkeys in the same area. I filed a case and Justice Ansari, as he was then, recognized me as the wildlife supporter and conservationist. Milord. So on that basis, since this is an elephant Schedule 1 under the Wildlife Act, there happens to be some lacunae in the evidence seen during the charge sheet. That's why I thought I'll bring it to my lordship
Where is your
as an
ID?
assistant.
1st of October.
Okay, so wait, it no? You cut that, huh? So and so appears for so and so and so and so, huh? It is noticed that an interlocutory application was filed by Ujjal Nayan Hendik.
No, Milord. Apurva Ballabh Goswami.
Where is that?
Apurva Ballabh Goswami, Milord, page 4.
Page 4. Acha, acha. You are the applicant, proposed intervener.
Milord. A lady.
Interlocutory application was filed by the applicant. That is the proposed intervener. Not proposed, that is the intervener. Shri Apurva Pallav Goswami. Why have you filed this IA?
There are certain lacunae during the framing of the charges under the Wildlife Act, Milord.
Acha.
And I wish to bring that, I wish to assist the state. I'm not interfering in the charges so framed, but
Huh.
certain lacunae because the petitioners, Milord, are the estate officers of the Numaligarh Refinery Limited.
Okay.
So they're supposed to be responsible for all the safety within the estate itself, Milord. For both
Acha,
humans-
what have you mentioned in your petition as to what work that you do?
Milord, I'm basically a conservationist in that area. I also, Milord, take a keen interest in, because that area is one of the areas which falls under the Butterfly Park, which is adjacent to the Kaziranga National Park, which is a World Heritage Site.
It is near the Kaziranga site?
Yes, Milord. It's an elephant passage through that thing. There's a NGT order also which asks the NRL to break down the wall.
Any recognition from some
Milord,
authority?
this court itself, Milord, Justice Ansari,
That
as
is
he was
entirely
there,
on different
he,
facts,
Milord,
Let it come,
recognized
we'll
me
see.
as a
Okay.
wildlife,
To that aspect also you'll reply.
Yeah.
Milord. So that was.
Okay, Mr. So-and-so, Pallab Goswami, full stop. It is stated that the intervener is a conservationist and is involved in the conservation of the wildlife in the area
My lord,
near Kaziranga National Park
Golaghat and that other district also.
in the district of Golaghat.
And also the next district, which is
But
Nagaon.
those things may not be mentioned now. We have got serious objection. to
Okay,
this
okay.
place.
That also I'll write that you have objection. And yes, to full stop, to filing of the instant interlocutory application by the intervener is objected to by the learned counsel appearing for the senior counsel appearing for the petitioner. As such, the maintainability of the IA is opened for consideration, is left open for consideration on the next date. However, the learned senior counsel for the petitioner submits that he requires some time to file his objection to the said interlocutory application. Prayer is allowed. List this matter on
1st of October.
1st of October. Okay, Thursday, 1st of October 2026.
Be obliged.
Interim may continue.
Yes?
Interim could.
What kind of interim?
Stay
Right.
Trial is stayed. The interim order passed earlier shall continue until the next returnable date.
both depends.
Both the petition, yes.
Repeat
There were
that.
two,
The two. my lord.
61 and 62, both, dono mein likhna. Same order. Same order.
My
I is filed in 62 also.
my lord, on 28th of July, my lordship, ladyship had attached both the matters together.
Acha, acha.
It is a common FIR and a common charge sheet. Only that accused are.
Acha, in 62, you write that appearance and all, and the matter be listed along with the other application. And in the meantime, the interim order be continued till the next returnable date. There, I is only one.
My lord, because my lordship on the last date had attached both the matters to be heard together.
I you have filed in item 61.
I have mentioned both the
Both.
things, my lord, because it is common order. You, my lordship, have attached the thing that it's a
Then
common
it will be
charge sheet,
same.
common-
Isme bhi I wala likh dena.
Obliged.
Yes, Mr. Hajarika.
Regular bail application. Prisoner was arrested on 29/7,
So, Amit,
31 days in
Amit,
custody.
when you give me this order, give me the file also. Yes,
He is custody for 31 days. Lordship will find the FIR page 16, the particular.
page 16.
16. The case of 108 million. ENS.
This is in Assamese, right?
Yes,
Translation is where?
yes, page 11.
Hmm?
Page 11,
Translation is okay, right?
right,
You are Mridul Ali,
yes.
accused number 1.
Yeah, accused number 1. The 2 and 3 are the parents.
Huh?
2 and 3 are parents of middle and
2 and 3 are what?
parents.
Parents.
Well,
For them, bail application is not
No,
filed.
madam. Their statement has been recorded and
They are also arrested.
no, they are not arrested, but their statement, they are the very old people,
Acha.
madam. They are allowed to go on.
Huh. And the person has died, right?
Lordship,
Committed suicide. Okay, let case diary come.
Lordship.
Right. Heard Mr. P. Hajarika, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Tiok Police Station case number 76 of 2026, registered under section 108, 3 subsection 5 of BNS 2023. Call for the case diary. No charge sheet, right?
No, madam.
Call for the case diary. List this matter on
As your lordship directs, 7th.
On 8.
8th of September.
Public.
please, Your Lordship.
Hmm.
Lordship, my primary contention is that I am not the FIR named accused person.
103 is there. Let the
Yes.
case diary come.
Lordship, just 2 minutes, if Your Lordship hear me. Lordship, I have been arrested 2 months after lodging of the alleged FIR, and there is no implication against me in the alleged FIR. And also, the grounds of arrest were not served to me, neither to my family members. These are my grounds.
Where is your FIR?
Lordship,
Page number 11.
yes.
When did he die?
He died on 2026.
And the FIR was lodged on 26.
23. 23.
23.
Yes, 5 days after the alleged incident. And I
You have written 26 in the translated copy. Oh, this 3 is like 6 in English.
yes.
So 23. So he died on 20 and FIR was filed on 23.
23. And I have
And
been
that was
arrested-
against Azim Ali.
Yes.
Oh, what? It was against Rizul Ali.
Yes. And I have been arrested on 3/4/2026.
Where is the forwarding report?
Forwarding report is in page 19. And I am one Samsul Haq.
He revealed about his involvement.
And Lordship, we have perused to the BNSS notice 47 and 48, page number 22 and 23. Lordship, the grounds of arrest,
Huh.
which are said to be written in here in handwritten form, this does not consist the actual grounds of arrest. These are falls under a category which it is reasons of arrest, which has been clearly defined in crystal clear language in Prabir Purkaista Lordship, the difference between grounds of arrest and reasons of arrest.
And to relatives it was given what?
To relatives also the same information was sent, which also consists of the reasons of arrest and not the grounds of arrest. Lord. I in fact have the certified copy also, Lordship, of 47.
It's okay. Mr. B. Sharma, let him be on bail. But it is pre-arrest or what?
No.
Bail.
No,
So he has been inside
Study since 4 months.
4 months.
4 months, then Lordship,
Lordship,
will
another
be entitled to default bail, Lordship, because 4 months will be exceeding the 90 days. period.
charge sheet has been filed.
More
Or
than-
charge sheet is submitted.
Charge has also been framed. My contention is that I am a local resident of that particular place, and also my grounds of arrest were not intimated to me.
Let the- let the
Consider-
records come, Lordship, because charge sheeted, if the charges has been framed, let the records come, Lordship.
It's okay. The allegations are not against him. And in the forwarding report also, nothing is written. Only that he has admitted.
But Lordship,
What
charges
admitted?
has been framed, Lordship. If
Charges are framed. He will appear before the court on each date. Okay, heard, Miss
Albany.
L. Banik, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Sessions case number 56 of 2026, arising out of Mukalmua Police Station case number 23 of 2026, registered under section 123/103, subsection 1 of BNS 2026. Pending before the Learned Court of Session Judge, Nalbari, Assam. The FIR in connection with which the petitioner was arrested was lodged on 23/2/2026 by what?
By Jaitun Biji,
by the mother,
mother.
by the mother of the deceased,
Yes.
wherein it was stated inter alia that the son of the informant had come out for his work on 19/2/2026 and and went to the house of the accused person, Mr. Rizul Ali, namely Rizul Ali, as mentioned in the FIR, and had tea in the house, TEA had tea in the house of the said accused, and that after consuming the tea, the son of the informant felt unwell and that he was admitted to the hospital. Full stop. It was also stated by the informant that her son was taken to GMCH for better treatment, but during the treatment, her son died on 20/2/2026. The learned counsel for the petitioner submits that the name of the petitioner was not mentioned in the FIR and that he was not involved in the said offense. The learned counsel has not involved. The learned counsel further submits that in the forwarding report also, the materials against the petitioner was not mentioned, barring BARRING, barring that the petitioner has himself admitted his involvement. The learned counsel has also raised the violation of section 47 and 48 of the BNSS to the effect that while giving the notice under the said sections, under the said provisions of law, sections under the said provisions of law, the particulars of the offense was not mentioned therein. And whatever was mentioned in the said notices was only with regard to regions of arrest and not grounds of arrest. Mr. B. Sharma, learned APP for the state, on the other hand, submits that during investigation, the involvement of the petitioner was found out by the investigating officer, and as such, he was arrested. As such, he was arrested by the police. Full stop. He further submits that charge sheet has been submitted against the petitioner and others, and the charges are also framed. And the trial has started.
Trial has started, but evidence has no witnesses has started.
Charges frame means trial had started. Okay. And the trial is going on. Upon consideration of the submissions made by the learned counsels, more so in view of the fact that there are no, more so in view of the fact that the petitioner, that no materials were stated against the petitioner in the forwarding report, and also due to the fact that basic particulars of the offense were not mentioned in the notice issued under section 47 and 48 of the BNSS 2023, as is required under the law and as is provided for by the Honorable Supreme Court. This court deems it fit, this court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of session judge. Session judge, which place? Which place? Nalbari. Session judge Nalbari. Under the following conditions, he will appear before the court on each and every date without fail. He will not tamper with the evidence. He will not influence the witnesses. He will not leave his place of residence without the permission of the session judge Nalbari. Okay. Petition is disposed of. 5. Yes, Mr. Ali.
Please a lot. The FIR that case, my lord, 11 mile. Two petitioners, my lord, they
So many provisions, 121, 118, these are cheating. What?
No, my lord, assault, my lord,
Assault.
assault. My lord.
Where is the FIR?
Page 11.
How many petitioners?
Two,
Two.
my lord.
Imadul and Akhtar.
Or
Page number 11.
11.
Assault on police personnel.
This is the allegation, my lord. Purely civil dispute between two parties, my lord. Now, as per forwarding, my lord, page 15, prime accused, my lord, they will,
Attacking with sharp edge weapon. Let the case diary come.
lordship kindly see forwarding report, my lord, page 15. The prime accused has been taken custody, my lord. We are the
15.
resident of the area. We were, after hearing, my lord, the incident, we appeared there.
And let the case diary come. Right. Because you have attacked them with sharp
And-
weapons. And whether you were a part of the group who were there inside the small hut or you were some strangers, that will be seen in the case diary. Heard Mr. R. Ali, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. By this application, the petitioners have prayed for bail in connection with Hattigaon PS case number 172 of 2026, registered under various provisions of law. We'll call for the case diary. List this matter on Hattigaon only. So 7th of September 2026.
May I please, the lordship? My lord, your lordship may remember yesterday I moved an bail application where the issue was money dispute, my lord, bill dispute. It is in respect of the same FIR, my lord. There were three accused, my lord. The FIR is at page 16, my lord. Yesterday I moved the bail application in respect of the accused number 3, my lord.
Yes, I remember the
Same, my-
case also.
Yes, my lord, accused
Okay.
number 1 and
So you, yesterday it was for
accused number 3.
Aftaruddin.
Yes, my lord.
Aftaruddin.
Yes, my lord.
And today is for
1 and 2, my lord.
Fariduddin and Hifzur,
Yes, my lord.
who
And-
had said Farid had actually taken money.
Yes.
Hifzur and Aftar said that if he does not pay back, Abi will pay it back.
Yes, my
Right?
lord. No,
Okay. Huh?
I-
Accused number 2 and 3 will
Not
pay the money
two
to.
and three, all of them took the money. Because actually, my lord, accused number 1, 2, 3, all are there doing nursery business. So that informal invested money over there, my lord.
Okay. Heard Mr. D.P.
And
Bora
only
learned.
difference is that accused number 3, yesterday it was anticipated bail, today they have been arrested, my lord.
Today they are arrested.
No, no,
Oh, acha, acha.
today petition, they have been arrested on 8/8/2026. my lord.
Okay. Heard Mr. D.P. Bora, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. By this application, the petitioners have prayed for bail in connection with Lonka PS case number 132 of 2026, registered under section 318, subsection 4, 316, subsection 2, as well as 1661, subsection 2 of BNS 2023. The FIR in connection with which the petitioners were arrested was lodged on 19/6/2026 by the informant stating inter alia that he is the proprietor of Sakib Telecom Computer and that the petitioners, along with another, are involved in business of nursery. Full stop. He also stated that that he and the accused persons, including the petitioners, were known to each other and that the informant had given a total amount of rupees. Total amount was how much?
My lord, he said it is
Yesterday, I think we came to know the total amount.
46 lakhs.
It's in-
46 lakhs, total amount of rupees 46 lakhs. Then, oh, it
And-
cannot be in total 46 lakhs,
46 lakhs.
46 lakhs,
Yes, madam.
46 lakhs to the accused persons to invest in the, no, to the accused person on different dates.
By bank transaction as well as.
Yes,
Yes.
by bank transaction as well as by cash. Full stop. It was also it was stated in the FIR that the petitioner number 1 and accused number 3, and petitioner number 1 along with another along with another entered into an agreement with the informant that the money will be returned to him, and if it is not returned by accused number 1, that is petitioner number 1, then petitioner number 2 and another will return the money to him. However, it was further stated that the petitioners along with another had given checks for repayment of the money to the informant, but the said checks were dishonored due to insufficiency of funds. As such, it was stated that the petitioners and another had cheated the informant. Full stop. Mr. D.P. Bora, learned counsel for the petitioner, submits that the instant case is in relation to a business transaction, and the same involves monetary issues between the informant and the accused persons. Full stop. He also submits that the contents of the FIR discloses a civil dispute. Full stop. However, Mr. B. Sharma, learned APP for the state, submits that the ingredients of cheating are writ large, WRIT, writ large in the FIR, and that no bail be granted to the petitioners. Upon consideration of the submissions made by the learned counsels, and more so in view of the fact that the contents of the FIR reveals a civil dispute between the parties, this court deems it fit to enlarge the petitioners on bail on furnishing of a bail bond of rupees 20,000 each, with 1 local surety each of the like amount to the satisfaction of
CJM Hujai, my lord.
CJM Hojai under the following conditions. They will appear before the no charge sheet.
No, no, sir.
They will appear before the investigating officer as and when called for. They will not influence the witnesses. They will not, and so and so. Okay. They will not leave the place of residence without the permission of the CJM
Hujai.
Hojai. The petition is disposed of.
Big name.
Was it 46 lakhs and 14,000?
46 lakhs and 14,000. Huh?
Very please, your lordship. This is a peculiar case, lordship.
Wait, what is this peculiarity
Report
here?
was called for, Lordship, whether any case has been registered against him.
Wait, I'll just see the last order. WT message from OC has been submitted that no criminal case has been registered.
Yes.
Yes.
However, the learned counsel has produced a copy of the notice issued to the directing him to appear, wherein the case has been mentioned as Fakiragram.
Pakistan PS.
Fakirganj PS DBB is what?
I don't know, my lord. I never heard.
Call for comprehensive report from the investigating officer. It is made clear that till there is no coercive action, it would also be open to the petitioner to appear before the investigating officer.
After this
Well-
protection also, my lord, the police officer threatening the petitioner.
Already there is an order for no coercive.
Yes, even then.
Acha, this is a comprehensive report.
Not a comprehensive report, Lordship, but that report discloses, Lordship, that no case is registered against him.
So my lord, kindly.
But one,
Acha, let me read whatever instruction he has placed with.
Okay.
Refer to a kind AB so and so. Regarding production of the case diary and verification as to whether any criminal case has been registered against Fulchan Ali. You are Fulchan Ali? Fulchan Ali. So and so, so and so. In this connection, I have consulted the available records of Fakirganj PS. Acha, there is a complaint against you. There is a complaint against you at the Fakirganj police station, and that was registered as DBB CR 59. Okay. And White Fakirganj PS Saha number so and so, an inquiry was directed to be conducted.
No,
And
accordingly,
in pursuance to that, somebody has gone to your place, and where they did not find you. You were absconding. You were not there.
accordingly, the petitioner appeared before the police station.
In pursuant to the notice.
Yeah, I noticed.
Then?
And also in pursuance with the last order.
Then what happened? He had said about his the same thing. Same thing was there on the last occasion also, Mr. B. Sharma.
Yeah.
This is that same instruction, 11.8. This 11.8 was before the last order. 14.8,
This
a
was-
comprehensive report was called for. That report is not there. You get a report.
Lots,
Same instruction was there on the last occasion too.
lots.
Same ins-
I will get the report then.
You get the report.
Lots.
And what were you saying that you appeared before the police and then what
Already
happened?
appeared. Already appeared as per the last order. As per the last order, last line, it would also be open to the petitioner to appear before the investigating officer in pursuant to the notice received by him.
So he appeared
He appeared.
and he gave his story. Part of his story, what? His statement and all were recorded or what?
I don't know.
You
what
don't know.
statement they or not.
This is the notice. Send, but okay, you get the proper report. Till then,
My lord, protection should be continued.
this will continue. Okay, heard Mr.
ATM. Hussain.
ATM Hussain, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By the last order dated 14/8/2026, this court had called for a comprehensive report from the investigating officer to the effect that although the petitioner was called by the police officer by giving a notice under section 35(3) of the BNSS, but it has been stated by the officer in charge of Fakirganj police station through the last instruction that no case has been registered against him at the said police station. Full stop. However, it is also stated by the officer in charge of the said police station that a complaint was received at the police station and an inquiry has been conducted with regard to the same. Full stop. However, when the matter is called up today, the comprehensive report that was called for from the investigating officer was not placed by the learned APP. As such, it is directed that on the next date, the learned APP should place a comprehensive report from the investigating officer. Full stop. It was also ordered by the last order that no coercive action should be taken against the petitioner. The same be continued till the next returnable date. Place this matter on
9th.
9th of September.
Obliged.
Oh, yeah. Whatever. I'll come back in 2 minutes time.
Lots.
Acha. What is that? 20? 9 is long after, right?
So only notice will go, Lord. At this stage, will only notice.
Acha,
Because
just in
passing
20.
on affair, matter has been compromised. with the
Okay,
party.
29 to just.
Only notice will go.
Okay. What is petition? By this petition, what have you challenged?
Passing of the affair, as the matter has been settled between the parties, it's a private dispute.
Okay.
Matter has been settled between the parties, and already a bail has been granted in these criminal cases.
and ultimately matter has been compromised and settled. We have filed a lordship the annex agreement for settlement.
Acha, acha.
So at
You
this
are
stage-
otherwise, it's a joint petition or what?
No
no.
joint petition,
Acha,
only piece of settlement, only notice will be issued.
okay.
We'll take justice.
Acha, Amit Kumar Rai and Kanchan Kumari.
Kanchan Kumar is the wife, Amit Kumar is the employee of the informant.
Acha, so the settlement is on between 1, 2 and respond number 2. Okay. Heard Mr. S.K. Goswami, learned counsel for the petitioner, assisted by Mr. R. Sharma, learned counsel for the petitioner, and Mr. B. Sharma is there, B. Sharma, learned APP for the state, for respondent number 1. By this application, the petitioner has, by this application, filed under section 528 of the BNSS 2023, the petitioners have challenged, the petitioners have prayed for quashing of the FIR dated 1/6/2026, being Dispur PS case number 345 of 2026, registered under section 316 subsection 2, 318 subsection 4, 336 subsection 3, as well as 61 subsection 2 of BNS 2023. The learned counsel for the petitioner submits that the only ground taken for quashing of the FIR is that a settlement has been reached between the petitioners and respondent number 2. Since the offense involves a civil dispute, issue notice the petitioners to take steps for service of notice upon respondent number 2
By Dusty Lot.
by dusty criminal, not
Raise that as well as Dusty, raise that as well.
by speed post with AD or by usual process, full stop. The petitioners are also allowed to take steps by way of dusty mode for the ends of justice. No, dusty mode for quick service of notice. Mr. B. Sharma appears for respondent number 1, and as such, no formal notice is required for required to be served upon him. List this matter after 2 weeks or date. List this matter on 16th of September 2026. Yes, maybe.
Your Lordship, this is a 482 pre-arrest bail application, Your Lordship. This honorable court, based on the same FIR,
305, 318, 318, 316 or what? Cheating? No.
Theft, Your Lordship.
Theft. Okay.
This honorable court at page number 22 was pleased to grant anticipatory bail to the other accused, Your Lordship.
Acha.
The
This
only-
is in respect of Naimul and Mozammil.
Naimul
Where is
and
the
Muzammil.
FIR?
Page number 22. Is
20
the order.
No, where is the FIR?
FIR is page number 12.
Page number?
12.
Entire consignment loaded in our vehicle. So how come you're in the picture?
My name has been taken during statement, Your Lordship, at page number 16.
Page number 16.
Page number 16.
4 persons were named as accused persons here. You are not amongst them.
Your Lordship, I was not among the arrested person. My name was taken from the arrested person.
This is AB, right?
AB, Your Lordship.
Okay, where are the materials against you? Who had said?
Your Lordship, page number 16, grounds of arrest, point number 1.
As per information of secret source, I along with so-and-so apprehend 4 person Munna Hussain Iftikhar so-and-so. And they have admitted that 7 other persons, Jitul, Moinul and so-and-so, have stolen. So you are amongst those. You are Jitul and?
I'm Naimul and Muzammil.
On Naimul and Mujammil.
And Mujammil, I'm not,
Naimul is there, Mujammil is not there.
Your Lordship, I'm a co-villager and police is searching for me, Your Lordship.
Acha. So where is the order you said?
Page number 23.
Okay, Likha. Heard Mr.
A.N. Iqbal.
A.N. Iqbal, Learned Counsel for the petitioners, and Mr. B. Sharma, Learned APP for the state. By this application filed under section 482, Nikki?
Wait.
Yeah. For 482 of BNSS 2023, the petitioners, namely Naimul Ali, Naimul Ali and Mozammil Haq, Mozamil, not double M, huh? Mozamil Haq, alias Mozamil Hawk, okay, same. Oh, Z dot had J, huh? Mozamil Haq have prayed for pre-arrest bail in connection with Azara PS case number 93 of 2026, registered under section 305B, 305C, 318, subsection 4, 316, subsection 2, as well as 3, subsection 5 of BNS 2023. The FIR in connection with which the petitioners apprehend arrest was lodged on 12/7/2026, wherein it was stated that a vehicle which was loaded with engine oil, grease, mobile, etc., from Castrol India Limited was flying from Azara to Dimapur, and that the said vehicle was driven by one Montu Kolita. Was stopped, no, was not, remained stalled at various locations on its way, which was seen through the GPS tracking system that was installed in the vehicle. Full stop. It was also stated that attempts were made to contact the driver, but his phone was found switched off, and that the said vehicle was diverted towards another place, and the articles from the said vehicle were stolen. Full stop. The police on investigation had arrested 4 accused persons, and it is the case of the petitioners that during the interrogation of the said accused persons, the accused persons had taken the name of one of the petitioner, namely Naimul Ali. Full stop. It is also the case of the petitioners. No, full stop. The Learned Counsel for the petitioner submits that with regard to the other petitioner, that is petitioner number 2 is concerned, the police is searching the said petitioner and had reached his home. And as such, he apprehends arrest in connection with the said offense. Full stop. However, he submits that the petitioners are no way involved with the offense at hand. Mr. B. Sharma, Learned APP for the state, submits that the petitioner number 1 was named by the other arrested accused person, and the name of the petitioner number 2 figured during investigation, and the police and the police, but during investigation, full stop. On consideration of the submissions made by the learned counsels, more so in view of the fact that the only material against petitioner number 1 is the statement of the co-accused, and there being no materials against petitioner number 2, as the same has not been stated anywhere in the forwarding report. No, not forwarding. Anywhere by the investigating officer. This court deems it fit to enlarge the petitioners on pre-arrest bail on furnishing of a bail bond of rupees 20,000 each, with one local surety each to the satisfaction of the arresting authority under the following conditions. Will appear before the investigating officer within a period of 10 days, will not influence the witnesses, will not hamper with the evidence, will not leave the his residence without the permission of the arresting authority. Petition is disposed
CD
of.
is already called for, Lordship, on 14/9/26.
Uh-huh.
CD has already been called for in respect of another co-accused at page 26. Page 25 is the order.
Acha,
In
this is in
respect
respect of Sakil Mustaq.
Yes, and CD has been called. He was granted interim. So, Lordship, let
Acha.
it be on interim, Lordship.
Sakil,
Yes.
he was also named by the co-accused.
Yes, probably. I'm not sure.
No,
Lordship.
not named before. Your Lordship. At page
No,
number 16.
Sakil name is not there.
it don't-
He is not even in the accused. It's okay. Sakil has different facts.
Lordship. So his facts are even more lighter than him, Lordship. And his
Co-accused statement.
yes, but his
And
CD has been called-
other to one, no one had stated about the other one,
No.
petitioner number 2. It will be considered independent. Yes. Petition is disposed of.
Obliged.
Nine, yes.
May I please, Your Lordship? Lordship, allegation is 87 BNS, alia 366.
Uh-huh. 87 is what?
87 is 366 alia IPC, Lordship.
Oh, kidnapping of.
Kidnapping.
Acha.
Sir, Lordship, kindly come to page 12 FIR, Lordship. Page 12, Lordship.
Yes,
Page 12, Lordship.
I'll see it.
Yes.
Accused is Ramjoddin. Same person.
Ramjamuddin, Lordship.
Ramjamuddin.
Yes.
Daughter is recovered.
Yes, the daughter is recovered, Lordship. I have annexed the order of the CGM, Lordship, page number 19, Lordship. Page number 19. 20 and 21 is the operative part, Lordship.
When was she recovered?
No, 29/7, Lordship. FIR lodge is 25.
Acha,
Lordship.
29/7 is the order.
Order dated and FIR is lodged in 25, Lordship. And she recovered on 28, Lordship, and 29, Lordship, taken before the judicial magistrate first class, Lordship. And her statement recorded, and Lordship, kindly come to page 21, Lordship. Page 21, Lordship, as the victim is major, she is at liberty to go to her place of choice upon executing a bond of ₹500 with an undertaking that she will appear.
No, she is okay. She is major.
Yeah,
But then the fact remains he had
There-
kidnapped.
there is a Lordship, there both the petition, informant daughter and the petitioner, Lordship, they are living neighbor village, Lordship. And they are in love relation since last 5 years, Lordship. But which the informant did not agree, Lordship. They want to marry with each other, Lordship.
But that fact has not come.
The 183 statement has to be perused by a lawyer.
183. Let the case diary come. Because it is like kidnapping a young girl of 19 years.
Protection may be given, Lordship. But age of the petitioner is 23 years, Lordship. I annexed his Aadhaar card and voter ID. Kindly come page 10, Lordship. Page 10, Lordship. Date of birth, Lordship, 19/12/2003, Lordship.
He is the accused petitioner here.
Lordship, 23 years, Lordship, and the girl is 19 years, Lordship. They were in love relation since they are living.
Okay, in interim, but let the case diary come and 183.
Yes.
Heard Mr. N.H. Loskar, Learned Counsel for the petitioner, and Mr. B. Sharma, Learned APP for the state. By this application, the petitioner has sought for pre-arrest bail in connection with Kaline PS case number 81 of 2026, registered under section 87 of BNS 2023. The FIR, in connection with which the petitioner is apprehending arrest, was lodged on 25/7/2026 by the father of the victim, stating inter alia that while his daughter was coming back from the house of his brother, the petitioner, along with others, had kidnapped his daughter by taking her in a vehicle which is without any registration, without any registered number plate. Full stop. The learned counsel for the petitioner submits that the victim was recovered and her statement, the victim was recovered and her statement was recorded on 28/7,
29/7, 2000.
on 29/7/2026. He also submits that the petitioner and the victim girl was having a relationship and that the victim had voluntarily went with the petitioner out of the scene. On the facts and circumstances of the case, this court deems it fit to enlarge the petitioner interim pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority. Under the following conditions, he will appear before the arresting authority within 7 days. Influence, temper, call for the case diary. List this matter on
11th, 11th.
11th of September.
Lordship, let it be on 14th, Lordship, because
14th of
7
September.
days.
Lordship, senior is engaged in another courtroom. Lordship, may kindly take the matter after some time.
Okay, after some time.
May I please, Your Lordship? Criminal revision petition against the order dated Lordship 6/6/2026 passed by the Lana GMFC.
Please, what?
Jimma. Number of cattle on Jimma Lordship. I think the petitioner is the authorized person who has the cattle trading license Lordship.
15 number of cattle.
Cattle Lordship.
Where is the FIR?
Charge sheet submitted, Lordship.
Okay.
In the
Page 25 Lordship. In charge sheet.
Let's see whether any cruelty. Page 25.
Page 25 Lordship. In FIR as well as sources, petition name is not in the neither in the FIR nor in the sources.
It's okay. He is the owner.
Yes, it is the owner. I'll see page 25 is the FIR. And he is the registered cattle certificate holder. Not present petitioner, he is authorized person. I have annexed the.
One second, let me finish reading.
Close.
So otherwise, there is cruelty. The veterinary doctor has also stated, and there were 15 cattle which were loaded on one vehicle. At best, 6 cattle can be.
No, Lordship. As per, I have annexed the cattle was transported in a livestock vehicle. That is page 59. Can you see?
What vehicle? That's a different vehicle.
Plus, the livestock vehicle.
Livestock vehicle.
Page
But doesn't matter. Under the Assam Cruelty to Animals Act, any vehicle, there cannot be more than 6 animals.
That is examined by the veterinary doctor. There is a
Veterinary doctor said that they are not fit to travel anymore and they were not well. They were.
no. Can you see the page 59 is the certificate issued by the veterinary doctor. And during the transport of the cattle, veterinary doctor also issues certificate. Fitness certificate, transit certificate also issuable.
This was FIR was in which date? 15th of May.
15th of May.
May 26.
Lordship.
And this is report dated 25.
This is regarding the vehicle. The vehicle is the livestock vehicle. That vehicle carrying a 15 number of cattle. There is space Lordship mentioned is the up to 15 livestock vehicle number of cattle 15 Lordship. And there is a coding and there is a FD facility in the vehicle Lordship.
Certified that Mr. Nasiruddin, son of, what is the petitioner's name here?
Here is the petitioner name is the Hema Padma Lordship. Here is the vehicle owner. The certificate issued in regarding the vehicle.
Acha, you want your vehicle, not the cows.
No, I want a cow Lordship. I am submitting that the vehicle which is mentioned in this page 59, the cattle was transported carrying the cattle.
You are not the owner of the truck or
No.
whatever this
No.
vehicle is.
I am carrying the cattle in this truck Lordship.
Okay, then,
Lordship, kindly see the SOP, Lordship. This is the
what is there to show that you are the owners of those cattle?
Lordship.
You
Here is the-
purchased it?
The 15 number, total 16 number of cattle was purchased by the present petitioner before, Lordship. Was out of 15 number, 9 number of cattle from one Sahabuddin, Lordship, to and 7 number of cattle from on Lordship on Khalilur Rahman.
Okay.
Thereafter, the said Sahabuddin and Khalilur Rahman sell the said 15 number total 16 number of cattle to the present petitioner. Thereafter, the present petitioner carrying the said vehicle, during the carrying the cattle, Lordship, the doctor as well, doctor issued, veterinary doctor also issues a veterinary certificate. Issue certificate.
Page
and the-
59.
Lordship,
No, page 59 is the vehicle.
Yes, I'll see the page, yeah, fitness certificate, Lordship. That is page-
59 I've seen. This is in respect of the
Sorry,
vehicle.
sorry, page 51, Lordship.
51.
Page 52, Lordship.
52.
52 is a certificate of fitness to travel cattle. During the cattle was transferred, and kindly next page, this is the list, Lordship. Page 55, Lordship, fitness. This is a tag number, Lordship.
But this is the consignor is Sahabuddin,
Because
the owner of the vehicle.
no, he is the seller.
Hmm.
Because when the cattle was sold, the consignor has to issue a certificate regarding that the cattle is a fit condition to travel.
Hmm.
According to the issue certificate in favor of Sahabuddin. Finally, this case is 55, Lordship. This is a total number of cattle, Lordship. There is a tag number also mentioned, Lordship.
15 numbers.
Lordship, for 15, because the vehicle capacity is 15 number. Therefore, the present petitioner.
This was by the veterinary officer
Veterinary officer.
saying what? Fit to be traveled.
Yes, Lordship, this is a fitness certificate, health certificate. And thereafter, the transit certificate also issued. That
In my opinion, animal described above is normal health and free from any disease. And no, where is the stipulation that it is fit to travel? Health certificate, okay. They have said that these are.
this is the page 52, Lordship. This certificate should be compliant signed by the veterinary officer. Date and time of examination, the 13/5/2000 examined, Lordship.
To be transported from Doboka to Silchar.
Lordship.
And on the transit, it was seized.
Yes, Lordship. Thereafter, the transit certificate also issue, page 57, Lordship. And as per SOP, Lordship.
Show me those cash memos where you have purchased.
Lordship. That is page from page 31, Lordship.
What is your name?
That is-
Hemapadma? Hemapadma? Where is your name? Hemapadma?
That,
That is the.
for that clarification, Lordship will find it at page 64. The clarification.
No,
what
I
Lordship
have
said.
submitted, Lordship. Kindly see page 48, Lordship.
48.
Lordship.
You said 31, now 48.
31, Lordship. The seller purchased the from cattle market. Thereafter, that seller sell the said cattle to Hemapadma.
Now,
He
where
the
is
final
that?
purchaser, he is the partner. Hemapadma is the final purchaser.
Where is that?
The page 48, Lordship. As the seller, Lordship, Sahabuddin, Lordship.
Sahabuddin purchased from?
Sahabuddin purchased from cattle, Lordship, Doboka cattle market. from
Doboka
Nepal purchase.
Municipal Board. What?
Lordship.
Arifuddin.
Arifuddin and
Name
some
of the
other
seller. Identifier name. Name of purchase. Sahabuddin. Sahabuddin purchased those cattle from someone else and then they sell it to?
the
Hemaprabha.
present petitioner.
How many cattle here?
Here is the table, there is a table, Lordship, total 9 number of 9 piece cattle.
Where is that?
Page 48.
48.
Next, Lordship, page 50, Lordship. Here is the Khalilur Rahman seller is the buyer is a Hemapadma Gam, Lordship. Here is the total number of the 7 number of cattle. There is
No, where did you get those number of cattle? 7 or whatever you said?
There is a table, Lordship. Below,
Where is the table?
below, Lordship. Page 50.
Animal details.
Lordship.
There are only 5 of them.
No, Lordship. There is
7 pieces.
7 pieces.
Number of animals, 9
Page
pieces.
48, 9 pieces.
9 and 7 are 16. So what happened to one cattle?
one cattle because there is a capacity of 15 number of cattle to travel, transport the cattle. Therefore, he transport the.
Where is the rejection order by the trial court?
Page 63. There is a page 63. Lordship.
It starts from 62, relevant
No,
portion.
relevant portion from page 63, the second paragraph, Lordship.
Hmm. Original ownership cannot be ascertained, it is
Yes,
said, right?
Because there is a format in the Assam Cattle Prohibition Rule. As per format, the present petitioner purchase and sell. There is a format. Lordship. The page 48 and page 50. Lordship.
Okay, heard, Mr.
Some Lordship.
Islam, learned counsel for the petitioner, and Mr. S. And Mr. B. Sharma, learned APP for the state. A report came from the police.
Big Board came, Lordship, there is a charge sheet submitted to report, there is a report that the charge sheet. I have.
Charge sheet is submitted
charge
during
sheet,
industry,
30
nobody appeared.
30
Nobody appeared before the IO to claim
I have
ownership, but
prepared,
then.
Lordship.
Ah.
The conduct of the IO is not good, Lordship.
On
I
the
have
other hand, on the
complained before the SP, Lordship. Okay, that is page 63, like, 60, that, kindly see.
Okay, heard Mr. What did you say? B. Islam, learned
Islam.
counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has challenged the order dated 6/6/2026, passed by the 6/6/20, passed by the learned Judicial Magistrate First Class Kachar Silchar, by which the petition filed by the petitioner seeking custody of 15 numbers of cattle was rejected. Full stop. It is the case of the petitioner that after obtaining the certificate from the veterinary doctor with regard to the fitness of the said cows and their ability to be taken from one place to the other, the petitioner, after purchasing the said cattle from one Sarafuddin or what? Sahabuddin had transported the cattle from
Lordship, Doboka to Lordship, Silchar.
from Doboka to Silchar. Full stop. However, it is submitted by the learned counsel for the petitioner that on 15th of May 2026, the police, on receipt of the information that cows were transported by one vehicle coming from the Haflong side, a Naka checking was conducted and the vehicle was directed and the vehicle was intercepted. And when the driver was asked about the documents with regard to the transportation of the cattle, the driver could not produce any documents and the cattle were seized. Seized on which date? 15/5, right?
Lordship, on
On-
45.
Seized on 14/5/2026. 14/5/2026.
28.
Full stop. It was also stated in the FIR that on the next day, that is on 15/5/2026, the veterinary doctor examined the cattle and was found that the cattle were not fit to be taken to any other place. And as such, the cattle were handed over to Silchar Gaushala Trust. Full stop. The learned counsel for the petitioner submits that the said cattle were purchased from one Sahabuddin, who in fact purchased those cattle from Hojai, from Doboka market, right?
Sahabuddin as well Khalilur Rahman, both 2%, from 2%.
Oh, what?
One for 9 number of cattle from the Sahabuddin and 7 number of Khalilur Rahman.
Acha, no, the Learned Counsel for the petitioner submits that the cattle were bought by the petitioners from 2 number of sellers. That is one, namely, that is namely Sahabuddin, and the other one is
Khalilur Rahman.
and Khalilur Rahman, who had purchased those cattle from the Doboka market from one
There is demand
Maqbul Ahmed as well as from different sellers.
different sellers.
From different sellers, will you, huh? Doboka market from different sellers. The receipt of purchase, yes, on payment of consideration by the petitioner. No, it was purchased by the petitioner, huh? On payment, on payment of consideration from so and so, who had purchased from various sellers. The receipt to that effect has been annexed in the instant petition. The Learned Counsel has also submitted that before the cattle were loaded and were transported, the certificate from the veterinary doctor was obtained, both in respect of fitness of the cattle as well as the fitness of the cattle to travel. No, fitness of the cattle for transporting to other places. Full stop. The Learned Counsel has also placed the impugn order dated 6/6/2026, wherein it was stated that the ownership of the cattle was not established, and as such, the Jimma was not given. However, he submits that the petitioner was the owner of the said cattle, as could be seen from the documents that he has annexed. Full stop. Mr. B. Sharma, learned APP for the state, however, submits that it is in the instruction of the investigating officer that the owner of the said cattle had not appeared before them, and as such, Jimma could not be granted. He submits that charge sheet has been submitted in the instant case, and the case is fixed for trial. On consideration of the submissions made by the Learned Counsels, more so, this court finds as follows. It is a settled position of law that any articles seized in connection with any criminal case should be given in custody to the owner or from the person or to the person from whom it is seized as soon as possible by the magistrate. The same has been held by the Supreme Court in Ambalal Desai. What is that? Sundarbhai Ambalal Desai versus State of Haryana. State of Haryana reported in 2012. Reported in, I'll give you the decision. So and so. Full stop. In the instant case, it is seen that the petitioner has bought the cattle from 2 sellers, namely Sahabuddin, and the other one is what?
Khalilur Rahman.
Khalilur Rahman, as could be seen from the receipts annexed with the said petition. And the same were transported by loading them in a vehicle, which was a
Livestock vehicle.
Huh?
Livestock vehicle.
which was a livestock vehicle. And that too, after getting a certificate from the veterinary doctor. Full stop. It is also noticed that in fact, 16 numbers of cattle were bought by the petitioner, but since only 16 number of cattle, 16 number of cattle were bought, but since only 15 number of cattle can be loaded in the said vehicle, the same were transported after following the due procedures of law. In view of the same, as such, this court directs the investigating officer or what? The court Who will give the custody now?
Investigation officer.
Huh?
Investigation or
Investigating officer, only investigating officer should give in custody the said number of cattles, that is 56 number of cattles.
no,
15 number of cattles to the petitioner after following due process of law. That is, after taking photographs, comma, guarantee of a reasonable amount, comma,
lordship,
a bond,
bond lordship. Bond.
guarantee na lage, a bond along with the undertaking that the petitioner would produce the cattles during the trial whenever it is required, as well as other procedures of law. The process of law without any delay. Petition is disposed of. Mr. Kamar, you are waiting for which matter? Next matter? Acha, okay, fine. Acha, you can take your book, Mr. Islam.
He's so excited, my lord, I forgot everything. my lord.
Yes. Mhm. Yes.
Please, my lord. Lord, I am appearing on behalf of the
Commercial.
petitioner.
Oh, you're for respondent?
Yes, ma'am.
Please, my lord.
Yes.
Lords, these are two revision petitions. Item number 12 is two revision petitions filed by the
12 and what?
accused.
12 and 13?
Yes, ma'am.
12 and 13, my lords.
Arising out of the same case, but in different connotation. ma'am.
Acha.
This
Please,
one
ma'am.
is regarding rejection of the order dated 2/3/26 for non-supply and calling of the coroner's report from
Inquest
Singapore.
report and other documents prepared by
Coroner's
Singapore.
report
Yes.
regarding arms.
Yes, ma'am. No, not arms, my lord, coroner's report.
My lords,
regarding
Oh,
since
that's
the
dead body.
incident,
Dead body.
Dead
No.
bodies.
Lords, my lords, the
We call it
if I may,
autopsy and
Uh-uh.
inquest, my lord. They call it as coroner's.
Coroner's report. Today it has come up for the first time.
Yes, my lord.
Yes, ma'am.
Delay.
And you are appearing for a special CID,
Ma'am,
PP,
special
for
PP.
a CID?
Yes, ma'am.
Oh.
In fact, for the state of Assam. my lord.
Hmm. 1 second, I'll just go through the.
Please,
ma'am.
please, ma'am.
But he has annexes synopsis that will speak.
2/3/2026.
Yes, ma'am.
So where is that order? 2/3/2026? Yes, Mr. Counsel?
Ma'am,
Page
Please,
number?
ma'am. Let's at page number
55 NHR 1.
annexure 125. Let's the relevant para is para 30 because the order speaks of other applications also.
What is the relevant part?
Let's para 30 of the impugned order is at page 39.
Paragraph 30.
Page
Yes.
39 minutes.
Okay. The case is also fixed for order on petition.
Yes, ma'am.
The two orders were passed simultaneously. ma'am.
Acha. Oh, this is in respect of Jubinder.
Yes, ma'am.
Yes, ma'am.
Okay. I have seen the, I was not aware of the petitioner's name.
Yes, ma'am.
So according to you, all were given
Yes.
and relay has been furnished to the accused. It is submitted that postmortem examination report, toxicology report, final medical report, cause of death, so and so has been furnished to the accused. Submitted to foreign nationals cannot fail to give statements under human.
While interpreting section 209 of the BNS.
Huh. It is submitted that investigation done by have done for their own investigative purpose. Used under the Indian criminal. It is very okay, yes. So it was rejected. But there were so many documents were sought for, right?
Please,
Not
my
only
lords, yes.
coroner's report.
Not only inquest report also, coroner's report also, and medical examiner report also, death investigation findings. Because all these documents are so relevant because the Singapore authorities have said in their findings that there was no foul play and the incident happened in Singapore. Milods, these are very important for the trial to be adjudicated in a fair manner. Milord, the learned ASJ has rejected my application on the ground. Milord, at para 35, the last line, they have mentioned that the uh, findings of Singapore authority has no bearing on the case. Milord, it is not a civil dispute where the bearing has to be decided. They can be relied upon by the accused to establish his
But
reasonable
then what
doubt
I
of
can
guilt.
find out from the order is that most of the documents were given to the accused
Milords,
persons.
all these documents which I have mentioned in the
legally
application.
entitled
Which
documents.
they are legally entitled, those were given to him.
Milords, I am saying those documents which I have completely mentioned in the application have not been provided. Those have been prepared by the Singapore authorities.
So
Milords,
the
as
inquest
per
report.
the inquest
One is the
report,
inquest report,
the
death
coroner's
investigation
report.
findings, medical
Yes, Milords.
examiner,
Yes, Milords.
medical examiner.
Report,
In fact,
medical
those
examiner
Indian,
report.
in fact, those Indians, what NRIs had come here and had given their evidence.
Yes, ma'am.
Please,
Statements,
Milords.
my lord.
Statements, Milords.
It's yet to be converted into evidence, my lord.
Mhm.
Their
The
statements
evidence is yet to be
under
recorded.
161 and 164.
And they had come to our
Yes,
country.
yes, state and.
So what medical examiner you want? The
Milords,
person who had
there
done the
was a
postmortem.
Milords, there was a medical, yes, Milord, kind of a postmortem. There was a medical examination done by the Singapore authorities, and a report was prepared stating that what were the circumstances leading to the death of the victim, and that is a report which is very important. That because that is the first authority to examine the case. Another, Milords, this death investigation findings concludes that what were the reasons and circumstances leading to the death.
To section
209.
and 209.
Please.
8 and 9, my lord. Offense committed outside India and receipt of evidence relating to offense committed outside India.
So 209.
Earlier 188, my lord.
Acha.
Now 208 is the relevant
208.
and 209.
When an offense is committed outside India by a citizen of India, whether on high seas or elsewhere, by a person not being citizen, he may be dealt with in respect of such offense as if it had been committed at any place within India, at which he may be found.
So as your lordship knows, my lord, under 177 CRPC earlier, that I'm well versed, that's why I'm saying, my lord, I looked into 177 equivalent to Sidon. So it says that ordinary a criminal trial will take place where the occurrence has happened. So here, this is an exception to the rule.
177. Committed any place in India which may be found and where the offence is registered in India. Provided that no such offence shall be. So sanction of central government is also required.
Yeah, all obtained.
Okay, it's obtained. So 209, when any offence alleged to have been committed in a territory outside India is being inquired into or tried under the provisions of 208, the central government may, if things fit, direct that copies of depositions made or exhibits produced, either in physical form or in electronic form, before a judicial officer, this judicial officer of the other country,
Yes, ma'am.
before a judicial officer in or for that territory, or before a diplomatic or consular representative of India in or for that territory shall be received as evidence by the court holding such inquiry or trial in any case in which such court might issue a commission for taking evidence as to the matters in which depositions or exhibits relate. So it is for the central government to direct that copies should be given.
If I may submit.
Huh?
Not the court, ma'am.
Not the court.
Because the court is relying on those two earlier 207 copy,
Mm.
my lord. We give it to them.
Mm.
And we are entitled under the law, the MLT, my lord, mutual legal treaty, my lord. So accordingly, all copies has been supplied. If they want, they should move the central government.
Yes, that is what it is not for
Milords,
the
if
court
I
to
may
direct.
submit, Milords, the
Because the court
reliance on
doesn't have
section
it, my lord.
209
We
is
don't have any
misplaced.
jurisdiction.
Yes, absolutely.
It is for the
Milords,
central government. You can make an application to the central government.
Milords, if I may just submit, Milords, in criminal jurisprudence, the power of there is no right of an accused to place documents on record. It is only the investigating agency which will collect all the documents and place before the court, and the trial will be conducted till his statement is recorded in
Why? The
313.
accused cannot place documents in court.
No,
They
Milords.
can by way of
No,
defense
Milords.
evidence.
Because there is a Supreme Court
cannot.
judgment that accused does not have a right to
When they
place
were
documents.
examined as defense witness, they can always place.
Exactly. After 313. After
After
recording
313.
of 313, it can be done. Milords, before that, the only thing which the accused can do is request the investigating agency to place on record the documents, or to request the court to direct the investigating agency to further investigate and place those documents which have been specifically pointed out by the accused.
No, further investigation will be allowed till the trial starts. After
Milords,
the trial starts, no question of any further investigation.
Milords, my question is very simple. If I am not allowed to place on record some documents, which might be in my favor, the prosecution evidence runs. Without placing those documents, how can it be a fair trial? And this is not some document which I have placed, which I have found out. These are those documents which have been procured by a proper investigating agency of a country where actually the offense was committed. Milords, even prima facie, it can be looked into what is the relevance of these documents.
But these are not required to be gone into. Now, answer me on one question. Whether
Please,
court has the power to call for those documents, it is for the central government.
Milords,
You
the
make an
investigating
application.
agency has the power to get those documents. When the investigating agency has the power to place other documents without seeking without asking me to go to the central government.
Agency also does not have the power. It is for the central government.
Milords, it's not about it's the additional power with the central government, and there is no bar on the investigating agency to place those documents on record. Even if this provision, Milords, if I may just take 5 minutes, this provision just empowers the central government additionally, that
What
if
additionally?
if
That is the
Milords,
only power.
Milords,
Central
it is,
government may.
but
if
it does
thinks
not
fit.
bar the investigating agency. It says that if the investigating agency has missed it, then the central government has the power to do so.
Where is that?
It is
that investigating agency have missed it?
Milords, there is no bar. Where is the bar for the investigating agency to put place on record?
Where is the enabling power? Forget about bar.
Milords, how come they then if that is the case, how come they can be selective of placing on record only those documents which favor the prosecution, and then they don't
Definitely,
say.
they will place those documents only. It is your responsibility to place documents in your favor.
Because,
After
but
313,
no, my
you
lords,
have
that is not the correct position. Investigating agency is not required to place on record only those documents which relates to the guilt of the accused. Investigating agency, though we have in the practice we have made so, but investigating agency, the role of the investigating agency to collect every document, whether it is in favor of the accused or against the accused. And this is the reason accused does not have a right to place the documents on record before 313. That is the reason. The investigating
see,
agency
there
has
is
to
an
be fair.
agreement between the countries. Right, there is an agreement between the Singapore.
And
This is
Milords,
mutual
how come
legal
that agreement is not referred when
assistance
they
treaty.
sought other documents, which I have not mentioned? There are some documents which they had filed. Accordingly, the prosecution had filed some documents prepared by Singapore authorities, but they had intentionally left some of the documents which are of very relevant,
No, that's
of relevance.
Coroner's
And
report came
then
when?
they do not rely upon the mutual treaties, and they do not rely upon the central government's power. They just file it.
But why can't you make an application before the central government to get those documents? You can always make that application.
As that is the
Because
mandate under 209.
209. You make an application.
Because we
Under
can
the
make an
treaty. Under the treaty, they will make a request and then they will get it. But where is the court's power?
because
You
the
make
court's
an
power.
application,
Because
I'll
I
give
will
you
make
that
an
liberty, then get those documents.
Please, Mil.
During cross-examination also they can put, I think.
Absolutely.
No, Milord, we cannot, the accused cannot put the documents which have not been placed on record by the prosecution. Those documents which are not part of the charge sheet cannot be relied upon by the accused unless there is after 313, and in defense evidence, I can only place them on record.
That is a
That
you
is the
place it
position.
during your defense evidence, or even during cross-examination they cannot put. They can put it.
They can put. Asking question
Milord,
is no
When you
as per
cross-examine the witnesses, then also you can put. It will be exhibited by the court.
Milord, Milord, I will move an appropriate application to the central
Then
government.
you come. Okay. In that case, I'll dismiss this. Heard Mr.
Ankit Dhawan.
Ankit Dhawan, learned, your senior counsel?
No, Milord.
Acha, learned counsel appearing for the petitioner. And Mr. Jet Kamar, learned senior counsel. Huh?
Oh my God, assisted by.
Yes, learned senior counsel, assisted by Mr. Priya. P. Doctor, learned counsel appearing for the CID, learned special PP for the CID. By this application, filed under section 438/440 of the BNSS 2023, as well as under BNSS 2023, the petitioner has prayed for quashing of the order dated 2/3/2026, passed by the learned session judge Kamrup Metro, Gauhati, in sessions case number 256 of 2025.
But at that time it was session case. When now session case.
Sessions case 256 of 2025. The case of the petitioner is that some of the documents, the case of the petitioner is that the victim died in Singapore and the case was registered in the said country, and certain documents were also provided for, as was asked by the prosecution from the country of Singapore.
By the IO during investigation, madam.
Mhm.
Were collected by the IO
Were
during the investigation of the case.
Some of the documents were collected by the
As per
investigating
FFP.
officer during the investigation from the country of Singapore, and after following due process of law.
MLT, ma'am.
Yes, and by following the mutual legal assistance treaty that was entered into between our country and Singapore. Full stop. However, the petitioner submits that few documents to the effect inquest report, death investigation findings, medical examiner, comma, complete coroner's report, and other related materials prepared by Singapore police authorities were not furnished to the prosecution. Full stop. He as such submitted, the petitioner as such submitted an application before the, where is our application? Is it annexed?
Yes,
don't
ma'am.
think so, my lord. No,
Application before the Session Judge Kamrup M. Gauhati.
page 58.
58,
8.
my lords.
58.
58.
Yes.
8
For a direction against the prosecution.
But against this petition, we have filed our objection, which is at Annex of
Page
5, page
61.
61.
Acha, against this 58.
Yes.
Yes. Against the prosecution, direction against the prosecution to place on record the said documents as has been stated above. Full stop. The prosecution, in reply to the said application, in reply to the contents of the said application, had filed a written objection before the Honorable Session Judge Kamrup Metro. And the learned Session Judge, by order dated 2/3/2026, had dismissed the petition on the ground that the necessary documents on the ground that, as per the provision of Mutual Legal Assistance Treaty, the investigating agency visited Singapore and collected evidences, and the same are furnished to the accused person as relied on by the prosecution. It was also stated by the trial court that the Indian nationals who were present on the day of incident were summoned to Assam, India, and their statements were also recorded, and the same were furnished to the accused persons.
This other side is more important.
Hmm?
Other foreign countries' investigation is not to be imposed or trusted upon the local in view of section 208 and 91. That line, my lord.
It was also held that the investigation done by the foreign investigating agency in a foreign country, as per their own law, will have no bearing upon the Indian court in relation to the investigation done under the BNSS.
My submission is it cannot be trusted upon.
Cannot be, it almost amounts to
Bearing,
that.
he's challenging that word bearing.
Oh, cha. He is challenging the word bearing. Mr. Dhawan, learned
Please,
counsel
Mr.
for the petitioner, submits that the prosecution had not placed and had neither obtained the documents which are in favor of the accused persons. And that those documents which are in favor of the accused person should also be brought on record. He further submits that the accused person will have the opportunity to place the documents in their favor only after the examination of the accused person under section 313 CRPC is completed. And as such, he submits that it will be, as such, he submits that non-placement of the said documents would prejudice the petitioner. Full stop. However, on the other hand, Mr. Z. Kamar, learned senior counsel, has placed the provision enshrined under the BNSS 2023, more so, section 209 of the said act, which
And read
provides
it along with, my lord,
208.
read it along with, sir, 114 of the BNS, that is IPC, that your lordship.
1/4 of BNS.
Yes. I read, my lord. Any
One
person,
second, let me take out.
any person liable to law for time being in force in India is to be tried for an offence committed beyond India shall be dealt with according to the provision of the BNS, that is
One which, what you said, 1/5,
1/4, my lord.
1/4. I have placed section 208/209 of BNSS together with section 1 subsection 4 of BNS 2023.
1S, yes.
Uh-huh.
1S, now this BNSS and
1S,
BNS.
BNS 2023. He submits by way of placing section 1/5 of BNS that
1/4.
1/4 of BNS that a person liable by any law for the time being in force in India to be tried for an offence. That a person tried for an offence committed outside India should be dealt in accordance with the provision of the said act. In the same manner, for the act committed outside India, in the same manner as if the act has been committed within the country. Full stop. By placing section 208 of the BNSS 2023, he submits that when an offence is committed outside India by a citizen of India, whether on high seas or elsewhere, he will be dealt in respect of such offence as if the same has been committed within the country where the offence is registered. No, within the country where he where he is found or the offence is registered.
Three situation.
Three situation. Full stop. And it is further provided in the proviso appended therein that no offence shall be inquired into or tried in the country except with the previous sanction of the central government. Full stop. Mr. Kamar submits that the sanction of the central government has also been taken and the offence is tried before the session judge.
Same
Kamrup.
furnished to them also.
Hmm?
Copies furnished to them also.
Okay, offence is tried before the session judge, Kamrup. Full stop. He also submits that all the documents as per the requirement under the law were provided to the petitioner or the accused persons. Full stop. He also submits section 209 of the BNSS 2023, which provides that if any offence is committed outside India and the same is inquired into or tried under the provision of section 208, the central government, if it thinks fit, may direct that copies of deposition or any other evidence, whether in physical form or electronic form, before the concerned officer of the other country be received as evidence by the court wherein the trial takes place. Full stop. He submits that in compliance of the said provision and in compliance of the agreement entered into between the two countries, the documents were received and were made the evidence in the trial before the session judge Kamrup M in Assam, India. He further submits that few reports which are being demanded by the accused persons are after, you said coroner's report is after the trial or what?
Yes, after the charge framing of charge matter, after filing of the charge sheet, sorry.
But then how can be after?
No, my lord, coroner's is their document.
Huh.
We went by our own independent investigation. That is why I submitted, my lord, that the Singapore authorities have done their own investigation and the same cannot be used under the Indian.
Cannot be trusted upon. Yes, we're right.
That is my.
Hey, last line to nalage. No, further service. I have full stop. I have considered the submissions made by the learned counsels and have gone through the records. It is a clear position of law as provided under section 209 that if any offense is committed outside India and the same is tried within the country, it is for the central government to direct that copies of depositions or any other evidence be made available, deposition or any other evidence collected in the country where the offense had taken place, either in physical form or in electronic form, be received as evidence by the court where the trial takes place. There is no full stop. There is admittedly no provision under the law that the courts will call for the evidence collected in respect of the offense committed outside the country. It is as such directed. No, it is as
They are given the liberty, madam.
yes, it is as such. This court therefore holds that the petitioner can take recourse under section 208 of the BNSS 2023
If so advised.
by making an application before the central government, if so advised and necessary, for the proper adjudication of the case. Oh, full stop. The instant petition is as such dismissed and disposed of.
Well, only one thing will do, my lordship, that petition number is 363, which they have filed it, and into that we have responded. Petition number may kindly be mentioned. because there
Petition
are
number,
page-
it is a dissolu, they have filed the application before the
Page 58 and.
58 was it? Tata Diba,
Petition number 363.
petition number
363 of.
363 of 2026. Number 2, my dear.
Because the 3 petitions were disposed of similarly on that day, my lord. So
Okay.
there may be confusion, that's why I
Okay,
said.
it's 363.
Furthermore, if your lordship would like to see page 14, paragraph 32 for refurnishing of my submission, my lord.
Paragraph, page 40.
Paragraph 32. These are the valid points which I have raised this. Subsequently, your lordship can give the final touch, my lord.
Paragraph 42, where is
No,
paragraph?
page 40, paragraph 32, my lord.
Page 40.
On the top, yes.
Hmm.
Now,
Paragraph 32.
yes, my lord.
You wanted these
No, my
submissions to be here.
contributions are there, so
Hmm.
if your lordship would give the final brushing, my lord, then incorporated my submission.
Okay, so this postmortem,
Yes.
toxicology, final medical opinion, all were received.
Yes,
I said only documents were received.
Yes.
Okay, I can.
As your lordship feel,
Hmm.
I just pointed, and furthermore, we have stated in details at NHR 5, page 61 in our objection. Same submission will be my submission today also. So a bit of furnish,
Yes. Hey, documents are good.
ornamentals, well,
Yes, he has furnished those, he has already got those documents, prosecution কথা কৈছে যে, ইয়াতে এইকেইটা লিখি দিব পাৰা. Postmortem report, toxicology report on all those has been furnished and it has been furnished to the accused, কৈছে ন? এই তাতে এইখিনি লিখি দিব পাৰা. You can say, I've marked it. I've marked it. Page number 40. I cannot trust it. Okay, it is already there. And the central government is the competent authority to exercise the
that is
power.
what I'm saying, only
Yes.
the written objection is there, in details I've
Okay.
stated.
তুমি দিবাচোন মই বাৰু সোমাই দিম কিবা এটা. Okay, Mr. Dhawan.
Please, minutes.
Oh, there is
He has
another.
another
Plus
item, my lord,
next
but it's in
item
a
is also
different-
related.
This is probably criminal revision against the order dated 2/3. Mr. Dhawan, if I'm not wrong, attachment
Yes,
of the
yes.
residential
Attachment of-
flat. Is it?
Please, sir, you are right.
Okay, then we will take it up at 2
Two,
then.
my lord. It will take some time.
Please.
A to dispose of them. Okay. Okay. Yes,
Lord,
other item.
My lord, before my senior starts, my lord, item 57, supplementary motion, my lord.
Huh.
I have a prayer to upgrade, my lord. There is some urgency, my lord. So lordship may take up before rising, my lord.
This motion really matters takes
My lord,
long.
it was listed yesterday, my lord, as a last.
Acha, acha. Okay, okay. I'll take it up and then
Before
I'll
that-
rise.
before
Okay.
that. Okay.
I'll sit late. Yeah. Yes, Mr. Kamar.
My-
Who is there for the yes, Mr. Dhawan? You are
Please,
there.
Milord. Yes, Milord.
This is for what?
Milord, this is against the order whereby my residential apartment was attached on the application of the prosecution.
By the same order.
No, no.
No, Milord, this is
Not
different
by the
order.
same order.
This is in
Not-
Miss case number 1 of 2026, my lord. Order dated 2/3/26. It starts from page 22, my lord.
22 Milords.
Actually, before his submission, my lord, we'll have a look at page 35, the actual finding of direction, my lord. Page 35, para
Yes.
18, my lord.
Yes, as this court is
Prima facie satisfied.
So 16 lakhs is actually the proceeds of crime,
Yes, madam.
but the rest are not. But the
Rest
entire
rest
flat.
are not concerned with here, my lord, because at the time of purchasing the flat, my lord, the rupees 16 lakhs was embezzled from the account of Jubin Garg, and that was paid for purchasing the flat. So the court deemed it fit that we will not attach the whole thing. You give a bank guarantee and your flat is be with you. That is my understanding from para 18. So this 16 lakhs is kept in the safe custody. That is what.
Yes.
So that if at the end of the trial, if he wins, he'll get it back.
But then he said that it was attached, the flat.
No, my lord, with
Yes,
the
ma'am.
condition that give a
Okay.
bank guarantee for 2 years.
Until we submit the bank guarantee.
Yes.
The order
Subject to
says
submit.
until we
It is
submit
his
the bank
condition.
guarantee.
He has got the right of audio. Mr. Ankit, we kindly submit.
So until you submit your bank guarantee, it will stand attached.
Attached. This is the
So-
order.
Is the issue before your lordship. Now his submission, your lordship will hear it.
So what do you
Plus,
say
if
on
I
this?
may. Yes, Milord. Plus, the timeline is very important here. The accused purchased the property in the year 2017. He took a loan from ICICI Bank and there were 66 installments paid. The last installment,
paid.
yes, Milord, the last, that is the 66th installment was paid on 18th July 2023. Milord, this date is very important. This installment was, the last installment paid was of 15 lakhs. And the case of the prosecution is that suddenly he paid such a big amount of installment. Because what is important to be noted, this installment was paid by check and the loan was closed. By his own account, it was paid by check. Now, Milords, in November 2023, after almost 5 months, he got associated with the late singer Zubin Garg.
Before that, he was not associated.
No, Milords, he was associated with TM Ventures Private Limited. And Milords, this has been admitted by the prosecution in their application itself. This is not what I am saying only. Milords, kindly have the application of the prosecution starts from page 53.
Yes.
Milords, at page 54, para 6. Milords, has it?
Yes.
If I may read,
So
Milord.
he was working with TM Ventures.
Yes, Milord.
What is TM Ventures?
Milord, it is a company which used to organize and manage the shows of singer Zubin Garg and other artists also.
So he was
It is-
associated with him.
Milord, I'll come back to it. Milods, the case of the prosecution is right from the inception, even in the charge sheet, is that being a personal manager, why I am accused in this matter, I am the personal manager of the late singer. And because being at the personal manager, I had the capacity to embezzle his money and misappropriate his money. And because of such reason, the amount which have been misappropriated by me constitutes a proceed of crime, which makes up their case for the attachment of my house, my firm, and whatever what else, bank attachment and everything. Those revision petitions are separate. I am not going into that. So this is their case. There has to be a proceeds of crime for the attachment. The proceeds of crime is that I misappropriated the money of the singer Zubin Garg, being in the personal manager capacity.
When did
Now,
he become
Miloj,
the manager of the late singer?
Miloj, November 2023.
November
Now,
20.
Miloj, kindly have page 54, Miloj.
But before that, he was a salaried person.
Yes, Miloj. This may I
of the
read,
same
Miloj?
company.
Miloj, may I read? The accused person, Shri Siddharth Sharma, who was a salaried person up to November 2023, earning 57,000 rupees per month from TM Ventures Private Limited, but suddenly rose to such a status to purchase the apartment of 30 lakhs, Miloj, the apartment which has been taken on loan, which is
Something to be pondered
something
upon.
to be responded upon. The accused person, Siddharth Sharma's father, and they are recording about my father's status, my mother's status, my wife, sorry, my mother was housewife and all that, which is not relevant. Miloj, just before that, Miloj, para 4. Now, how they make a case against me through the prosecution witnesses, that how I misappropriated the money, though nothing has been placed on record, if I may just point out. At para 4, they mention a witness, namely Ritu Prayag Garg, had stated on oath the fees collected from the shows of Zubin Garg should be made in the bank accounts, and insisted Siddharth Sharma not to accept cash from organizing committees. But Siddharth Sharma declined the same so that the Binami transaction and money laundering can be facilitated through him, as he was the manager of late Zubin Garg. Because all these things could be happening only after November 2023. I was not the manager. The manager was a company named TM Ventures. I was just a salaried employee over there. There is not a single statement in the application, in the whole charge sheet, stating that while I was a salaried employee in TM Ventures, I used to embezzle the money of late Zubin Garg. The only charge against me is that being a personal manager, I used to handle his shows, I used to handle his events. And they say, as per the allegations of the prosecution, they say that I used to deal with the artists, the managers and event managers, everyone, and insist on cash and then embezzle that money. For example, if
But
the
in,
amount,
but in paragraph 4,
please,
it is not stated that after he became the manager. Neither it is stated that during that
my
period
lords,
also.
in the whole charge sheet, it has not been stated that being an employee. Everything starts from I becoming, when I am not in the capacity of managing the funds. I am a salaried employee in a company. The company should be the accused that he has mismanaged. I am not the person who has been authorized working for a management company to manage the accounts of the singer,
But then the
until and unless
company,
I become the
whoever
personal
is,
manager.
no, whoever is responsible for day-to-day affairs, he will be responsible.
Exactly.
Company is
Exactly,
okay.
Milord. I totally bow down to this, because the company is the manager of day-to-day affairs till November 2023.
Who was
So
in charge of day-to-day affairs?
the TM Ventures Private Limited, and I
Hey,
was
that
just
has
an
to be meant
employee.
by someone.
I was not the owner of TM Ventures.
But then who was the?
That is for the prosecution to place on record, and the company should be look for, not me, not my house. They have attached my house just being an accused in this matter, and I had paid the loan way back before becoming the personal manager of the singer.
Okay, what is the finding of the court?
Please, Millers. Millers, first of all, the finding
16,000.
of the court is They have wrongly
Will-
recorded.
Shall remain under attachment of CID till the bank guarantee is given by
Yes.
Siddharth Sharma. The bank
Yes,
guarantee shall
madam.
be initially for a period of 2 years with provision of extension or till the order of this court. It is hereby cleared bank guarantee as so and so. Okay. So
Milos,
you,
kindly have page
so you
number.
are not agreeable to give a bank guarantee?
Milos, I am in jail. I have no sources. They have stated that since prosecution establishes that it is at the verge of liquidating, Milos, my learned senior will not deny this. Even to get the wakalatnama signed, I have to move an application before the court. How can I, being in jail, in custody, I'm not on bail, alienate my property? This, and the court has not, in the impugned order, has not stated anything how the property is at the verge of alienation. Second thing, my lords, the amount, whatever they say, I misappropriated everything. I have paid through check, through my account. It is not something I have paid a cash amount to the bank and I am not able to explain the cash. It is upon the prosecution to explain. They could have done income tax rate. They could have done other remedies. If my account just suddenly got the cash payment, nothing has been placed on record by in the
So
application also.
you paid the last installment to the tune of 15 lakhs.
15 lakhs, my lord.
At one go.
At one go on 18/7/23.
Yes, my lords.
18/7/23, you were just an employee of the company.
Company TM
And
Ventures,
you
who used
became
to
the
manage
manager in November 23.
2023. Milords,
Why the
if I
installments
Milord.
amounts were not of the same amount per month or
Milords,
what?
earlier it was same of 15,000.
Rate of 15,973.
65.
15,900.
Yes,
73
Milords.
per EMI.
65 installments were
240
paid at
months.
15,000.
So some EMIs perhaps was not given. So what is the necessity of paying?
In this case, it is reverse, my lord.
Ah.
EMI was given at one go and he cleared the dues within, by paying 15 lakhs, 93,110. So this
The
amount
66th
is that
installment.
misappropriated amount.
Acha, he paid it at one go.
One go.
Yes,
Per
Milord.
month he did not pay.
No.
He
It was for a
before that
duration of
in
240
65.
EMI, equal installment, monthly installment.
But then those equal installments he did not pay.
Earlier he was paying regularly, that was for him, my lord. But when he became the manager, he misappropriated and deflected money.
But manager he became late.
No, my lord, at that time he was a manager.
But he said that the manager he became
Yes,
on
it's
November.
written in their application.
It will come from the record.
Where is that? It is not stated in their application.
It is stated, Milords. Milords, kindly have page 54, para 6.
54 para 6. Yes, I've gone
Yes,
through.
Milords. Yes, Milords.
This is
He was a salaried employee in TM Ventures Private Limited, earning 57,000 rupees. It has been clearly
Yes.
mentioned till November
but
2023.
it is not stated that he became manager in the
Milords,
year November
how I cannot become a
2023.
manager of late Zubin Garg when a company is managing his affairs and I am an employee in that company? I can be an employee. Then
No, I think
please.
not manager of late singer, manager of this company only.
So the company, so exactly, if I embezzled the whatever funds I could embezzle, it could be of TM Ventures, not of the singer. Firstly, because I am the salaried employee of a company. If I am a salaried employee of Sony, some Sony Private Limited, and Sony Private Limited is managing the affairs of an artist, whatever I can do, I can embezzle the funds of Sony. I cannot embezzle the funds of the artist the Sony is managing. I am a salaried employee of the company. Now they say that being the employee also, I could have embezzled his fund because later on I become the personal manager of late Subin Garg.
Kamar, he's saying that
No, it's not correct statement of facts, my lord.
it is your, I think it is your application. But then, of course, in so many words, you have not said that he was not the manager prior to November 23.
Yes, ma'am.
But
That
then
is
you
not-
are a salaried person up to November 23, earning 57,000 per month from the TM Ventures, but suddenly rose to such a stature to purchase the apartment of rupees 30 lakhs, which is something.
Cleared the amount in one go. And that is what the court found from the records, my lord. that this 16 lakhs is the proceeds of crime.
Mm.
He has got other attachment also, my lord,
Mm.
that Mohavir Ekwa, where he has invested some good crores, my lord. So that is a different subject matter, my lord. But right now we are attaching the flat on the ground that he has misappropriated and has invested that money in purchasing the flat by paying it at one go.
Mm.
That is what coming up from para 15 of the judgment, my lord, order, my lord. Kindly come to Lordship para 32, my lord. That will clear your Lordships.
32 of the order.
No, yes, 32, page 32, running page, para 13, my lord.
Paragraph 13.
Yes, my lord. Well, reverting back to the case in our hand, my lord.
Yes.
We have found that the investigation agency has enclosed the statement of the loaned account of prime accused Siddharth Sharma. Details of the same reflects that the sanction amount of loan was 18 lakhs 50,000 bank account,
Mm.
which was sanctioned on 8/11/2017 for a period of 240 months and monthly EMI was of 15,973.
Mm.
However, the loan account was closed on 18/7 with the payment of 15 lakhs 93,100.
Acha, before the loan amount could be closed, he had paid the
Yes,
entire.
absolutely. So how can a salaried people with one go? And this property is not only his sole property, it is purchased in the name of the mother,
Mother.
I believe, my lord,
Mm.
Suman Sharma, my lord.
Mm.
And this Suman Sharma is merely a housewife.
Mm.
She has got no source of income. Her brother was, his brother was also a student at that time. So
Okay,
safe
that
and
is
accept.
matter of trial, those
Yes,
will be seen.
absolutely. That's what I'm saying, my lord.
Mm.
That Siddhartha Sharma got the money from where?
Mm.
On the other hand, we have done forensic analysis of the money that he has invested everywhere, deposited money there. That is the CS report D 205. Document number 205, which the prosecution relies upon. There is the CA report, forensic analysis was done, and it was found, yes, this was the money that has been paid to the bank at one go.
Okay, paid to the bank at one go to clear his loan. It's
Loan,
okay.
absolutely.
Where is that CA account? CA.
That is document number 205. Today we are in motion stage, my lord.
Mhm.
Will come up at time, my lord. But right now he is submitting what is his prayer, we don't know, my lord. Mr. Dhawan, can you please spell the code, tell the court as to the prayer you are seeking right now?
Prayer
No,
is
sir,
to.
I'm seeking setting
No,
aside of the order,
There cannot be stay,
attachment
that is
order.
my consideration.
No.
Because till that he has not executed. The says that if he executes the bank guarantee, my lord,
Hmm.
he can get into his house.
But he's saying that bank guarantee he being in jail cannot give.
That is what the mother is there.
Mother is there, but
But
now he
As
being
per
is
the
that,
said-
otherwise
prosecution
the whole
only,
purpose will be
mother is
frustrated, my
housewife.
lord.
he wants setting aside of this attachment order.
My lord.
That's all. He wants setting aside of the attachment order
Oh.
along with the prayer that
No, then it will lose.
bank guarantee he
My
cannot
lord,
give.
then it will lose. The court was of the view that in this case, the 16 lakh that is involved in this case
Hmm.
is to be secured. So that if the person, he wins it, it will revert back to him bank guarantee. If it loses it, then if the crime proceed as per law, it will be distributed among the person from whom it was the proceed of crime. That is the law behind the logical, behind 105, 106, 107 BNSS, my lord. That has been clearly reflected, my lord. It's starting from page 31, para 12, my lord. And in the petition, he has not make any interim prayer for something like that, not to execute.
No, nothing. Only to
Ah.
to cancel the attachment and
Please, ma'am.
together with the fact that
So
he cannot
that in the
give the-
motion state itself cannot be done so, my lord. We'll have to file the reply.
Okay, let the CID file reply.
Please, ma'am.
We will consider on the next day. Heard, Mr.
Ankit
Ankit
Dhawan.
Dhawan, learned counsel for the petitioner, and Mr. Jed Kamar, learned senior counsel, assisted by Mr. P. Sharma.
P. Datta.
P. Datta, learned counsel appearing for the respondent. By this application, the petitioner has prayed for quashing of the order dated 2/3/2026, passed by the learned session judge Kamrup Gauhati in miscase number 1 of 2026, filed by the chief investigating officer of CID of SIT CID police in connection with CID PS case number 18 of 2025. Issue notice. The petitioner to take steps for, no, issue notice, Mr. Kamar, the learned senior counsel, by his assisting advocate, appears for the respondent, sole respondent, As such, no formal notice is required to be served upon him. Some copies you require? No, copies you have.
Because he is
Okay.
from a outside matter.
Uh-huh.
I'll
Miss,
give it-
the learned counsel appearing for respond number 2 prays for some time to file an affidavit in file his objection to the said application. List this matter after 2 weeks on a date to be fixed by the registry. Full stop. Okay, right? Or you want a date?
Obliged.
Can it be on 3 weeks because we'll have to call for the.
List after 3 weeks on a date to be fixed by
My
the
lords, it
registry.
will be better if a date be given.
Uh-huh.
If a
Yes.
date be given, my lords, it will be more convenient.
Okay, list this matter on 22nd of September.
Please, ma'am.
No, that will not be 3 weeks. So that will be 3 weeks. 22nd of September, 2026.
Obliged, my lord. Highly obliged.
Much of it.
Yes. What is this revision?
Is the order asked by the session judge,
Mm-hmm.
criminal appeal number 118 of 2000
You have challenged what? Judgment and order. Criminal appeal. Conviction.
conviction.
Okay, let me admit this matter and call for the records, right?
Yes, and there,
Is this a POXO?
no,
Acha.
Direct conviction.
NI Act. Let notice be issued.
Yes.
Heard, Miss
SJ Hayat,
S.J. Hayat, learned counsel for the petitioner.
pair for suspension of the order.
Let notice be issued. The other party committees NIA, right? So, negotiable instrument. Yes, for the petitioner as well as Miss S.H. Bora, learned APP for the state of Assam, representing respondent number 1. By this application filed under section 438 of the BNSS, the petitioner has challenged the judgment and order dated 6/3/6/2026, passed in criminal appeal number 118 of 2025 by the learned session judge Kamrup M. The full stop. The petitioner has also challenged the judgment and order dated 31/10/2025, passed by the learned court of JMFC 1 Kamrup M in complaint case number 1118 of 2021. Full stop. By the said impugned order dated 3/6/2026. Where is that? 3/6/2026? Acha, acha. Okay. And 6, the petitioner is directed to pay an amount compensation.
Amount of 9 lakh,
Ah,
including
wait, the petitioner was directed.
the related portion is on case number 30.
34. No, 34, no. 35.
35, 36, 37. And the order of the learned JMFC 1 is, the relevant portion is on page number 55.
Mm-hmm.
55.
Acha. In the appeal, it was just upheld, right?
Yes,
This court is of the
sentence is on page number 55.
55.
Number 36.
By the by the order dated so and so, the judgment and order passed by the trial court was upheld. The petitioner was convicted. Is that? Under section 138?
Yes.
Under section 138 of the NI Act, and was sentenced to pay a fine of rupees 9 lakhs to the complainant as compensation within on a more. And it was further directed that the convict shall undergo SI for a period of 6 months in default of the payment of fine by the order of the trial court dated by the order of the trial court dated 31/10/2025. Issue notice. Petitioner to take steps for service of notice upon respondent number 2 by speed post with AD or by usual process. Call for the trial court records along with the records. A call for the trial court records along with the records of the appellate court in connection with the aforesaid case. List this matter after 3 weeks. On the date to be fixed by the registry. 16.
May I appeal, Your Lordship? Petition is filed against the judgment and order passed by the learned additional session judge FTC Kachar Lordship. Whereby the Lordship kindly come to the page 48 Lordship.
So 420,
420 Lordship.
468.
468.
Okay, heard Mr. N.H. Roskar, learned counsel for the appellant. For the petitioner.
Petitioner.
For the petitioner and Mr. S.H. Bora, learned APP for the state representing respondent number
1 Lordship.
1.
One, I-
Respondent number. Respondent, sole respondent. What is sole? For the state of Assam. By this application, filed under section 438/442 of BNSS 2023, the petitioner has prayed for setting aside of the judgment and order dated 17/8/2026, passed by the learned additional session judge FTC Kachar Silchar in criminal appeal number 61 of 2025. Full stop. The petitioner has also challenged the judgment and order dated judgment and order dated
17/8/2026.
No.
Or-
23
Appellate is 17/1.
29/11/25.
29/11/2025. Passed by the-
Judgment and order dated 29/11/2025, passed by the trial court in GR case number 807 of 2008. Full stop. The petitioner had stated that by the said judgment of the trial court, he was convicted under section 468 of the IPC.
Lordship, pardon. Learned appellate court set aside the section 468 Lordship.
It's partly
and-
allowed.
Partly allowed.
Partly allowed.
Partly allowed, and convicted under section 420 Lordship.
Okay.
Set aside Lordship.
No, trial court had convicted you on.
Yes.
Trial court, I'm talking about trial court only. Was convicted under section 468 of the IPC and was sentenced to undergo SI for a period of 6 months with fine and default stipulation. Full stop. The trial court had also convicted the petitioner under section 420 of the IPC with fine,
Or rupees
with
10,000. 10,000.
with fine and default stipulation. Full stop. Against the said judgment and order of the trial court, the petitioner has filed an appeal before the additional session judge FTC Kachar Silchar, and after hearing the appeal, the learned court had modified the sentence and had set aside the conviction and sentence under section 468 of the IPC
Yes.
and had upheld the conviction and sentence passed by the trial court under section 420 of the IPC against the petitioner. Call for the trial court records in connection with both the trial court as well as the appellate court. List this matter after 3 weeks on a date to be fixed by the registry. What is this?
I is for the Lordship, actually made
Suspension.
and suspension sentence and allow him previous bail Lordship.
What is the sentence here?
Yes, 6 months.
6 months.
6 months.
6 months.
You are already on previous bail.
Yes.
Where is that?
This will be at the next year Lordship, but during the time of filing the appeal Lordship, he was in previous bail Lordship.
But
During
when
the
it's-
time of-
To file the revision, he was put on previous bail.
Yes, Lordship. Made an application there. Lordship.
6 months total, 420.
Yes,
6
Lordship.
months.
Okay. Heard Mr. N.H. Loskar, learned counsel for the applicant, and Ms. S.H. Bora, learned APP for the state. By this application filed under section 430 of the BNSS 2023, the applicant has prayed for suspension of sentence and for allowing him to go on bail in connection with the judgment and order dated 17/8/2026, passed by the learned additional session judge FTC Kachar Silchar in criminal appeal number 61 of 2025, by which the petitioner was by which the conviction of the petitioner under section 420 IPC awarded by the trial court was upheld. The petitioner was sentenced to undergo SI for a period of 6 months with fine and default stipulation under section 420 of the IPC. It is this sentence that the petitioner has prayed for suspension and for allowing him to go on bail. Full stop. It is noticed that the petitioner was convicted under 420 IPC with and was sentenced to undergo. Where is that? Sentenced to undergo SI for a period of
6 months.
6 months with fine and default stipulation. The learned counsel for the petitioner submits that the petitioner was enlarged on previous bail so that he can file an application before the High Court challenging the said conviction and sentence. Full stop. Under section 430 of the CRPC, the High Court can suspend the sentence and release the appellant on release the. Actually, that is an appeal.
Previous bail.
This is.
He wasn't previous.
But where is the? He has not annexed the order.
He's only on the only submitted. Lordship.
Where is the appellate court's
Yes.
order? Huh?
Nothing on record to show that he is.
Yes, that is why I've said in his submissions.
Yes, Lordship.
But where is that? The conviction and sentence when the stands acquitted of the charges is directed to appear before the
15 days.
within 15 days and to receive the
Nothing was there.
Ah.
State order.
before the learned trial court within 15 days from today to receive further order.
Yes.
So,
15 days is not completed, Lordship.
but you should have annexed the previous bail.
Lordship is suspended till the final order of this revision petition, Lordship.
This is okay, but where do I get the enabling power? 430 is in respect of appeal.
430 Lordship, subsection 3, Lordship.
There is nothing on record to show that he was on previous bail.
Nothing. He has not annexed.
The judgment also, Lordship, that is not reflected.
Under section 430 of the of the BNSS 2023, it is provided that if the convicted person satisfies the court by which he is convicted that he intends to file an appeal, the court shall, where such convict is sentenced to an imprisonment for a term not exceeding 3 years, release the person on bail unless there are special reasons for refusing bail for such period that could afford sufficient time to present the appeal and obtain orders from the appellate court. Full stop. The learned counsel for the petitioner submits that the petitioner was released on previous bail. However, he had not annexed the copy of the same in the present petition. But in view of the sentence, which is only for a period of 6 months, and coupled with the fact that the appeal could not be heard within the said period of time, this court deems it fit to suspend the sentence and enlarge the petitioner on bail. Suspend the sentence. Dated. Suspend the sentence. 29/11. Suspend the sentence dated 29/11. Suspend the sentence dated 29/11/2025, which was upheld by the appellate court by order dated 17/8/2026, and allow the appellant to go on bail on furnishing of a bail bond of ₹20,000 with one local surety to the satisfaction of additional session judge, FTC, Kachar Silchar. Full stop. The I is disposed of.
Yes. Hello.
Item 10 now. Yes, Mr. Ahmed?
Page 13 is the FIR, Lordship. I am seeking crossing of that FIR and criminal proceeding, Lordship.
Quashing of FIR.
Yes.
Special Judge Assam. Why Special Judge? PC Act.
PC Act.
Where is the FIR?
FIR page 13.
Long FIR?
Long.
No.
So, I'm just cutting it short, Lordship.
What is your name? Madhav Saha.
Madhav Saha.
Yes.
My point is also very limited before your Lordship because this is PC Act, so I am not going to into details of the FIR. So only I am on procedural. If your Lordship see page 13, last paragraph. So this is the second incident. There are Lordship on last three paragraph I am reading.
Last paragraph of page 13.
Director of Vigilance, Anti-Corruption.
What is this?
Lordship, it is respondent number 2, Superintendent of Police, Lordship.
You can appear.
Vigilance and Anti-Corruption. So there is a special PP perhaps.
Acha.
Let them appear, Lordship.
For vigilance, CM vigilance.
Yes.
And
Director of Vigilance and Anti-Corruption.
okay. So there will be a special PP.
Yes.
So call him. I will take it up after some time. Who is there?
Lordship, we have to verify.
Okay. After some time.
Please sign off.
My God. Yes. 17.
May I please, your Lordship? Lord, we have challenged the order, my Lord, case 41.
You have challenged the order
Case 41, my Lord. Dated
for
1.
setting aside 1/8/2026.
Here, my Lord, what happened, my Lord? The land, my Lord, petitioner purchased the land in 1999 by Annexure 1, my Lord, by registered sale deed. Then it was muted in his name. Then, my Lord, in 2024, the respondent number 2, his nephew, my Lord, he was staying at Nagaland. He came back home.
Wait. I couldn't follow you. Where is the FIR and all?
This is not
This
FIR,
is. Acha, show me the order 1/8/26.
case 41. By this order, my Lord, the executive magistrate, my Lord, he is directed to implement the agreement.
Okay, so this Siraj Ali did not appear.
No, my Lord, the agreement, how, my Lord, executive court can direct for execution of agreement, my Lord. His application, my Lord, page, annexure 3, page 26. He filed application under section, my Lord, 126, earlier 107, 145 and 140.
Page 26.
Lordship.
So he Sirajuddin is the second party.
Oh,
So what happened?
now his prayer, my Lord, Lordship, kindly see. Paragraph, page 20.
This is the application filed by whom?
Respondent number 2, my Lord, on whose favor, my Lord, the order has been passed.
Rahimuddin.
Lordship. Baharuddin.
Acha, Baharuddin, yes.
Baharuddin.
So, what do you want to show from this page 26?
This is the petition, my Lord, filed by the Baharuddin, my Lord, for under section 164, 165 and 126 CRPC. And his prayer, my Lord, page 28. His prayer for, my Lord, inquiry and impose 145 proceeding.
Acha, let notice go to Baharuddin today.
And till then, my Lord, impugn order may kindly be stayed because police is forcing, my Lord.
What do you say on this?
Police cannot.
No, why? Implementation of the aforesaid agreement. Why this court cannot?
No, executive magistrate cannot. This is a civil jurisdiction, my Lord. How,
And further, it was also said, maintain peace and tranquility.
that
between-
is different, my lord.
That is different. That is okay.
That is different.
Hmm.
Regarding land part, my lord, executive.
See,
Fourth-
Sirajuddin was a part of the agreement. Now he is backed
No, I
out.
am not the part of. This is agreement is fourth, my lord.
Was not challenged.
You should have pointed out that. You did not appear.
Yes, my lord, we have taken this plea, my lord.
But then
No
you did not
agreement was signed.
appear.
Even, my lord, agreement is signed, my lord, between two parties regarding handing over land.
Hmm.
The executive magistrate, how can he execute? this
Acha, there
agreement?
was an agreement where everyone had decided that
Lord.
land
And it
will be
was
apportioned
by the civil court.
Distributed among the parties.
amongst it.
Yeah.
And he did not appear. Sirajuddin should have appeared.
That's why ex parte order has been passed by the
No
learned.
ex parte order. Later on, serving repeated notices, Sirajuddin did not attend. As such, ex parte for implementation, OC is directed. Let
Notice
notice
should
issued
go to the
today,
ex
and then we will decide on the interim prayer. Heard,
Regarding,
Mr.
my lord, direction to the OC, my lord. How can OC will hand over the land, my lord?
That was not given.
This is the order, my lord.
Murajhar is directed to ensure
Yes,
peace and tranquility.
OC Morazar is directed to ensure the peaceful and before that,
During
my lord,
implementation, implementation will be done by you all. He will maintain peace and tranquility. A bond amounting to so and so also signed by both the parties. That is according to law.
Now, first part may kindly be stated, madam. Second
First part, there is nothing.
regarding
Serving,
implementation,
you all had entered into an agreement. You did not appear. Heard Mr. R. Ali, learned counsel for the petitioner, and Ms. S. H. Bora, learned APP for respondent number 1. By this application, the petitioner has challenged the order dated 1/8/2026, passed by the learned executive magistrate Hojai at Simonta Sankadev Nagar in MR case number 217 of 2024, by which the officer in charge of Murajhar police station was directed to maintain peace and tranquility between the parties during the implementation of the agreement. Issue notice the petitioner to take steps for issuance of notice upon respondent number 2 by speed post with AD or by usual process. List this matter on 14th of September 2026.
Made please, your lordship. Concurrent findings are there, your lordship. I was convicted by the CJM and then
It should be the revision then. Why petition?
revision, your lordship. I filed a revision.
Acha. Or revision petition?
Revision.
Okay. In the first page, it is written petition. Okay, heard Mr. T. Deuri. We'll call for the records.
Yes, sir.
T. Deuri, learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state, representing respondent number 1. By this application, the petitioner has prayed for setting aside of the judgment and order dated, setting aside and quashing of the judgment and order dated 27/2026, passed in criminal appeal number 1 within bracket 1, 01 within bracket 1 of 2024. You have not challenged the order of the trial court.
No, your lordship.
Why?
Only the appeal is which I-
Acha, trial court, you were acquitted.
No, I'm convicted, your lordship.
Concurrent.
But then
Concurrent findings.
concurrent
What the-
findings.
I'm only
Yes.
challenging-
But if your appellate order goes, your trial order will remain.
Yes.
I don't know, but I've seen many cases. If your trial order goes, then appellate order will also go, I think. The subsequent orders. But a trial order will remain.
That has to be challenged.
Okay. In the prayer also, you have made only appellate order. No, you have also. No, you have also challenged. No. Criminal appeal only.
Yes.
Perhaps you have to amend the petition.
In my respectful submission, your lordship, if the appellate order goes, the trial order also goes.
I don't know. Why will trial court order go? Appellate order will go, trial court order will remain. That is a previous order. I don't know. What do you say?
Even I'm also on the same.
Right.
with you. Yes, Lordship.
Because in writ petitions, what we do,
Yes.
we say this and consequential order. So
Yes.
consequential order goes if the basic goes.
Yes.
But if the later order
Later
goes, the
then
earlier order will remain.
Will prevail. That is the law, usually. Subject to correction.
Subject to corrections, of course. Okay. The learned counsel for the petitioner submits that the petitioner was convicted under section.
130.
You have not annexed the trial court order also.
I have been
Where is that?
at page 18.
18.
Order dated 9/1/2024.
Acha, okay. Page 18 or 14?
18.
18 onwards.
18 onwards.
18.
It starts as 18.
Was convicted. Trial court order must have only upheld the order of the trial court.
Yeah.
Yes.
The appellate order.
Where is the operative portion in the trial court's order?
At page.
Page 41, I suppose.
41.
No, page.
The appellant, Biren Borua, right, was convicted under section 138 of Negotiable Instrument Act 1881 and was sentenced to RI for a period of 1 year with a compensation of rupees 5,60,000 with the default clause. The learned counsel for the petitioner submits that the said conviction and sentence was challenged before the appellate court, and the appellate court, by order dated 27, by judgment and order dated 27/2026, had upheld the order of the trial court. Call for the, but you have to have the trial court's order. You have not challenged the trial court. You file an I, okay. Call for the records in connection with both the, call for the records in connection with both the trial court as well as the appellate court, as mentioned above. Any notice? Oh, yes. Issue notice?
Respondent number 2.
The petitioner to take steps for issuance of notice upon respondent number 2 by speed post or by usual process, with AD or by usual process. List this matter after 3 weeks on a date to be fixed by the registry. Ouch.
Lordship, the order under challenge is order dated 25/11/2025.
Mhm.
Passed in a order under challenge is order dated 25/11/2025. Passed in a proceeding under section 138 of the NI Act.
Let the notice go today.
Yes.
What is this order 25/11?
Lordship, by this order, the trial court under section 91 of CRPC directed the complainant of NI proceeding to furnish the banks the income tax.
Acha, where is that order?
Order is page 13. Operative party is page 13 also.
13.
1-3. Para 8, Your Honor. The complainant shall produce his income tax return for the so and so year. Lordship, the only problem with the order is the complaint in a proceeding where there is section 139 of the NI Act, Your Honor. The presumption goes in favor of the complaint.
So to the extent you are the complainant here.
I am the complainant here.
So you were directed to produce this. His income tax.
2012, 13, 13, 14 and 14, 15. That too decades ago, Your Honor. Or this order was passed on 25/11/2025. I had to produce the income tax documents of the year 2013, 14.
That doesn't matter. It will be there with your CA.
Your Honor, these documents are not in my possession, Your Honor. Because even as per the provisions of the income tax that I have to keep the income tax return for the 7 years. And Your Honor, the problem with the order is the petition that has been preferred by the accused person under section 91. They want the adverse presumption upon the complaint if complaint fails to produce these documents before.
This application under 91 was filed by the accused person.
By the accused person, Your Honor, at the stage of defense evidence, Your Honor. The problem is the accused person has all the liberty to lead all the evidence at the stage of DW. He could have called the income tax authority to submit all these documents, to which I have no objection. But that person did not call the income tax authority. That person directed me to submit these documents before the court. But at this stage, I cannot produce these documents. If I cannot produce, the adverse presumption will be drawn against me that I don't have these incomes. I don't have the source of income. And case is at the stage of DW. If I fail to produce, the case will be heard will be fixed at the stage of arguments and judgment will be passed. And that might prejudice me. That is the problem.
Show me section 91 of the CRPC. By either party, it can be filed, right?
Your Honor.
So your only ground is that you don't have those in your possession.
Your Honor.
Those income tax certificate return for the financial year of 13.
12 to 15, Your Honor. 2012 to 2015.
To 2012 to 2015, you don't have.
Your Honor, I don't have.
And your balance sheet? That you have.
That goes again. That goes with the income tax report, Your Honor. That is always tagged there. Balance sheet. You know, there are numerous judgments of the Honorable Appeals Court.
On what?
That the complaint cannot be directed to act in a particular manner in a proceeding under section 138. The production of
Cannot be
directed to act in a particular manner in a proceeding under section 138 of the NIT, Your Honor. In 138, Your Honor, there is a presumption that the check was issued for the legally enforceable debt. It is the accused person who has to revert the presumption. They have all the remedy.
But what will, by calling these documents, what purpose will be served?
They want to prove that I don't have the source of income to lead this amount, Your Honor. The check amount.
Yeah, how much amount did you give it to the accused?
15 lakhs, Your Honor.
15 lakh.
1.5, Your Honor.
Let no notice go today. We will consider on appearance of.
But on the next date, matter will be fixed for arguments, Your Honor, and judgment might be passed. So till the next returnable date, Your Honor, case may be stayed, Your Honor. Trial proceeding may be stayed.
Because this, I have to see if I have to dispose it of. Okay, heard Mr. N. Sahu.
No, Your Honor. P. Pravar, Your Honor.
P.
Pravar, P-R-A-W-A-R.
A learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state for representing respondent number 1. By this application, the petitioner has prayed for quashing of the order dated 25/11/2025, passed in CR case number 2571 of 2025 by the learned court of JMFC number 1, Kamrup M, Assam. By the said order dated 25/11/2025, the learned court had directed the complainant to produce certain documents relating to his income tax return for the financial year 2012 to 2015 and the corresponding balance sheet. Full stop. The learned counsel for the petitioner submits that the case was instituted under section 138 of the NI Act,
And at the stage of
wherein the allegation is that the complainant, wherein it was stated by the complainant that he had given an amount of rupees 15 lakhs to the accused person, and the accused person had issued check to him which got dishonored due to insufficiency of funds. He submits that the said documents which were directed to be placed has no connection whatsoever with the instant case. Full stop. Issue notice. Petitioner to take steps for issuance of notice upon respondent number 2 by speed post with AD or by usual process. In the facts and circumstances of the case, in the interim, this court finds it fit to stay the further proceeding of CR case number 2570 of 2015 till the next date of listing. List this matter after 3 weeks on a date to be fixed by the registry.
Washing petition, Lordship, for the section 528, where challenge is made to.
Washing
proceeding
petition
under-
of what?
Of a
FIR.
section 12 petition under Domestic Violence Act.
Oh. You are there. Today it has come up for the phone. No. Today it has come up after so many times.
No, for the first time.
No.
On the
Pray for
last of the year,
adjournment.
I was not there, Lordship. Lordship, this petition is filed on the basic issue involved is that the petitioner and the respondent, they have never cohabited. In fact,
They have
never cohabited, Lordship.
Acha. Married?
Married, Lordship, under Special Marriage Act, but they never live together as husband and wife under a single law. And to constitute domestic relationship as per definition of section 2F, they have to reside in a household, Lordship. That definition, if Lordship comes to the definition of
yes.
section 2F, they have to live together as
Domestic
husband and
Violence
wife
Act?
in a shared household.
The DV Act one? Yes, they have to stay in a shared household.
Yes. Admittedly, they never stayed together under a single roof.
But
so-
that is a disputed position. Do you agree?
And apart from this, Lordship, I filed a petition against her under the provisions of section 25(3) of the Special Marriage Act alleging nullity. As because the
Alleging?
consent for the marriage was obtained through fraud and coercion. She was earlier married to some other person, Lordship. After my marriage with this respondent, Lordship, I happened to come across e-court service, and from there I came to know that she was earlier married. And that fact was suppressed to me at the time of marriage, Lordship. I have annexed everything, Lordship.
And she was not divorced with that person?
No, she in fact had filed a petition under section 125 also against that person. And ultimately what had happened, both the parties failed to appear and that case was filed, Lordship. When we came to know about this entire incident, we said that we cannot cohabit. And we filed a petition under section 25(3) of the Special Marriage Act. After filing of our petition, after 2 months, this petition was filed alleging domestic violence, Lordship. Now proceeding is going on. There are 2 counts basically. Supreme Court has made it very clear that only on the point of gross abuse of the process of law and gross illegality, proceeding under section 12 can be quashed. And these 2 aspects are fulfilled in my case, Lordship. There is gross illegality in the sense that her earlier marriage was suppressed as we filed a petition. And as a counterblast to our petition under section 25(3) of the Special Marriage Act.
25(3) is what?
Lordship.
25(3) of Special Marriage Act is?
25(3) is
Nullity of marriage.
Nullity of marriage, Lordship, where the consent
nullity
of
of
either
marriage.
party was obtained by coercion or fraud.
Okay. Acha. So here what happened? You will file your objection.
Yes, today is the first day, Your Lordship. I have entered myself I didn't receive any notice of this case, but there are always cases pending in the trial court. That's why I came to know about this case and I filed my wakalatnama. Lordship, I need to go through that case. I maybe served a copy of the petition, Your Lordship.
That will
first.
get an opportunity after notice issued. If I may treat Your Lordship to the
Your Lordship,
to page 61.
1 second. But admittedly, you must be knowing about the facts. Admittedly, you have not stayed together.
we stayed together, not in the house of not in my matrimonial house, but in my parental house, Your Lordship. Lordship, we have been in a relationship.
Your parents' house.
Yes, my parents' house.
And then
He used to live in Gauhati, and he often visits my house. We have been in a relationship since 8 years, for 8 years. And during that period, at first, we conducted the court marriage under the Special Marriage Act, and thereafter, he and his family members went to my place. The conversation, conversation of marriage was done between my families and his family members, and thereafter ritual social marriage involving the kaji, that social marriage was conducted. Your Lordship, after the social marriage was conducted in the year 2025, Your Lordship, then when I told him that you came here, we stay together, that we have consummated our marriage, you should now take me to my matrimonial house. Then he gave me excuses that he does not have a home to stay, as he is now staying with his mom and his elder brother.
So you were married earlier?
No, Your Lordship. Your Lordship, to my shock, utter shock, the petitioner had filed a petition of nullity in the trial, before the trial court, where he has produced a copy of petition of maintenance, Your Lordship. And
Okay, we will consider.
It is a certified.
And
copy,
Acha,
Lordship,
we
page
consider,
33.
we will consider an interim after she files her wakalat because she actually cannot appear today.
Cannot appear.
Yeah,
Lordship,
I
for a
have
moment,
filed the
Lordship
wakalat
comes to
number.
page 33. I have annexed the certified copy of the petition which he had filed. The page 32, page 33, her name is shown, page 33. Her Naziha Shabnam, and name and address of the second party is Mamul Ali, and name of witness, serial number 2, Muhammad Ashraf Ali. Muhammad Ashraf Ali is the father of the respondent, Lordship. And the original certified copy, that Lordship will find at page 36. Is an SMS, Lordship.
Yes.
Her name is shown as Najia Shabnam. She is the respondent. And
Sami Mamul Ali.
Mamul Ali is the first husband.
Huh?
First husband.
First husband, not you.
This is the certified copy, which I have obtained from the CGM court Golaghat. And here, under the column Hakki Nam, Abedon Kari, Najia Shabnam, Mohammad Ashraf Ali. Ashraf Ali is the father of this respondent, Lordship.
So what do you want to show from here?
She suppressed her earlier marriage, Lordship.
Lordship, she was not married earlier.
That marriage which was solemnized with me, Lordship, that was obtained under fraud and coercion, Lordship.
Later on, you came to know that she had a previous husband.
Yes, Your Lordship.
Mamul Ali.
Yes.
And what is your name?
My name is Shahid Alam.
Shahid Alam.
Yes. And
here this is what? Page number 33 is what application?
Is the maintenance petition which she has filed against her earlier husband.
Oh, 125 you
Yes.
said. Okay, heard Mr.
A. Ganguly.
A. Ganguly, learned counsel for the petitioner. And Miss
S. Jed Hayat.
S.
Jed Hayat.
S. Jed Hayat for respondent number 2. Or what? Sole respondent
Yes, ma'am.
for respondent number 2.
2.
And Miss S. H. Bora, learned APP for respondent number 1. Miss S. Jed Hayat submits that she came to know about the case and she has appeared, but she is yet to file her wakalat nama.
Ma'am, I have filed my wakalat number. After that, I haven't.
Acha, you filed a wakalat?
Recent.
Okay, fine. No, don't write. This is an application. Filed under section 528 of BNSS 2023. For quashing of the proceedings in connection with. Oh, this is an application filed by the petitioner, yeah. Filed by the petitioner under so and so for quashing of the quashing of the proceeding in connection with Miss MISC dot DV case number 26 of 2026, registered under section 12 of the Protection of Women from Domestic Violence Act 2005, which is presently pending before the learned subdivisional judicial magistrate Golaghat. The case of the petitioner is that he was married on petitioner is that although he was married to the respondent number 2, but he had not cohabited, but he did not stay together. But he did not stay together with his wife even one single day. Full stop. The petitioner submits that the respondent number 2 submits that he came to know that respondent number 2 was earlier married to one Mamul Ali, and that the marriage with him was done through coercion and what do you say? Fraud. Full stop. He submits that under the Domestic Violence Act, an application can be filed only when the aggrieved party has shared a household with the spouse.
Within the meaning of domestic relation.
Within the meaning of domestic relation and given under section
2F.
2F of the said act. He submits that they have never stayed together And as such, there was no domestic relation between petitioner and the respondent number 2. And in that view of the matter, the domestic violence case cannot stand. Full stop.
Nullity petition.
Yes. He also submits
Page 63.
that the said case under the Domestic Violence Act was instituted after he had filed an application for nullity of marriage before the court of
Learned District Judge Golaghat, page 63.
Okay, Learned District Judge Golaghat. Miss S.J. Hayat, Learned Counsel, appears for respondent number 2. Although no notice, before any notice was given to her, as she had come to know about the case and she appeared. However, extra copies be given to her within a period of 2 days. Miss Counsel, appearing for respondent number 2, further prays that she be allowed some time to file her affidavit in objection. Prayer is allowed. List this matter on 23rd of September 2026. In the facts and circumstances of the case, this court deems it fit to stay the further proceeding of the CR case number.
DV.
Yes, DV case number
Please DV case.
26 of 2026 till the next date of listing. List accordingly.
Means DV case number.
Uh-huh.
Means DV.
Miss within bracket DV case number
26/26 pending in the court of SDJM Golaghat.
pending in the court of SDJM
I'm
Golaghat.
obliged.
Hello.
It's a criminal petition, my lord. More or less, my lord, it's a mercy petition, my lord. I have default in appearing before the court since 22, my lord.
NBW.
NBW, my lord, that may be recalled, I will appear, my lord. I have narrated my grounds, my lord, at page 6.
Okay. Heard Mr. N.J. Doctor, Learned Counsel for the petitioner, and Ms. S.H. Bora, Learned APP for the state. By this application, the petitioner has prayed for quashing of the orders dated 24/3/2022
And subsequent orders.
and all other subsequent orders in connection with Sessions case number 69 of 2016, arising out of Kokrajhar PS case number 155 of 2014, registered under section 366 within bracket capital A of IPC, which is pending in the court of Session Judge Kokrajhar. Full stop. The Learned Counsel for the petitioner submits that the charge sheet in connection with the said case was submitted on
1710.
17/10/2014, and the case was instituted before the trial court.
The section should be.
Full stop. Trial court, full stop. Here, the Learned Counsel submits that initially he appeared, right?
Yes, my lord. Initially I appeared, my lord. Thereafter, my lord, I couldn't appear.
What is your name?
Mine.
Azadul.
Yes, my lord.
Azadul Islam. Absent without steps. Absent.
And one of the co-accused, my lord, died during the.
Acha. Azadul absent without steps. Okay. The NJ Doctor, Learned Counsel submits that initially the petitioner appeared before the trial court, but later on, due to some genuine reasons, he could not appear before the same. And as such, by order dated 24/3/2022, NBWA was issued against the petitioner and others, and other accused persons.
Now page 26.
25/11/24. Then
Page number 26, madam. Last page, annexure 5, madam.
Fix.
11/09/20.
Hmm.
The other person died, madam. Case is
He
abated.
further submits that that by order dated 11/9/2024, it was reflected that who died? Oh yes, one of the accused person had died, and the case against the same was abated. And as far as the petitioner is concerned, NBW was again issued, and notice was issued to the bailer. However, Mr. Learned Counsel for the petitioner submits that the petitioner would appear before the trial court without any fail, and other accused persons, including the petitioner, would be present. And as such, by order dated 11/9/2024, it was submitted that the petitioner appear before the trial court without any fail. And other accused persons, including the petitioner, would be present. And as such, by order dated 11/9/2024, it was submitted that the petitioner appear before the trial court without any fail. Full stop. In the interest of justice, this court therefore directs the petitioner to appear. Oh, Mr. and Miss S.H. Vora, learned counsel for the state, however, submits that the petitioner had not appeared before the trial court, neither he had taken any steps on his behalf. And as such, the trial court had rightly issued NBWA against the petitioner. On consideration of the submissions made by the learned counsels, more so in view of the fact that the petitioner petitioner has more so in view of these facts and in view of the submissions made by the learned counsels, it is as such directed that the petitioner should appear before the trial court within a period of 7 days from the date of the order and would appear before the said court on each and every date without fail. Full stop. Till the petitioner appears before the trial court, the order of NBWA issued against the petitioner by various orders are kept in abeyance.
And the next date is fixed on 8/9.
It is further submitted that the next date of the instant case is fixed on
8/9.
8/9/2024. And on the said date, the petitioner should positively appear before the trial court. However, if the petitioner does not appear within the time stipulated, the order by which NBWA was issued will get revived. Petition is disposed of.
Fine, I'm of this.
State petition.
My lordship, kindly peruse the last order. Scanned copies were called for.
Last order.
Last order, 17/8, ma'am.
What happened? Copies
Scanned
have not
copies
come.
Not come, my lords. And my lords, the magistrate has passed, again, he's asking for certified copies of stay orders.
Huh? Certified copies.
Yes, my lord, kindly peruse the orders. Today he has passed an order.
What happened? This is an petition for what?
My lord, for quashing a Zimma petition, my lord. Zimma order passed by
Oh.
CJM. My lord, kindly see the order, tone and tenor of the order, my lord.
25/8.
Yes, my lords. Matters fixed on 24th, it didn't reach the, it didn't got listed. I mentioned before this honorable court, then today it has come to list. It's passing this kind of orders.
I'm not getting it. What? Certified copy of the order dated 17/8 passed by the Gauhati High Court.
That has been given, that has been given, since it's that.
No, what happened? The Jimma was given to the
Zimma was
owner.
given, we assailed that Zimma before this court stayed that order.
Before which court?
My lord's court 9, that they took it.
No, before the High Court.
Yes, High Court.
You have challenged the Jimma
Yes,
order.
yes, exactly.
And the court had stayed.
Yes, madam. Had stayed and asked for the scanned copies. It has not come. But the learned magistrate, what he's doing, my lord, in spite of his knowledge that 24 it is fixed, he fixes this matter on 25th before his court and passes this kind of orders.
Oh, it is on 25th. Okay.
Yes, my lord.
On perusal, I appears that the order by this court regarding interim Jimma was stayed till
Yes.
24th.
Now again, he's asking for.
And the same has been complied with. Since the period of the stay of order dated 17/8/2026 has expired yesterday, the IO is hereby directed to submit a certified copy of the passed by the Honorable High Court on or before the next date. Acha, so what the trial court thought is that yesterday it was
Over.
on 24th that stay order goes. And then has expired yesterday and the IO is directed to submit the certified copy of subsequent orders.
My lord.
So what happened on 24th? She wanted that.
Yes, my lord. 24, the matter was not listed somehow, unfortunately. So I made a mention before your lordship. And that day, lordship had to, didn't sit on that day, one particular it was fixed. So it is fixed today.
Oh, 26th I did not sit.
Yes, madam.
So 26th what happened?
26th, lordship, we didn't.
Deferred.
Deferred. Since
And
I
then-
had prayed before, particularly before lordship to
It's
take up the.
okay, now what? Now
So
the
now, my lord, call for the scan copies, we again call for, my lord. Because prima facie, my lords, we have a case.
till next date.
Yes.
Okay. Heard Mr. D. Gogoi, learned special public prosecutor, Wildlife Assam, appearing for the petitioner. Appearing for
the state of Assam, my
for the petitioners.
One-
State of Assam and special public prosecutor. For the petitioners. Notice not issued, right?
Not.
By the last order dated 17/8/2026, the case record of what is this?
SIVWLO.
What this is a case number?
Yes, my lord.
SIV capital letter, huh? SIV dash WLO wildlife. O stands for what? Dash 01
It's gas, man.
dash 01 of 2026 dash 2027. It was called in connection, no, of the said case from the court of Chief Judicial Magistrate Sibsagar. There is an office note showing that case has been received by the dealing assistant okay, for which scan call for immediately after receipt. Same is, however, the office note dated 24/8/2026 reflects that the same has been called, but and the case has been received by the dealing assistant of Sibsagar. It was received by the dealing assistant in the morning of 24/8/2026, and the scan copies are being prepared, and the same is awaited for its receipt before this court. Notice has to be issued, I think.
Not issued, my lord. Not issued.
Notice should be issued.
Notice can be issued.
Issue notice upon respondent number 2. Petitioner to take steps upon the sole respondent. Petitioner to take steps for issuance of notice upon the sole respondent by speed post or with AD or by usual process, or with service or with the receipt of the reminder, I think, because already they are
Already
in
is in process.
or with receipt of the scan copy of the trial court records. List this matter after 2 weeks on a date to be fixed by the registry.
Interim to continue. That order stays, my lord.
Interim what?
My lord, there's an order. Interim is there, my lord. The orders dated.
Oh, state.
Yes.
Interim order passed by order dated 17/8/2026 be extended till the next returnable date. That till the next returnable creates problems, actually.
Then my lord, it will be improper also. Or lordship can make it until further orders, if lordship desires so. Otherwise, again, there will be trouble.
Again, it will not be listed until further orders.
My lord.
Yes, Mr. Devan.
Lordship, is a petition for quashing of FIR, Your Lordship. So, Lordship, allegation against me is that, Your Lordship, that in the name of providing.
Only FIR quashing,
Lordship.
no charge sheet.
Not charge sheet, FIR quashing, Your Lordship. So, allegation against me is that in the name of providing job, Your Lordship, I took.
Where is the FIR?
FIR is a page, Your Lordship. A translated version is page 11, Your Lordship.
Okay.
Page 11.
Mr. Borua, how many case diaries are there?
There are around 6, my lord.
From 3:30, I'll take up those bail matters. And there is one matter of Mr. Chaudhary. Yesterday's matter, right? What happened to yesterday's matter? Okay, fine. I thought I fixed this matter today. Okay, from 3:30, I'll take up bail matters. And after that, again, if time permits, I'll take criminal petitions, okay?
Like yesterday, my lord.
Like yesterday, because these are motions, I cannot leave it also.
My lord.
And further, the case diaries will have to be again retained.
But then lordship might also do one thing, my lord. Only the case diary matters lordship can take up, my lord.
Only
The
case
other
diaries
things, my lord,
matters.
other matters lordship can, my lord, subject to my learned friends, my lord.
Yes. Other matters, we will fix a date.
Yes, ma'am.
You give the item numbers where case diaries are not there. Miss Bora can do it. And then in those cases, date will be fixed. Only bail case diaries matter. Okay. Yes, Mr. Devan.
So, my lord, the vernacular is page 15, Your
Okay,
Lordship.
I'll read it. Wait.
And
Regarding
English version is Your Lordship. From page 11.
What is your name? Dhanjit Talukdar.
Dhanjit Talukdar.
He is the accused.
Yes, your lordship, he's the sole.
Okay, I'll read the FIR with.
Yes,
With due respect, I beg to state that in the month of January, Dhanjit had the promise to provide me a job in the institute. He got from India and also took for him in personal account address. He took it easily. He made an whenever I asked for the money, he pretends me. Time of me taking the money where I should check the security. So how can this FIR be quashed? What is your ground?
So my response submission before lordship is that case is otherwise lordship. Totally a manufactured case in lordship.
That will be seen, dear.
Lordship, the respondent he's a money lender, your lordship. So because of my personal necessity, your lordship, I had taken your lordship 4 lakhs of rupees with 5% interest, your lordships. And also, your lordship, I have repaid your lordship. In the very
But that is totally a different story. That will come in at the later stage.
But the thing is that your lordship, even your lordship as a security, he has taken 2 checks from me, your lordship. So if any realization is to be made, your lordship, there is a civil liability, your lordship. The criminal liability doesn't fall within the purview.
No, there is a cheating. There is a see.
whether
Had
there
it
is-
been a normal giving and taking money is different. Here he had promised to give a job to him, and he had failed, and he had neither returned the money.
So as per the information, your lordship, derived, your lordship, this is the allegation, your lordship.
Yes,
Is
but
that-
then I am only with these allegations made in the FIR. Right. I have to see the prima facie whether this FIR makes out a case. This makes out a case under 420.
So your lordship,
But whatever other case you have, that
Lordship,
it's
lordship.
a concocted one, you place it during framing of charge, you place it, maybe charge sheet can also be, I mean, investigation is on. The charge sheet is yet to come, may not be. It can be a final report also. But prima facie, it shows.
Prima facie, your lordship, there is a because allegation is giving the job, your lordship. So prima facie, there is a case, your lordship. But I'm not restricted to that part, your lordship. So
हाँ नहीं गुस्सा आ गया मुझे हाँ yes
so prima facie, your lordship. So far, your lordship, the prima facie, there is an initial deception, your lordship. If there is a question of providing job in lieu of money, your lordship. So there is a prima facie, your lordship. That is, it is after perusal of the your lordship, after it has come to the fore, your lordship.
yes sir.
But I am on your lordship, the second part, your lordship. So
security check.
a security check, he has taken the security check, your lordship.
That is security check and some
also,
documents,
lordship,
two
2
signed
lakhs-
documents.
2,50,000 thousand of rupees. I have stated para 4, your lordship. I have returned back through bank transaction, your lordship.
Where is that?
Para 4, your lordship, of my petition.
No, this will not. The quashing of FIR, you see, what is the, what is the guideline? What has this 92 Supreme Court decision has said, Bhajanlal? If it does not make out prima facie a case, a cognizable case, then it will be quashed. Otherwise, it will not. No. This is either you withdraw or I'm dismissing.
Lordship, it is after recital of the your lordship, the FIR, prima facie there is a case.
So that is all I have to
Prima
see.
facie there is a case.
You think yourself in my position, then you'll find.
But he has taken my submission before your lordship is that prima facie he made out the case in the FIR. But he has taken the recourse to your lordship this what is the actual fact? Actual fact is otherwise.
That police will investigate. He will get the witnesses. Maybe your fact will be established. And then no charge sheet. Why are you apprehending? What do you say, Mr. Borua?
Later notice.
If the FIR discloses
No,
commission of
this-
cognizable offense, my lord, that cannot take place. From Bhajanlal, the Niyari ka
Settled position.
settled law, my lord.
You either withdraw or I'll dismiss. I'll pass order.
Liberty.
Mr. A.A. Devan, heard Mr. A.A. Devan, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. Mr. Devan submits that he has instructions to withdraw the matter with the liberty to file afresh if required. Prayer is allowed. Matter is closed as withdrawn.
Apply.
Ako tenole purjonto. Ki tenole guisa ako. Yes.
Yes, Lordship, I have inquired from senior counsel, Mr. P. Kotogi Pallapudi, sir. He says, Lordship, he is not representing he is only representing the CM vigilance, not the Lordship,
Acha.
vigilance and anti-corruption.
Okay, you try to contact. We will take it up next week.
Next week, maybe.
Okay. As prayed for by learned counsel for the petitioner, Mr. A. Ahmed, list this matter on
my lord.
on 9th of September. Next week, there are only 2 days.
Next week, I will approach the registry after serving the copy.
3rd of September, 2026.
Item 32 and 33 of that. Where in this list, I have made mention in the morning hour because there is no stay order in the present case.
Admission. Motion to ignore. Let me take it up after motions. What happened? Okay, I'll take it up after motion. Or 3:30. No, let me take up the bail matters first. Why do you want, what is the urgency in taking up this matter?
There is no stay order in the case, Lordship, and trial is proceeding. That may, Lordship, prejudice me because of that. Here, Lordship, initially the wife filed a application, one FIR alleging 376 against me. Then, Lordship, husband filed a FIR against her for adultery. Then again, she filed one FIR against husband and me, saying that we.
Husband and me? You are for the husband. What?
No, I am for the other accused person, Lordship.
Ah.
So again, she filed one FIR that present petitioner along with the husband has Lordship that compel her to indulge in sexual activity.
Oh.
So these 3 FIRs are there. Lordship knows that when that malicious act is there, then apart from the FIR, other circumstance can also be seen in the while passing the FIR.
So it is for quashing of the FIR.
Of the FIR.
All the 3 FIRs. Well, how many FIRs?
2 FIRs.
2 FIRs. Against you.
Initially, her version was that I have committed rape upon her. Secondly, she says that in collaboration with her husband, I have committed rape on her. So this fact shows that there is nothing. So therefore, I was praying that this may need some time for final hearing. That in the meantime, some protection will be given by staying the proceeding. So informant side is also there. So
but then you should have prayed that on the very first day itself. So many times.
Record was told.
Let the informant appear, my lord.
Informant already appeared. Informant already appeared.
So,
secondly, my lord, we have not been able to go to the TCR, my lord. What is there in the TCR, my lord?
TCR has been called. It's here.
lord,
Yes, scant is here.
Scan is here, there, my lord.
There is no urgency as such. Okay, investigation is going on.
No, the trial is going on.
Trial is going
Oh, charge sheet submitted.
Charge sheet submitted. So
Trial is going on.
yes. If evidences are recorded, then
Charge framing done.
charge framing done. So that is the DP.
So, okay, we will finally dispose it off. What stay now? Stay of the proceedings.
Today also I am ready for final year, but time will not.
Time is not, time is very short. And he has to go through the TCR.
TCR, and secondly, my lord, the opposite party also is required to be heard, my lord.
Mr. A, her,
Already appeared. I have informed them.
we will hear it next week. We will hear it on 9th of September for final disposal. Heard Mr. A. Ahmed, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. Although the name of the learned counsel appearing for respondent number 2 is shown in the cause list, but he has not appeared when the matter is taken up today. On the prayer made by the counsel, it's okay. On the prayer made by the learned counsels for the parties, list this matter on 9th of September, on which date an endeavor will be made to dispose of the matter. No, the bail hearing. Item 40. What about 38, 39? Okay. 40. Yes.
Please, your lordship, assignation another court.
This is the problem, like, no, the advocates cannot come, I think.
My request is.
Tell your senior to come after some time, okay? But tell him to come soon.
Lordship, regarding 41, Lordship, is a charge sheeted case, Lordship, TCR may be called for, otherwise that's.
41.
Yes, Lordship, it is a charge sheeted case.
Okay, charge sheeted case. So TCR is not here.
Yes, Lordship.
It was one of fixed for case diary, my lord, but we have been informed that statute has been submitted in this.
So case diary has not come. TCR will have to be called.
Yes.
Jason 41 too. Heard Mr. Beach of 41 not likhiba. Heard Mr. B. Chaudhary, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. This is POXO.
Initially, POXO was not there, Lordship, in the FIR as well as in the forwarding report. POXO was not there, but the format, Lordship, they said 4 is added, Lordship. Last time I have submitted.
So is there.
No notice may be issued, madam.
Notice was issued.
Issued.
Notice had gone and notice was given to your office also.
Yes.
My lord,
You get the instructions, okay? Okay, then say the learned counsels at the bar. Learned counsels appearing for both the parties have stated that charge sheet has been submitted in the instant case. As such, this court directs that TCR be called for from the the scan copy of the TCR be called for from the learned court of.
From special judge.
No, TCR be called for from the concerned court in connection with. You know the PRC case number or
GR
something?
case number is there.
In connection with
606
GR case number 606 of 2026. But which court? Any idea?
It's a POXO, since POXO is the.
Special judge?
Special judge Bipuria, my lord.
From the court of concerned court within bracket dear special judge Bipuria.
So it's a Lokhinpur because the certified copy was issued by the district and session judge Lokhinpur.
Yes.
Okay.
Special judge.
Special judge Lokhinpur.
Special judge Lokhimpur Kora. Full stop. Further, the notice has been issued upon respondent number 2. And as such, Mr. Borua is directed to get the instruction as to whether the service upon respondent number 2 is complete or not. List this matter after 2 weeks on a date to be fixed by the registry.
I think date can be fixed, otherwise it will.
Now, as well, this TCR has to come. List this matter on 17th of September.
I leave.
The councils na hai. Tamne ye buje khwana had a calculation koriye sir. Okay, after some time, whoever is there, we will take it up. You are for the respondent.
Informant for the informant.
Informant, yes. Let Mr. Chumua come. 43. Yes, Mr. Ali. Case diary is there.
Case diary is same, my lord.
Show me the FIR.
FIR, my lord, page number 10.
Yes, wait, I'll read it.
Some electrical goods has been.
Anwar Hussain.
Lordship. Electrical goods has been stolen by some unknown person. The FIR has been registered under section 303 for which punishment up to 3 years.
So how are you in the picture?
Well, I have been arrested on suspectively, my lord. The stolen article has been recovered from other person, my lord, page number 15.
It was not recovered from you.
No. From page number 15, my lord. From one MS Sunny Light Mundia Patar. And the owner of this Sunny Light, my lord, in the bottom, Azhar, in the bottom of the page number 15. The name and signature of the person from whom produced. MS Sunny Light, Village Mundia Patar, property.
So the theft had taken place on your instruction.
Yeah, this is the allegation, my lord.
It is in the charge
Yeah,
sheet.
but this is the, my lord, perhaps, my lord, the materials collected during the investigation, my lord. Thefts committed as per his instructions, my lord, and it was recovered from one Azhar Ali's house, my lord, But that Azhar Ali is yet to be apprehended, my lord. He's at
And 44 days today.
Any independent witness saying that it was
This is also my lord, implicated, my lord.
uh-huh.
Independent witness is also implicated, my lord.
And other accused person have said that he instructed them.
No, not other accused person, independent. The other accused person, Azhar Ali, he is yet to be arrested, my lord. Other witnesses, my lord, implicated as per his direction, my lord. The theft was committed, my lord.
Witnesses, how can they say that?
No, because, my lord, while my lord, carrying the, my lord, stolen goods, my lord, they were engaged, my lord. They said that this Azhar Ali has asked them to, my lord, collect the materials from this person, my lord, possession.
From Anwar Hussain.
Anwar. That is the, my lord, materials perhaps in the case diary.
They were carrying the stolen articles.
They do not know, my lord, it is a stolen or not, my lord.
And they were said what? Azhar Ali?
They have said that Azhar Ali has instructed them to, my lord, to take the materials, my lord, from Anwar Hussain. Anwar Hussain, my lord. It is his position, my lord.
Okay. But in the forwarding report, anything written about Anwar Hussain?
Forwarding report, my lord. Yes.
Okay, heard Mr. Ali. H. A. Ahmed, Learned Counsel for the petitioner, and Mr. R.J. Borua, Learned APP for the state. By this application, the petitioner has prayed for bail in connection with Borpeta PS case number 257 of 2026, registered under section 303 within bracket 2 of BNS 2023. The FIR in connection with which the petitioner was arrested was lodged on 10/7/2026 by 10/7/2026, by which it was inter alia stated that on 9th of July 2026, certain items were stolen from the factory premises of the informant. And that the items were stolen from the backside of the factory premises through the paddy fields. Full stop. The learned counsel for the petitioner submits that the name of the petitioner did not find place in the FIR and that during the investigation, the petitioner was arrested on the ground that he was the one who had instructed others to steal and to carry. Full stop. However, he submits that the petitioner was not connected with the offense of stealing from the informant's factory premises. Full stop. Mr. R.J. Borua, on perusal of the case diary, submits that there are independent witnesses who have stated that other co-accused who is yet to be arrested had instructed them to get the materials from the petitioner, and that the said witnesses has got the materials from the petitioner. On consideration of the submissions made by the learned counsels, more so in view of the fact that no incriminating materials was stated against the petitioner in the forwarding report, nor his name was there in the FIR, neither. And also due to the fact that the independent witnesses independent witness, if this court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of so and so, under petition is disposed of.
Almost 40 days behind the bar, Lordship.
Only on incarceration.
40, almost 40 days, Lordship.
What is the offense?
Offense, Lordship, wife committed suicide.
Wife. Show me the FIR.
8 years of marriage, Lordship. Earlier, nothing.
It was a 1 second. It was like neither in the case diary.
Lordship, FIR is at page number 10.
Acha, I'll read it myself, wait.
Yes, Lordship, more than 8 years of marriage, Lordship, earlier there was nothing. No FIR, no complaint against the husband.
Okay. Unusual circumstances. How
Lordship,
did?
Lordship, here, Lordship, only one sentence goes against him. Unusual circumstances, I hereby want to lodge this FIR.
As I have
So and so,
suspicion.
as I have suspicion of.
Yes, I've seen that.
Even he didn't say that earlier her daughter has complained, made a complaint at the house. That much was 40, almost 40 days behind the bar. There is a minor daughter, 4 years and 6 months. Lordship, mother committed suicide, father is in there is a psychological effect upon the girl child, Lordship.
Acha, what is there in the CD, Eri? Yes.
Lordship, case diary received, but along with the postmortem report, but that is not completed because of viscera report is still.
Acha, what does postmortem report say?
If cause of death could not be ascertained because of the viscera report, Lordship.
Send me that report.
Yes.
And what about other witnesses? Anybody else? Quarrel, something?
Lordship,
No.
prior to the occurrence, there are some quarrels among them.
That will happen in nature also.
Husband
Okay.
and wife, Lordship, sometimes there is a clash, Lordship.
Not sometimes. Everyone will face that.
Even at our houses also, Lordship.
Yes. Those who does not quarrel, they are not also proper husband and wife. Acha, where is that? Postmortem, this is the one.
If
Yes.
there is no quarrel.
But
they
whatever
are not
life
very-
has gone, Lordship,
So,
so subjected to reality, both physically and mentally. So,
anything there?
yes, Lordship.
No mark injury, no mark liable, likely to be injury. No mark. Fraught scene.
Yes, fraughting is there.
Scene. The knot is towards the left side of the neck.
Yes.
To ascertain abrasion seen in the chest.
Yes.
No mark likely to be injury. Due seen in the chest region. Chest, there is some injuries,
Yes,
right?
there are some injuries.
No such observation seen. Excessive frothing seen. Inquest converted at so and so. This is not a postmortem report.
That is a postmortem report that is not conclusive because of
No,
this.
it is written the actual cause of death to be ascertained after postmortem. So where is that post? This is not,
That is
I
that
don't
is
know.
because of this is postmortem report.
This is inquest.
No, Lordship, kindly go through there's a that is awaited perhaps. There's a postmortem report.
No, then you have not given me the right
Lordship,
thing.
let me check.
This is inquest.
Inquest is there. PM is perhaps not there, Lordship.
This is postmortem.
Yes,
Next
postmortem
one.
report is there, but that is not completed
Okay.
because of the viscera reports that is awaited. Demand is not.
Wait, informative.
Why to hold on a demand of dowry as
Chest, there is burn in the chest.
how it
Epidermal burn of 18 centimeter.
Yes, he has been pushed, I think.
Acha. An oblique non-continuous ligature mark of size is present.
Yes.
Non-continuous above at the level of thyroid. Non-continuity being the position of the knot. Externally,
In
the
her wrist
ligature mark
also
is
she
dry.
has abrasion is there.
I think it is a suicide case. Internally, the hyoid bone and thyroid neck tissues are found to be healthy, but in suicide cases, hyoid bone is.
She has got injury on her chest, Lordship.
Chest, there is epidermal burn.
Yes, how it comes, Lordship?
Lordship, if I may.
But not much, 10 centimeter. 10 centimeter will be how much? This much.
It's quite big.
10 centimeter, 18 centimeter. But
That's a big
that had not
portion,
led
Lord.
to her death.
Lordship, if I may.
But before the incident, there was a quarrel between the two persons.
Okay.
As
108 is what abatement.
Yes. Abatement of society.
Lordship,
My
if I may,
lordship is
Lordship.
appearing for the.
I am for the informant, Lordship.
Mm.
Lordship, there are some facts because the FIR was filed in the hurry on the same day, and the father has filed the FIR, so he could not give in detail. First of all, Lordship, the deceased lady was pregnant, Lordship. There were many demands of dowry from before, and the husband always used to complain against the wife, saying that you gave me a girl child instead of a boy child. That is happening from before. We have given statements also to the police. Lordship, now without that, she was pregnant, and somehow he came to know that the child in the stomach was a girl child. So Lordship, so my prayer is that postmortem report also on the last page, the opinion of the
But
toxic.
in the postmortem report, nothing that she was carrying pregnancy?
Lordship, they have sent the, it is written, they have sent the uterus for the forensic, Lordship, on the page number 4, Lordship, page 2, point number 2.
Page number 2 of the postmortem report.
Lordship, page number 4 of the postmortem report. 4.
Lordship, may I submit one thing?
One second. Where?
Lordship, point 2, whole uterus has been preserved. 10% formal saline solution sent to the Department of Pathology, GMCH, for histopathological examination.
Postmortem, that will be clear from the postmortem only.
On the page 5, Lordship, final opinion as to the cause of death.
That too she has
Lordship.
shown.
Lordship.
Chemical whether there was any poison and all.
Lordship.
But she was pregnant is not given in the postmortem.
Final, if the final postmortem report may be awaited, that is my prayer. If it
Final FSL report.
Lordship, FSL.
FSL report will be at best poison and all.
Investigation is still going on. Lordship, only for.
And the allegation is abatement.
Yes.
Abatement, there has to be proper abatement.
There has to be some intentional, the prior conduct of the petitioner that has to be taken into consideration.
And abatement is not just saying.
She has taken out
There are
the-
injury marks on the body, Lordship.
On different parts, he has
No,
sustained.
there is only chest injury.
Yes.
And Lordship, in the
wrist also.
wrist also, Lordship. Lordship, also regarding the facts, if it is not on record, if I may submit, Lordship, what had happened that when they received, the door was in the house, the husband was there, wife was there, deceased wife, and 4.5-year-old daughter was there in the house, and the door was locked from inside. Later on, they had to call the landlady and open the door, get the door broken, and they were inside in that condition for so long, and the husband never tried.
Inside.
Lordship?
Accused was also
Yes,
inside.
Lordship, they was inside.
Lordship, what he has submitted before this honorable court, is it on oath, Lordship? Is it on oath? He is submitting verbally, Lordship.
It is my
there
submission.
any submission made on oath?
Okay. Heard learned counsel Mr. G. Chamua for the petitioner and Miss S.H. Bora, learned APP for the state, and Mr.
K. Jain, Lordship.
K. Jain, learned counsel for the informant. By this application, the petitioner has prayed for bail in connection with Polton Bazar PS case number 196 of 2026, registered under section 108 of BNS 2023. The FIR in connection with which the petitioner was arrested was lodged by the father of the deceased, stating inter alia, father of the deceased on 27/2026, and stating inter alia that his daughter was married to the petitioner on 19/2/2018, and that the petitioner and his daughter and his wife and their small daughter and their minor daughter was staying in a residential complex at Gauhati. Full stop. He further submits that he received the information on 19/7/2026 that his daughter had died in unusual circumstances. Full stop. The learned counsel for the petitioner submits that in the FIR itself, the informant had stated that he had suspicion that the petitioner was responsible for the death of his daughter. He further submits that the petitioner has been inside the jail for
39 days.
39 days.
for 39
been
days,
Has
and that the investigation and that custodial interrogation is not required. Full stop. Miss S.H. Bora, learned APP for the state, submits that The postmortem report of the deceased shows that the deceased died due to suicide, although the final report was kept pending till the report of the FSL is received.
My objection may be recorded.
She also submits that there are independent witnesses who have heard the quarrel that had taken place between the petitioner and the deceased person before the occurrence. She as such objects to the bail to be granted to the petitioner. Mr. Jain, learned counsel for the victim, for the informant, stated that the instant FIR has been lodged by the father in a hurried manner, and that the story behind the death of the deceased was something different. He submits that he submits that the deceased was pregnant, and upon knowing that she was bearing a girl child, the petitioner has pressurized, has quarreled with her to such an extent that she killed herself. Upon consideration of the submissions made by the learned counsels, more so in view of the fact that the FIR was lodged on suspicion, and also due to the fact to establish a charge under the abatement, establish a charge for abatement under section 108 of the BNSS.
Of BNS.
BNS, the specific particulars resulting in abatement should be there, which is found missing. And on that count, this court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of
CJM Kamrup.
CJM Kamrup under the following condition. Petition is disposed of.
Deeply obliged, my lord.
Oh, charge sheet is submitted?
Yes.
Okay, heard, Mr. You approached the trial court. Heard, Mr. N. Ahmed, learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state. Ms. S.H. Bora submits that the charge sheet was laid in respect of the present case. White charge sheet number?
White charge sheet number 81/2026, dated 27/08/2026.
Okay. As such, the learned counsel appearing for the petitioner submits that he be permitted to move the appropriate application before the concerned court. The prayer is allowed. The matter is closed as withdrawn. Matter is closed as withdrawn. Matter is closed. This bail application is closed. Tumalke anage likha na? Yes.
Lordship, may I please, Lordship, in this case, Lordship, he was arrested on 27/6/2026.
This is item 40.
Item 40, Lordship. And
yes.
as on today, Lordship, he's in custody for 62 days. Lordship.
62.
62 days.
What is the offense?
109, Lordship.
Lordship, FIR will find page 24, vernacular, and translated copy will find, Lordship, page 18.
Translation is okay, right?
Lordship.
What is Saidur Rahman? I submit.
Under section, Kima?
It
238 K. Dowry date, Lordship.
This torture, this dowry, is it a actual fact?
Lordship, it happens, Lordship.
I have not seen personally anywhere. Even in
No,
villages,
in
I have my
villages,
in-laws'
it
place.
happens usually.
Heard that she was tortured for money.
No, no, Lordship, it happens.
It
It's first time
happens.
things happens, Lordship.
Okay, so how did she die?
Lordship, prior to the occurrence, she was subjected to cruelty, Lordship.
No, what does the postmortem report say?
That is awaited, Lordship.
Oh, postmortem report is not there.
That is not there.
We'll have to hear some other, because whether she was killed or
Under
she
what
committed suicide,
yes,
at least.
we have to know that.
Otherwise, what is there keeping it pending?
Independent witnesses.
In the affair,
They said about the demand for dowry, relatives also.
Yes. Other materials.
That case I'll have to reject. Let the postmortem come. Heard Mr. Ayu Chaudhary, learned counsel for the petitioner, and Miss Asej Bora. Miss Asej Bora submits that although she has the case diary, but the postmortem report of the deceased is not present. As such, she makes a prayer that the matter be taken up on a later date and that she can place, so that she can place the postmortem report. Prayer is allowed. List this matter on
9th, Lordship.
9th of September 2026, on which date Ms. Bora will submit the postmortem report along with other documents.
Lordship, CDB retained or
CD, the case diary to be retained till then. So let us take it up on an earlier date.
Lordship, on 5th.
Can you bring the postmortem report?
Lordship, I think usually it comes
From Hujai, Lordship.
7th, ho jaye.
Lordship.
on 9th.
Okay, 9th. Okay. Will CD be retained till then?
Or is it, shall I send back the CD along with the postmortem report, Lordship?
That will again take long.
On 9th, we'll produce, Lordship.
Okay. The postmortem report on the prayer made by the public prosecutor, the postmortem report, the case diary be sent back and be again obtained along with the postmortem report on the next date
Lordship.
and be placed on the next day. Yes, Mr.
Organized,
Poddar?
Lordship,
Hmm.
I am behind the bar for 63 days, Lordship.
Acha.
An FIR which was registered under offense of 64 without any allegation of any rape.
Rape is there.
No, allegation,
What
it
about
was registered under 64, but no
329,
allegation of rape, Lordship.
74, 75, 79?
Those may be at par. If even taken at par, it may be.
What are these offenses?
This is 354 capital, A, maximum
Oh.
punishment 3 years, 5 years.
Touching, watching. Okay.
So Lordship,
Modesty.
on the last date, Lordship, when it was moved, Lordship, it was sent, the Lordship is willing to go to the statement of the victim, Lordship.
Acha.
Yeah.
I have seen this on the last occasion.
Yeah, Lordship. I
Okay.
have referred to the page number 30, Lordship, if Lordship goes to
Page number 30.
30, Lordship. While rejecting
30.
my bail,
30.
30. While rejecting my bail, Lordship,
Acha.
Learned Session Judge has made a specific observation that after the victim in her statement number 183B NSS also stated that accused touched her breast.
Oh, acha, acha.
That is the only allegation.
Accused touched her breast.
Yes, Lordship.
As far as rape, the contents are not there.
Not in FIR. So statement may be there, Lordship. So
Acha, I
I am a
forgot.
police head constable, Lordship.
Huh.
She was a tenant in my house. The
Hmm.
incident, alleged incident, as per FIR, is of 13th of June 2026. FIR was lodged on 26th June, after 13 days.
26 June. Wait, 1 second. I'll just go through this.
14 lot.
Following the
At page 14.
final year of so and so, and residing a tenant in a rented room of Saradev Yadav. Saradev Yadav. At demand. Residing in a tenant in a rented house of which to I informed the wife of Saradev and went to Yes, yes. What is 182?
Madam, Lordship may kindly peruse, my lord, her 183.7. I'm not, my lord, reading in the open court, my lord.
Mr. Borua, have you seen Mr. Dave's WhatsApp status?
My lord, Dev.
A lovely necklace and a lovely so and so from his shop. I was thinking to take it from him free. Is it okay? Lovely necklaces, so many gold ornaments.
My pleasure. I will.
Your shop in Sibsagar? Najira. Okay. 183, right? It's in English.
It's in English.
Same allegation as in the FIR. He's a student, right?
My lord,
Yes.
she is a student, my lord, and only, my lord, only it is not the, my lord, first case, my lord, that she was molested, my lord. There is another student, my lord, whose, my lord, 180 statement also been recorded, my lord. That is in the very next page, my lord. Lordship may kindly say she was also molested in this manner, my lord.
Oh,
Because
she's
he
from
being
Aparna.
the tenant, my lord. But these students, my lord, they are, my lord,
The landlord.
come to pursue study, my lord. And he being the landlord, my lord, he has molested the girls, my lord. And secondly, my lord, my learned friend has submitted, my lord, it is not a case of rape, my lord. Lordship may peruse her statement, my lord, the victim's statement, my lord. It's a clear case of rape which has been defined under section 63, my lord. 63, my lord, 2, my lord. 63B, my lord.
63B.
Yes, my lord.
BNS.
BNS, my lord. At this time, my lordship will only go by the statement of the victim, my lord.
63.
B, my lord.
Inserts to any extent any object or part of a body. He has inserted his
He has used his finger, my lord. He has used his finger, my lord.
no finger into her vagina.
That in the FIR, nothing is there, Lordship.
But
Only
then in
touch.
her in
the
her
FIR,
180
Lordship, it is
and
in
not
the
only,
FIR which was lodged after 13 days.
but in respect of the other girl also, and I
also not
suddenly
made any
tried to
FIR,
kiss
Lordship.
me. My roommate knows. Roommate when I went to the washroom at night, tried to enter. I informed his incident. See, the other girls also have
No,
complained against
They
him.
have not filed any FIR, Lordship. I have
No,
evicted them, Lordship. I have
everyone
a cross
not
FIR was
filed.
there, Lordship. Second part is, I have lodged a cross FIR again, Lordship, them to evict. I have asked them to evict from the
Where is that cross FIR?
page 24, Lordship.
This FIR was lodged by the mother.
My wife, Lordship.
No. Earlier FIR was lodged by mother.
Victim.
Oh, by the victim herself.
After 13 days, Lordship.
No, 30, why it is, my lord, delay, my lord, that has been explained, my lord. Her magnum.
But then here she had stated, no, sexually assaulted me by touching my breast and vagina
Yes.
from inside my clothes.
Yes, Lordship, those are 354 offense, Lordship. I admit that.
No.
It
Touching,
second and part.
touching my breast and
Yes, Lordship.
vagina. So
Touching only is 354.
touching,
Original
no.
policy, Lordship.
You see 63B.
Yes, Lordship.
Inserts any part.
No, inserts any part, there must be something inserting.
But sexual assault, she said.
No, sexual assault, see, defines sexual assault, Lordship. But definition of rape is different and sexual assault is a different one, Lordship.
No. Whatever she said,
Second part, Lordship.
she did not say it so many words. Where is her FIR? You said page 24.
24, Lordship.
When was this? 26/6.
That
Same
I
day.
have lost it, but it was registered on the same day, Lordship. It was earlier one. then my affair was registered.
You have not translated.
That was not given, Lordship.
No, you have not translated the FIR.
No, Lordship. Simply to show that, yes, she was a
Universal
tenant.
council. মই আমাৰ ঘৰত বিভিন্ন
ভাড়া থাকিব ইউনিভাৰ্চিটিত অধ্যয়ন কৰা আছিলে তাই আমাৰ ঘৰত বেআইনীভাৱে বিভিন্ন ধৰণৰ অসামাজিক কাম সংঘটিত কৰি থাকিছিল আনকি আমাৰ ঘৰ ভাড়া ঠিকমতে দিয়া আদায় দি থকা নাছিলে বিদ্যুৎ বিল আদি আদায় দিয়া নাছিলে যোৱা 13/5/26 তাৰিখত মই ঘৰ ভাড়া বিচৰাত আসামীজনী আমাৰ ঘৰত হুলস্থুল আৰু আতংকৰ সৃষ্টি কৰে আৰু যোৱা 16/6 তাৰিখত ৰাতি 8:30 মান বজাত আসামীজনৰ পিতৃ আৰু আন 3জন অচিনাক্ত দুষ্কৃতিকাৰী আমাৰ ঘৰত অনাধিকাৰে প্ৰৱেশ কৰি আমাৰ ঘৰৰ পৰা বিভিন্ন সা সামগ্ৰী ভাঙি বহুত ক্ষতি সাধন কৰে পিছত মোক আৰু মোৰ স্ত্ৰীক বিহাৰী জাতিৰ তুচ্ছ তাচ্ছিল্য কৰি আমাক নানা ধৰণৰ ভয় ভীতি প্ৰদৰ্শন কৰে আৰু এখন সিলিন্ডাৰ
And this was against only the Korobi Busho.
Lordship.
Heard Mr.
Lordship,
Heard Mr.
May I
S.
kindly say, my lord, did the FIR, my lord, also lost on the same day, my lord, when the FIR was by the informant, my lord.
Second part,
Now, my lord, my second submission is that, my lord, there are materials, my lord, that has been collected by the IO, my lord. And there are implicating materials, my lord, by the victim as well, my lord. Because it's applied, my lord, 63B, my lord. Because, my lord, as per her.
But then in her statement of, in her, what is this?
Lordship, I am during my jail due to my cardiac problems, Lordship, I was taken to Uprajar Medical College. Then from jail, I have shifted to Gauhati Medical College, Lordship. That
And
document I
the
have
charge
given
sheet is submitted, no?
So the investigation is pending, my lord.
Okay.
So I have
Heard Mr.
no
S.
objection, my lord, to releasing the accused person on bail at this stage.
I am a police constable, Lordship.
But one
That
thing
is why, my lord, that is why he is being a police constable, my lord.
And
My-
they have already been.
My
they-
strong
they-
objection may be recorded.
They have already vacated my house. They have already vacated my house, Lordship.
Yes, they have already.
Vacated, Lordship. I am ready to cooperate, Lordship. No way.
But
no
I was terrified and shocked when she is of what age? More than
She's in
18?
University.
Okay. So he's,
Right, yeah.
when he realized that I might shout, why didn't she shout instantly? When these things were done?
Definitely,
could
my
have
lord, she is a
shouted.
teenage, my lord, she will scare, my lord.
Doesn't matter, she pays money and then she stays. Okay. Heard Mr. S.K. Poddar, learned counsel for the petitioner, and Mr. R.J. Bora, learned AP for the state. By this application, the petitioner has prayed for bail in connection with Kokrajhar PS case number 96 of 2026, registered under section 329 within bracket 3 /64 within bracket 1 74 75 2 79 of BNS 2023. The FIR in connection with which the petitioner was arrested was lodged on 26/6/2026 by the victim herself, stating inter alia that one night she was stating inter alia that she stayed in a tenanted house owned by the petitioner, and that one night she stayed in her friend's place, and that when on the subsequent night she came back to her rented place, the petitioner rented place, and while she was cooking, the petitioner entered the kitchen and outraged her modesty by touching her hand and by trying to kiss her against her will. Full stop. It is also stated that the petitioner had sexually assaulted her by touching her breast and vagina from inside her clothes. Full stop. She further stated that when the petitioner realized that she will shout, she might shout, the petitioner released his hold. Petitioner had released her. Released from holding her. Full stop. The learned counsel for the petitioner submits that the petitioner had lodged a counter FIR on the same day itself, stating inter alia that
The same day, my lord, when the informant lost the affair, on that day, he also lost this.
Huh. On the same day of lodging of the FIR by the victim.
But not the same day when the incident took place, my lord.
Incident took place when?
On 13th.
13th.
FIR was lodged on 26th.
No, the learned counsel submits that the a counter FIR was lodged by the petitioner, stating inter alia that what exactly? That
She vandalized my house. She used to do
Bring.
improper works during her.
Is stating inter alia that the victim that the alleged victim was committing antisocial work in his place, and that he has damaged that she has damaged his house. Full stop. He also submits that that the victim had stated that the incident had taken place on 13th of June and the FIR was lodged on 26th of June 2026. Full stop. He also submits that the petitioner was inside the jail for
63 days.
63 days and that bail be granted to him. Mr. R.J. Borua, learned APP for the state, submits that the statement of the victim recorded under section 183 of the BNSS clearly shows that she was subjected to sexual harassment as well as rape under section 63 of the BNS. He also has placed reliance on the statement given by another victim who had also stated that the petitioner had harassed her sexually. He as such submits that no bail be granted to the petitioner. Full stop. Upon consideration of the submissions made by the learned counsels for all the parties, more so in view of the fact that the FIR was, that there is considerable delay in lodging the ejahar, as well as there is no attempt on the part of the victim to shout after the incident had taken place, this court deems it fit that petitioner be released on bail, enlarged on bail, on furnishing of a bail bond of rupees 20 with one local to the satisfaction of
CGM Kokrajhar.
CGM Kokrajhar under the following conditions.
Obliged.
Petition is disposed of. A to D, dear. Mr. Borua. 46, yes.
46 and 47 arrest from the same FIR, my lord.
My lord, 46 and 47, we have received the case diary, my lord. My lord, what I beg to submit, my lord, they were on interim, my lord. So the pursuant to the interim protection, my lord, they appeared before the IO, my lord. But what I have found from the case diary, my lord, some more investigation is required, my lord.
Some more?
Some more investigation, my lord. So, my lord, since they let them be on interim, my lord, we'll call for the upload case diary, my lord.
No, their statements are recorded now.
But my lord, the money, my lord, which was alleged to be, my lord, taken by force, my lord, that is yet to be recovered, my lord. So that part of the investigation is still pending, my lord.
It's okay, but that doesn't mean they are anticipatory.
Anticipatory bill, my lord.
But so what are the matters you said? Furqan Ali and
Adil Parvez, my lord.
46 and 47, my lord.
46, 47.
Yes, ma'am.
Furqan Ali, Adil Parvez. Whether their statements are recorded, both of them.
Recorded, my lord, both of them.
They are cooperating, let them be on bail. And the investigation will continue not only in this, so many of things. Okay. Okay. Heard, Mr.
M.A.I. Hussain.
A.I. Hussain.
M.A.I.
M.A.I. Hussain. Learned counsel for the petitioner. Eto heri diba, huh? Item number eto ki? 46. Learned counsel for and Mr. R.J. Borua, learned APP for the state. By this application, the petitioner has prayed for pre-arrest bail in connection with Dispute PS case number 95 of 26, registered under various sections of law. The copy of the FIR, no, not the copy, the FIR in connection with which the petitioner is apprehending arrest. Where is that?
FIR is at my lord, page number 18.
Is apprehending. No, where is the English version?
English from 21.
20
My lord, I go by the
was lodged on 16/2/2026. Before the officer in charge of Dispur police stations, by which the informant has inter alia stated By which it was stated, no, inter alia, that the petitioner is Rahul here.
The 47 is Rahul, my lord.
Adil name is not there.
Adil Parvez is brother of Rahul, my lord.
Brother of Rahul.
Police has been searching for Adil Parvez, that's why I approached for this honorable court, ma'am.
So Adil name is not there in the FIR.
Not in FIR, ma'am.
Stating inter alia that when he reached a homestay, on being asked by one Ajizil of Gwalpara, one boy named Rahul with 4 other boys took him inside a room and took away his mobile and was bitten by 5 persons. Full stop. He also alleged that by taking the password of his mobile phone, they took away an amount of rupees 1,35,000 from his account. Full stop. The learned counsel for the petitioner, however, submits that the name of the petitioner did not find place in the said Ejahar. But police, during investigation, where is that? How is your name figured?
Paragraph.
Is searching for you.
Yes, madam.
Where is that paragraph?
Right.
During the investigation, the police went to his house and he was searching him.
4 and 5, madam.
Searching him, huh?
4 and 5. madam.
Searching him to arrest. As such, the learned counsel submits that the petitioner is apprehending arrest in connection of the said case. Be that full stop. It is Mr. R.J. Borua, learned counsel for the petition. It is also noticed that the petitioner was enlarged on interim pre-arrest bail by order dated 13/3/2026 with one of the condition that the petitioner shall make himself available for interrogation by the investigating officer within a period of 7 days. Full stop. The learned APP for the state, Mr. R.J. Borua, submits that pursuant to the said interim order, the petitioner has appeared before the investigating officer and his statement was recorded. As such, it is seen that the petitioner is cooperating with the investigation and accordingly, this court deems it fit to make the order dated 13/3/2026 absolute with the further condition that the petitioner should comply with all the conditions mentioned in the said interim order. Petition is disposed of. What about this one? Furkan?
Furkan.
Oh, Rahul's name is there.
My lord, Furkan is Rahul. Rahul.
Rahul.
Yes. So here, my lord, I have.
No, it একে type hobo, no. You write, heard Mr. Itu to একে hobo. Is apprehending arrest to একে hobo. In connection of the said ki apprehending arrest was lodged by so and so, by which the informant has alleged that এখানে একে hobo, alleged that when he reached the homestay, কিবা কলো যে the petitioner along with others will deliver. The petitioner along with others took him inside a room and had beaten him up and also snatched his mobile, and also by taking the password of his mobile took away so much of money. He can say so and so. It is baki hineke. He also had appeared before the trial court.
For the IO.
So IO, so and so. Okay, disposed of. Bill, hogal nahi? Bill. Oh, good. Bills are over.
Bail hearings are over. The case that is over.
Okay. Okay. Then. In other matters, date is given, right?
24.
Yes, 24.
Informant and
You have challenged the FIR.
No.
Fact sheet.
Proceedings.
All proceedings.
Lordship, at page 58, from page 58 to 63, Lordship would see that the informant and the accused person was in a deep relationship.
Fifth, acha.
deep
Then-
relationship. Now, accused is a married person, and the girl used to give tuitions to his son. Then they come to a relationship. Then there is a deep relationship from page 58 to 63. Lord, you would see the photos of page 63 also. Now,
Okay, they were in relationship
yeah,
then.
now both families knew about it and came together and came to a settlement that these things will not happen. Then they all parted in 2021. Now, in 2025, suddenly, now this FIR has been filed narrating everything from 2021.
Filed by the girl.
Filed by the girl. We have obtained anticipatory bail, and now we have been called for appearance by the session
Okay,
judge.
sure. FIR is at page 21.
Yes, 21.
Wait, I'll just go through this. With you, I would like to inform
It's
you,
long, isn't it?
Tamal Paul. You are Tamal Paul?
Yes.
Tamal Paul was residing nearby to my house with his family, and due to his persistent vision of a 7-year-old son, at sometime in the year at around 5 a.m. when I was entered by an chased me and suddenly roughly hold me from behind and also touching my body. There was an absolute area and there was a commuter from taking the and taking close again. Long FIR?
Very long affair.
Wait.
Mean basic.
Wait.
Then she was one day admitted to hospital. Lordship. Thereafter,
Wait, 1 second. I'm just fast reading it. And harassing me was under. Not possible for a person to continue sexually harass a girl after years, months. He went to her house. Difficult to believe that story.
My lord, this is my
There
lord.
was a relationship.
Not will.
Maybe, my lord. Maybe they have a relationship, my lord. But why, my lord? Whatever my learned friend has submitted, my lord. It is not that my lord, incident occurred in the year 2021, FIR lost in the year 2024. Why the FIR has been lost in the year 2024? That has been explained by the my lord, informant, my lord. Because 21, this
25.
21, my lord. 21, the first incident took place, my lord. After that, it was continuing, my lord. Then 24, my lord, ultimately she lost this FIR.
25.
24, my lord.
25.
25.
24, 5,
Page number
24, 5, 2025. Now,
page
these
number
pay-
29, my lord. It is
Let him
24,
complete,
5,
huh?
2024, my lord. In the page number 29, my lord.
Vernacular.
Yes.
29. No, 29 is different. Is it? Same.
Yes, this
Yeah, this is the FIR, my lord.
Acha, acha.
We have typed it out. Police, nothing has been. Nothing else.
24, 5, 24.
24.
24, 5, 24.
20. Only 25.
Then? Yes, we are
That,
saying.
my lord, now, my lord, this case is ended in search sheet, my lord. So now they have come, my lord, when they have received the summons, my lord. So let the, my lord, notice be issued at this stage, my lord. Notice be issued and, my lord, scan teacher may be called for, my lord. Because this is a search sheet case, my lord. So we'll have to, my lord, consider this scan on the basis of the materials collected during investigation, my lord.
But one thing I'll just submit. The only section that has been put is 64. Now, this submission would not have been made if from 58 to 63, my senior would have seen that all the messages given by the girl shows that it is completely consensual.
No, it's okay. He's saying that, yes, so maybe it's a relationship. But then now it is too late. I mean, it started from 21. But quashing without looking into the documents, because now charge sheet trial is on. Trial is on.
Trial is, my lord, someone has been issued, my lord. He is not.
Summons has been issued.
Notice maybe, notice go ahead.
And let the notice go, okay?
Chairman.
Heard Mr. B.P. Bora, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. By this application, the petitioner has challenged the FIR dated 24/5/2024, lodged by respondent number
Sorry,
2.
Lordship, that is in effort.
Respondent number 2, which was registered as Margherita Police Station case number 63 of 2025, registered under section 64 of BNS. Full stop. The petitioner has also challenged the subsequent charge sheet submitted on 24/7/2025, as well as the orders passed in PRC case number. What? Case number is not there.
Lordship,
Oh yes, PRC case number 234 of 2025. Full stop. D. Issue notice. Petitioner to take steps for service of notice upon respondent number 2 by speed post with AD and by usual process. Okay, what? Call for the trial, scan copy of the trial court records in connection with the aforesaid case.
may I point out one thing? It is committed to the session court at page 17, Lordship, session
In
case
the
number
interim,
11.
let the further proceeding be stayed.
Let the scan copy call for after that, my lord, without the hearing, without hearing the opposite party, my lord.
Have you made that prayer?
Yes, Lordship. Further proceeding state is page 18, Lordship.
Okay. Yeah, in the above facts and circumstances, no, in the facts and circumstances of the present case, more so, on a prima facie examination of the case, it is found that there was a relationship between the petitioner and respondent number 2, and the relationship had continued since 2021, and in the year 2024, allegations were made against the present petitioner. And in that view of the matter, in the interim, this court finds it fit to stay the further proceeding of PRC case number 234 of 2025 until the next returnable
My lord,
date.
regarding my stay order, my objection may be recorded, my lord. Regarding stay of the proceeding.
এটার আগত দি দিবা তেতিয়াহলে।
It is committed to the session case number 11M 2026.
Corresponding to sessions case number
11M/2026.
11M/2026 pending before
Additional session just FTC 1 Margherita.
additional, our objection to Mr. R.J. Borua had objected to the interim prayer on the ground.
The ground that, my lord, let the issue notice be issued, my lord, it's in the. it is,
On
my
the
lord,
ground that the
such is
same,
case, my lord.
on the ground that the same may be considered on receipt of the trial court records.
My lord.
Yes. Yes, yes, Mr. Viswas, yes. 40? 48. So no, there is no bail hearing. I have finished. There are no case diary in your case. Oh, Mr. Kotoki. Yes. Huh?
And on last occasion, you lost it, assured me that interim will consider that.
Acha, acha. Mr. Lance, interim order is already there.
That is our lack, but there is the interim order.
Wrongly typed.
My God. Oh, let's type question. Amit. Interim order will type question. Interim order nahi. Interim order is not there. Nahi type koi liye. Sob sabo lego. If any likha nahi, interim order passed dale should continue nahi.
So we pray for it.
Did I dictate that? I'll have to see the online. It was not dictated.
Our prayer that interview will consider it, even if the case day doesn't come.
Ah, that I said.
Yes.
Today also third day when it comes.
Amit na lage ar mor logot. Etu moi ebor bhul hojjo nokoro de. Amit koi diba na lage ar. Moi koi dim. So
Today also case there is not before your lordship, my lord.
today also case diary is not there.
2024, my lord. Transaction took place in year 2024. Between a private company and another person.
প্রথমতে লিখি লোৱাচোন, heard Mr. P. Kotoki, learned senior counsel assisted by Mr. S.C. Biswas and Mr. R.J. Borua, learned APP for the state, and Mr. A.S. Chaudhary, learned counsel for the informant. On the earlier occasion, inadvertently, it was stated that there was an interim order and it was directed to continue till the next returnable date. However, there is no interim order and the said stipulation in the order may not be considered at all. Full stop. Yes. So today, what is to be done?
Case diary not safe, so that may be fixed, my lord, for the case diary.
Three occasions, they appeal to. Occasion it does not come, next of time. We have given some protection. If God wants to.
Had though that statement been recorded here, I would have considered. That is not recorded.
They assured us.
Yeah, I know.
The other way it was recorded.
I know, yeah, understand. I had said that. But then it was not reflected in the order.
I understand.
It
No,
was.
Your lordship said I will keep my mind. You brought to assured us.
My lord, may I pray, my lord, let the matter may come up any day, my lord, next week, my lord. On my lord, third, my lord, we'll produce the case diary. If we fail to produce.
No, not third day. Once it was called on 12/8.
Second day.
That was the first day.
Second.
Today is the third day.
Thursday.
Today is the third day. But yes, but
My lord, today is the.
Acha, you
My lord,
place it on
20
second.
On 24th, my lord, CD was called for, then thereafter 28, that is today, my lord, today is the third. And
Third
next day will
day.
be the third day, my lord.
Third. No, do one thing, place it on third, second.
My lord.
15 seconds of protection.
No, we'll produce, my lord, we'll produce the.
No.
Standing after.
No interim protection. On second or third, either I'll reject or I'll allow.
But still that matter.
Huh?
I'm only praying for on to second, my lord.
Then in that case, they will bring the case diary late. You bring it on second.
Yes, my lord. They will not be there in hurry, my lord. They want to. No, we'll produce the case diary, my lord. This is my submission, my lord. We'll produce the.
So and so, full stop. Para. Mr. R.J. Borua is directed to place the case diary on second without fail.
My lord.
And the matter will be considered on that day. And if no case diary is produced on that day, this court will hear the case on merits and dispose of. Okay, on second I'll dispose of. No question of interim.
Item number 59.
Item 59.
59, lordship. Here,
What?
the statutory period is 60 days, lordship. And as on.
Oh, 60 days is over.
No,
Yes.
No, lordship. As on today, 50 days.
50.
50 days.
Another 10 days.
Lordship, may kindly, lordship, forwarding report, lordship, page 15.
Item number
59.
Forwarding report.
Lordship, kindly see, lordship.
What is there?
Page 16.
16?
Lordship, point number, lordship, 3.
Motion equal nahi. My God. What?
Point number 3, lordship. IO collected the CCTV footage of ATM where seen that similar person like Nazrul Islam, petitioner,
Broke the ATM and other 3 co-accused to prevent him from tempering the evidence.
similar person like Nazrul Islam.
Acha, no, that you should have got the bail on the very first day itself. You did not get, let the case diary come. You fix a short date, okay?
Intimation, my lord. I has paid for some time, my lord, to produce the case diary.
But see, today is the 4th day, I think.
Lordship, 4th day, lordship.
One day, my lord, I am just praying for another day, my lord. On 7, my lord, we will produce it.
See, somebody else is, looking like Nazirul is arrested.
Lordship.
Or is arrested.
Lordship.
Okay.
And lordship, page 8.
Heard Mr. Ayu Chaudhary, learned counsel for the petitioner, and Mr. R.J. Borua. Mr. Borua is directed to place the case diary or the next date without any fail. Full stop. Release this matter on 3rd of September.
7, my lord, 7.
Lordship.
7, my lord.
Otherwise, lordship.
See, somebody else is inside the jail.
2 days are holiday.
Somebody else is inside the jail, it seems. Third. Try it on 3rd, please. 3rd on 3rd of September.
Deeply.
Yes.
Here, my lord, the petitioner was arrested in a case, my lord, in the year 2024, my lord.
Defreezing the bank account.
Yes, my lord. Thereafter, his bank account has been freezed, my lord. And the charge sheet has been laid down in this case, my lord. Lords will find The charge sheet, my lord, at page 21 it starts. Lordship, may kindly at page 25, my lord. Relevant portion, my lord. Para 70,
25.
fact disclosed during investigation.
Huh?
Point 17, my lord.
Huh?
Fact disclosed during investigation.
Yes, what happened?
I see Graham put, my lord, in the charge sheet, my lord, there is no mention about the why the account has been freezed or the petitioner, my lord. There is no mention whisper in the
Show me the order from where. What is the order? 26/3/25?
my lord, at page 32, my lord. This is the order of the SDGM M, my lord. May I remember seen petition number 1 file on behalf
It's
of
okay, I'll read it. But it is in the order, it is said that finding sufficient materials,
Nothing
your.
is finding, my lord, may kindly see the charge sheet, not a single whisper is there, my lord, at page 25.
Is it that?
My lordship, may I kindly see one aspect of the matter, my lord. This order passed on 26/3/2025, my lord. Last year, my lord. Then, my lord, charge sheet submitted on, my lord. My lord, 36/2024, my lord.
After filing of the charge sheet, my lord, we approached, my lord.
And now why it is so late?
That is why, my lord, they have come after, my lord, March
They may-
2023.
They may obtain the instruction, my lord, whether
my
by
lord,
freezing.
let us call for.
March 25, and now you have come for defreezing the account.
But since this charged case, my lord, so, my lord, the second teacher will have to be perused, my lord, because there is
may
no
call
role
for,
to
my
play
lord.
by the IO, my lord.
Acha,
IO has
well-
to
They can
complete
obtain
the
the instruction, my
investigation.
lord, whether my.
No,
that is
from whom,
required
my
or
lord,
not.
because IO has no role to play, my lord, after filing of the charge sheet, my
No,
lord.
no, just see from the charge sheet where the freezing of the account has taken place.
At
When?
page 25, nothing has been mentioned, my lord, why his account has been freezed. Not a single ground has been. 17 married, my lord. Page 25, my lord. Page 25, my lord. I see Grampur outpost along with the staff apprehended 2 persons near Kathalguri village, namely Abu Sharma and Safiqul Islam, while smuggling 18 numbers of petrol in their ISA truck. During the course of investigation from their interrogation, it is found that on 13/5/2024, they came to the border.
So let the TCR come, right?
Then in the meantime,
Or, my lord,
TCR come, there may be some order where it is.
my lord, lordship, my lord, also, my lord, you dispose of this application, my lord, directing to APR, file and phrase application, my lord. Because, my lord, charge sheet submitted in the year 2024,
After
rejection,
filing charge sheet,
rejection order is of 2023, 2025 March, my lord. So, my lord, can be disposed of, let them file a phrase application before the trial court, my lord. Because at this
after
now,
filing
my lord,
charge sheet, we
the
approach, my
trial
lord.
must have been, my lord, proceeded, my lord.
Here may be called for, my lord.
No, he is.
The case is
No,
pending.
he is correct in saying that March 25. Now we are in the
Case is
end
still
of
pending
26.
for, my lord, appearance stage, my lord.
No, you can file another fresh application before the trial court.
Direction will be given, I will file.
Okay,
Yes, sir.
and they will consider.
Yes.
Okay, heard Mr. A. Hawari, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state, by this application. Filed under section 528 of BNSS 2023, the petitioner has prayed for defreezing the saving bank's account of the petitioner. Full stop. The petitioner has also prayed for quashing of the order dated 26/3/2025 passed by the learned SDJM within bracket M Gosaigaon in PRC case number 191 of 2024 corresponding to Gosaigaon Police Station case number 72 of 2024 registered under section 379, 411, 34 of IPC read with section 13(1)/14 of Assam Cattle Preservation Act 2021. The learned counsel for the petition, the case of the petitioner is that An FIR was lodged on 14/5/2024 by 2024, by which it was inter alia stated that one vehicle coming from West Bengal side was found loaded with cattle. And when the police personnel tried to stop the vehicle, the driver did not stop and drove the same in high speed. Thereafter, the police personnel somehow could stop the vehicle, and on search being made, 18 numbers of bull were found tied in with their legs and mouths, and the said bulls were seized by the police personnel. Full stop. On completion of the investigation, the police has submitted charge sheet on
36/2024.
30 charge sheet. Where is that?
21 it is.
21. Charge sheet on
30 June 2024.
36/2024. Full stop. The learned counsel for the petitioner submits that in the said charge sheet, there is no mention about freezing of the account of the petitioner. Full stop. He further submits that an application was filed by the petitioner, being petition number 690 of 2025, for defreezing the account, being account number 3297 500 6653. Full stop. And the learned court of Subdivisional Judicial Magistrate M. Gosaigaon, after hearing the parties, had rejected the said application for defreezing the account. It was stated in the order that finding sufficient materials against the accused person, the police had freezed the account of the petitioner. Full stop. However, it is seen that the FIR was lodged in the year 2000, in the month of May 2024, and the charge sheet was submitted in the month of June 2024, and the order refusing the defreezing of the account was passed on 26/3/2025. Now we are in the month of August 2026. The instant petition has been filed on 24th of August 2026 after such a delay. It is as such seen that the order of the trial court was way back in the month of March 25, and now there will be lot of changes in the said case. As such, the petitioner is directed to move a fresh application before the Court of Subdivisional Judicial Magistrate Gosaigaon, if required and if advised. Full stop. Petition is as such closed. Make a face. If it is again denied, then come. But after so many months, yes. 26, Mr. Kotoke. 31. আৰু কোড নাই নেকি আৰু কোড নাই নেকি এনেকে যে লিষ্ট কৰিছে আৰু কোড নাই নেকি yes
This petition is the midst of trial, my lord. Come before lordship, but we don't
further cross examination.
The 311 petition was filed, page 9, page 48, my lord. Where we want to cross examine petition 1 regarding the place of birth of the.
Was it required for just the decision of the case?
Yes, because The certificate, the birth certificate we found is doubtful.
So where is the order? Show me that order. 1-8.
It was that your lot will find that order into order is that 1/8/2026, page 53.
1-8. Uh-huh.
Page 53, madam.
Page 53.
Because there's a doubt that the certificate was, the birth certificate was, because it was drawn after 18 years.
Not about when she we learn it from the one question is not so okay, she was born, but she does not know. And as such, we are very similar. Acha, during her deposition, she did not say where she was born.
No, she was not.
And then now she will know where she was born.
No, the mother. We want to ask the mother.
Ask the mother.
PW1.
But what justice will be delivered?
Because no, you're also they're relying upon a birth certificate. That is an HR 8 page 47. That birth certificate,
PP,
but-
1 second at a time for she was not showing only delay in filing into election. So then what?
Well, basically, because you'll also find the birth certificate there is, because now in view of the legislation amendment of 2017, the birth certificate, the date of birth has to be from the birth certificate, otherwise or from the matriculation. So they have exhibited one birth certificate, annexure 8 page 47. The date of birth is recorded is 2006, and but it was registered, it was issued was on 2018 after 12 years.
Date of issue 10/4/2018.
Yes, ma'am. After 12 years, ma'am.
After the case was registered.
Just before the case was registered, my lord.
Just before the occurrence.
Not because the occurrence was, yeah, after filing, after being a major, she filed a case, ma'am. After being a major, she filed a case. Now the question is that we are doubt that this certificate is also properly obtained. For that purpose, we want to know where she was actually born. If it is hospital, then we can call for the hospital records, verify whether.
But this certificate was there when she was examined for the first time. When did you not?
That was left out. That's why I want to put that question when, because we want to.
Why left out? The advocate was not proper in examining. That cannot be a ground for 311.
Because it was later on exhibited, my lord. Anyway, because the birth certificate doesn't say where it was, what took place, my lord.
Place of birth is there. Barni, Hajo, Barni, Bamuni Gaon.
That is the village, my lord. There's a residence, my lord.
Place of birth.
Place of birth, but it was most probably in the hospital or that, for that purpose, we have to verify, man. That's one line question, man.
This was there when she was cross-examined. What is the need?
That was.
How will it change the nature of the case?
Change it because we want to show that if she is born in hospital, at least we can bond on the record from hospital that whether there was exist on the year 2006, she was born in hospital or not.
Sure. So you are disputing her birth certificate.
Yes, man. That was most probably it was fraudulently obtained.
So what is the case about?
Case about section 8, man. Bad touch.
POCSO. Oh.
That's why the certificate.
To see her majority, minority, and all that.
On that count, otherwise not.
But it was available, not? It was like available during that time. Okay, heard, Mr.
My humble submission, my lord, 311.
Kotoki, learned
In the case of POCSO, my lord, so let the notice is to go, my lord, because victim has to be hard on every step, my lord. It is a case of POCSO, my lord, and Lordship is well aware about the, my lord, provision of 311, my lord. For what purpose, my lord, 311 can be used, my lord? It is not to fill up the lacuna, my lord.
PW1 is the minor child.
No, with the mother of
Mother.
informant, my lord. So let the notice go, my lord, this.
This birth certificate was seized from the mother.
She has exhibited.
She has exhibited.
Yes, yes.
And according to her, her date of birth was this 2006.
6. 15/5/2000 as per the birth certificate. But when the child was asked about the meeting was asked about the death, she says that I doesn't know where I was.
Instead of giving notice and all, let for just decision of the case,
No, my lord,
let
that
this be allowed.
That is my submission, my lord. 311 is only for to, my lord, for the end of justice and for the judgment.
No, if they are disputing the date of birth
So
certificate.
then, my lord, the informant has to be heard, my lord, because he has informant as per POCSO, my lord, and the recent decision of our honorable High Court, my lord. My lord, victim has to be heard on every stage of the, my lord, trial or any proceeding, my lord. So looking maybe issued, my lord.
What answer she will give? It is only mother will be
It is, my
examined.
lord, without hearing them, my lord, informant, my lord, if lordship is disposed
But
of
it
this
is
case,
mother who has to be again re-examined.
but the case is under POCSO, my lord. The trial is going on under POCSO Act, my lord. And lordship may kindly see the impugn order, my lord. What is wrong in the impugn order, my lord? After, my lord, after 3 years, my lord, examining the cross-examining the, my lord, PW1, they has filed his application, my lord, to fill up the lacuna.
Okay, heard Mr. P. Kotoki, learned senior advocate, assisted by Mr. I. Chaudhary for the petitioner and Mr. R.J. Borua. By this application, the petitioner has challenged the order dated 8/1/8/2026, passed by the Court of Additional Sessions Judge, Special Judge POCSO, Kamrup M, in Sessions Special Case Number 19 of 2023, by which the petition filed by the petitioner for recalling PW number 1, the informant, for further cross-examination was rejected. Issue notice, petitioner to take steps for service of notice upon respondent number 2. Scan copy is not required, no? No. List this matter after 2 weeks on a date to be fixed by the registry. No, I could have disclosed it.
Let the informant appear.
In further proceedings now, the kind of argument that he is making, even further proceeding you have to hear. I was thinking to dispose it of. Okay.
Further proceeding, because 330 statement has been fixed for 330. That is another submission, my lord.
Then-
End of the trial, my lord.
Then
End of the trial.
we have to hear the victim. That is too much actually.
It will delay the matter.
Delay. Absolutely. Yes. Will to take it up. You to take adjournment in that case.
Naturally, we will take it. The deadline fixed, my lord.
Okay. List this matter on 11th of September.
We'll take steps.
27.
Not 2 weeks, huh?
But they start post, my.
What? Speed post?
Speed post.
Or through what? Or through the office of the PP?
Not a bail application, so let it go about speed post, my.
Speed post. Yes, yes. What is this, Mr. Dury?
Your Lordship, I'm challenging and it's complaint, Your Lordship. I give it.
Let notice go.
Yes, Your Lordship.
No time.
Yes, Your Lordship.
Notice go.
Yes, sir.
Heard Mr. T. Deuri, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. By this application, the petitioner has prayed for quashing of the impugn order dated 8/4/2024, passed in DV case number 126 of 2024, by which the Court of Subdivisional Judicial Magistrate Nagaon had issued notice to the petitioner directing them, petitioners, directing them to show cause as to why what happened? Summoning.
Yes, Your Lordship, but Your Lordship may kindly take up.
Where is that order 8/4?
8/4, Your Lordship, page 31. The domestic incident report was not taken into consideration. Your Lordship.
Acha, issued notice, to the respondent. Issue notice. petitioner to take steps for service of notice upon respondent number 2. Mr. R.J. Borua, learned counsel, appears for respondent number 1, and as such, no formal notice is required to be served upon him. The prayer for interim would be considered on appearance of the respondent number 2. Place this matter on 14th of September. Yes, 28.
Wait, please. In this case, Lordship, final report was submitted. Thereafter, the complainant has filed a complaint case without following the requisite section of 223 and 225. Lordship will kindly see.
Final report given. And then she must have filed a protest petition. What?
Yes, that was the procedures. They should have filed protest petition challenging the final report. Then the protest petition may be given a reinvestigation or converted to a complaint petition. That is the procedure, Lordship. Now, what he has done, final report, Lordship, would see at page 37.
Then what did they do?
Yes,
They filed
Lordship,
complaint.
Page 22, Lordship, will see the complaint now.
Page 22.
22. The prior in the complaint.
Okay, let notice go. Now it is almost 5.
Yes, Lordship. Only page 22, prior, Lordship, no challenge to the final report.
Acha, this is a fresh complaint.
Fresh complaint.
That can be done, I think.
Lordship, but it has to follow the prerequisites of 223 and 225. Lordship, therefore, what I'll say, Lordship, today has no time, Lordship. Lordship may take next week, Monday.
Okay. On the prayer made by the learned counsel
It will
appearing
take some time, Lordship.
for the petitioner, list this matter on Monday will be 31st.
30%.
There were so many matters.
Or any date next week. Any date, Lordship, please.
List this matter on? Ab bolo.
Any date.
Second. 2nd of
Yes, Lordship, any date.
August. 2nd of September. Okay.
It will take some time there.
There is no time. And I cannot apply my mind
Yes,
anymore.
yes, Lordship.
29 ki adjourn.
May please, Your Lordship. 528 application, Lordship. We have challenged the entire proceedings pending as PRC case number 57 of 2026 under section 69 of the BNS 2023.
69 is what?
69 is a new section. It was not there earlier in the IPC. It says that sexual intercourse by employing deceitful means. Here the allegation is basically that on the promise of marriage, I had sexual intercourse.
Oh, that is what?
Yes, the Lordship may see the FIR, everything will become clear. The FIR is at page 28, is the translated type copy. I would urge your Lordship, it's late, to read the vernacular, Lordship. It becomes more clear. At page 33.
No. Vernacular is tougher for me.
Okay, so 28, Lordship,
Wait,
will read the
I'll read it, I did it. Humble prayer. Your name is? Raju
Raju
Longfar.
Yes.
Okay. Okay, yes. Then?
I'll place very quickly to attract the false promise of marriage. That promise has to be made at the initial stage of getting into the relationship. And that promise has to have a direct nexus with the alleged sexual acts. Here, if your Lordship reads the FIR, the allegation starts from
He fell in love with me and also promised to marry me.
10/10/2022.
10/10/2022.
From there till 5/4/2025, there is no allegation, Lordship, of any sexual intercourse. So the there is no proximate, the promise doesn't have a live connection with the sexual intercourse that have. That is a very subtle law. I have certain judgments.
Then what happened? Charge sheet submitted?
Charge sheet has been submitted. FIR was registered under 4 sections. The other three sections, the charge sheet was not submitted. Only under section 69 was there. Thereafter, charge sheet, I'll just take your Lordship.
Charges framed?
Charges framed? No. Cognizance has been taken under 69. Summons have been issued.
Summons issued.
So now I am before your Lordship. That order, cognizance order, your Lordship will find at page 50.
Admittedly, of course, that 69 will not come, but then if any other offense comes, then rape and all.
No, rape they have not alleged. Nothing.
Not alleged is a separate thing. They can always add.
Details for that also, that He did
If-
not
if
call,
we have
my
to
lord.
go by the definition of rape, the earlier one, then there has to be a misconception of fact. And again, the law is almost similar, that the promise of marry has to have a direct nexus. So here, if you're not.
Acha, rape will also not come. It was not, it was
No,
seems to be
kindly say, my
consensual.
lord, what is there in the FIR, my lord?
Mm.
মানে ইমান তাৰিখৰ পৰা মোৰ লগত চিনাকি হয় 2020 পৰা 22 মাইলত মোৰ লগত চিনাকি মোক ভাল পাই বিয়া কৰিম বুলি প্ৰতিশ্ৰুতি দিয়ে মাইলত
Mm.
মাইলত ইনিচিয়েলি মাইলত he proposed then he have assured to marry her মাইলত যোৱা ইমান তাৰিখে that is the 5/4/2025 তাৰিখে
So all
বিয়া
these
যদি
3
বিয়া
years,
কৰিব বুলি পৰোচনা দি মোৰ ঘৰৰ পৰা মোক গুৱাহাটীলৈ লৈ যায় গুৱাহাটীত আম্বাৰীত এটা ভাড়া ৰুমত মোক ৰাখি প্ৰায় 3 মাহ মোৰ লগত শাৰীৰিক সম্পৰ্ক কৰে মাইলত
she is not a girl of 10 years.
But definitely, but it was a false promise, my lord, to marry, my lord.
No, for 3 years, there was no allegation.
Lordship, one thing will
Not 3 years, my
clarify.
lord.
False promise has to be from inception.
Yes, let's settle the lordship. I have
Ah,
judgments.
those are there.
Then, my lord, since it is such that case, lordship may kindly call for that scan copy of the TCR, my lord.
Eh, not required in all, each and every case. You
Lordship,
call.
one more thing I'll submit.
Hmm.
I have
Yes,
applied for
Mr. Bora.
anticipatory bail.
Sorry, bidding for
One
the
paragraph
respondent.
which makes it very clear.
The bail order will not. be.
183 statement was produced, and therein the court has come to a categorical finding that she has stated that we used to stay as husband and page 56 of para 6 you'll find. This is the order of this honorable court. Para 6.
Mm.
I'll not read, lordship may read on perusal of, that is the 5th line of the para 6. And thereafter the last line of para 6 makes it clear, lordship. So at this stage,
Introduced her before his officials as his wife.
family members were.
But I submitted, there are some dispute errors and there was differences. Yes, Mr. Bora?
Lordship may kindly see page number 42. The
What? Page number?
42. There is
42.
42. There is the charge sheet.
Yes.
May I read, Lordship?
Mm.
During the period of investigation, the statement of the witnesses and FIR named accused person, it is revealed that the FIR named accused Raju Rongfar eloped complainant victim Miss So-and-so from her parental residence with a promise to marry her. So initially there was a promise of marriage and started living together, and thereafter they started living together. So the thin line is, firstly, whether the promise was made prior to the physical relationship or not. That is required to be decided by this honorable court or by the trial court. After living together for about 7 months, whenever the complainant victim requests him for legal marriage, he gets angry and started quarrel. Later, the FIR named accused left the complainant victim and moving out. So, from the reading of the charge sheet, Lordship, it is very clear that initially a promise was made to the alleged victim, to the respondent number 2, and thereafter they started living together. For 3 years, they lived together. For some reason,
So there was the promise. She believed that promise.
And there the Supreme Court clearly.
She is
said
not
that
she is
it
not
takes
such a,
everything into active
she
consideration.
is not such a minor girl that she can be deceived to such an extent.
yes, understood, because there was a,
So many
in fact,
years.
why they live together, because there is a ritual. The victim belongs to the Boro community and the petitioner belongs to the Karbi community. A ritual had taken place in the residence of the victim house, Lordship.
What
There is also
ritual?
some small ritual, and after that they came to Gauhati
So the
and they
false
started.
promise goes on his own statement. Lordship.
So the false promise goes, you have married.
And on
No,
what
no, they
authority?
He had married you.
They did not marry.
He himself.
Yeah, kind of marriage.
They did not get married. That is the
He would
difficulty.
have run away from that ritual also if
But
he
the
had
family
bad
members were that
intention.
he accepts it, and a ritual has some sort of a
Now,
traditional ritual took place.
now the petitioner says that I don't want to marry.
Maybe something has happened. Now he can say his false promise has to be there from the initial.
But
Now something had happened and he is rejecting. Fair enough.
But from the reading of the charge sheet, Lordship, it is apparent that initially there was a promise. So
Initially,
tomorrow-
yes, there was a promise to marry.
Yes.
It was not a false promise to marry.
That is,
might be a breach of promise.
Lordship, that is the point. Whether it's a false promise of marriage or it's a breach of promise of marriage, from the reading of the charge sheet, it is not clear. And therefore, it's a tribal issue. Therefore, this honorable court at this stage, in my respectful submission, cannot decide that whether it
No,
was.
not required. These cases should not deter, I mean, shouldn't, it's a waste of time for the trial.
The Lordship may call for.
Without
Call for
wakalat,
Waste of time
No,
for
I
the
have filed my
trial.
wakalat number. I have filed my wakalat number.
No, see, it's okay. He can say. But these are waste of time of the trial court. One big girl above 18 years will move on moving.
Tomorrow the date
person.
is fixed. Tomorrow the date is fixed for
Huh.
appearance as well as photocopy. Let the copy be received by the petitioner.
No, it's like
and
harassing the.
Let them file it by way of.
No, it's okay.
additional-
I heard Mr. MP Chaudhary. learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the, this is the last case I'm taking up. R.J. Borua, learned counsel for the, no, I'm dictating, don't come now. Learned counsel for the state, and Mr. R. Bora,
Lordship.
learned counsel for the victim, for the informant. Huh? By this application, the filed under section 528 of BNSS 2023, read with article 227 of the Constitution of India, the petitioner has prayed for quashing of the Khairani police station case number 10 of 2026, registered on 1/3/2026
Yes.
under section 69/131/296/324/4 of the BNS 2023. Corresponding to PRC case number 57 of 2026, pending in the court of Learned Judicial Magistrate First Class Hamren, West Karbi Anglong. The petitioner has also challenged the charge sheet submitted in the instant case against the petitioner under section 69 of the BNS 2023, as well as the subsequent order passed in PRC case number
57 of 20.
57 of 2026. The case of the petitioner is that an FIR was lodged on 1/3/2026 by Srimati Frebolin Brahma, stating inter alia that she was in love relationship with the petitioner since 2022, and that the petitioner had promised to marry her, and they were in a relationship. Full stop. It is further stated in the FIR that on 5/4/2025, the petitioner, with the intention of getting married to the victim, alleged victim, took her to Gauhati from her home, and that physical relationship was entered into between the petitioner and the alleged victim. It is also stated that thereafter, the petitioner had taken her to the police quarters, and there also she was subjected to physical relationship for a period of 7 months. Thereafter, the alleged victim states that whenever she raises the topic of marriage, the accused person, that is the petitioner, used to threaten and assault her in the police quarters. She thereafter stated on subsequent days too, she was assaulted, and that the petitioner had injured her by going to her place. With the further allegation that family members of the petitioner had also abused her by going to her room. On completion of the investigation, the petitioner, on completion of the investigation, the police had submitted charge sheet on 24/7/2026, white charge sheet number 24 of 2026, matching 26. Subsequent thereto, the case was listed before the Judicial Magistrate First Class Hamren West Karbi Anglong, and cognizance was taken by order dated 31/7/2026. Cognizance of the offense was taken against the petitioner by order dated so and so. Mr. M.P. Goswami, M.P. Chaudhary, learned counsel for the petitioner, submits that the instant case was although registered under section 69 along with other sections of the BNSS 2023, but the charge sheet was submitted by the police and the petitioner was only charged under section 69 of the BNSS 2023, BNS 2023. He submits that under section 69 of the BNS 2023, it is provided that whoever being in a position of authority or in a fiduciary relationship. 69, right?
69.
Oh. Hey, provider, I'm thinking, what is this fiduciary relationship? Okay, huh? Whoever, katidiba, by deceitful means or by making promises to marry to a woman without any intention of fulfilling the same, establishes sexual relationship with the woman and which do not amount to the offense of rape shall be punished with the prescribed punishment. Full stop. He submits that the promise not to marry the victim should be there from the very initial stage. And that if that promise was there and then it was broken by the person towards that woman, the offense will not be established under Section 69 of BNS 2023. In the instant case, he submits that the petitioner had, in fact, promised to marry the victim, which is writ large in the FIR itself, as it has been stated therein that the petitioner is known to the victim since 10/10/2022, and that petitioner fell in love with her and had promised to marry her. There was no averment in the FIR that the petitioner had given a false promise of marriage. Whether there is any, nowhere, right?
No.
False, Kikolo? False promise of marriage to her and took advantage of the situation and had entered into physical relationship with her. He submits that it was a clear case of that it is clear from the FIR that it is. He further submits that from 10/10/2022 to 5/4/2025, there was no allegation against the petitioner by the victim, and that they were having the relationship and had also entered into physical relationship. The learned counsel had also placed the had also placed the order passed in the bail application, which although cannot be considered in this petition, but only to the extent to see the victim's statement that has been recorded by the court under section 183 of the BNSS. And in the said order, it is seen that the victim had stated before the magistrate that they were living as husband and wife, and that the petitioner had also introduced her before his officials as his wife. As such, he submits that ingredients of section 69 is not meted out in the instant case. On the other hand, Mr. R.J. Borua, learned APP for the state, submits that with the promise to marry, the petitioner had entered into a physical relationship with the victim, as could be seen from the bare perusal of the FIR. He has also placed the charge sheet wherein it is stated that petitioner had taken the victim from her parental house with the promise to marry her and started living together and maintained physical relationship. And that after 7 months, the petitioner refused to marry her. Full stop. Mr. R. Bora, learned counsel for the informant, had also stated that there was a false promise to marry and the petitioner had taken advantage of the victim, had taken advantage of the situation and had established physical relationship with her, and which becomes an offense under section 69 of the BNS 2023. I have considered the submissions made by the learned counsel and have gone through the records. A simple reading of the FIR itself shows that petitioner and the victim were in love and the petitioner had promised to marry her way back in the year 2022. It is also in the submission of the learned counsel for the victim that there was some ceremony initiated. No, there was some ceremony carried on between the petitioner and the victim as per the local practice, which is as per the local practice, which is done before someone gets married, right? Before someone gets married. Full stop. As such, it is seen that there is no false promise to marry. In fact, the petitioner wanted to marry the victim, but it is seen from the FIR that later on, that is after many years, there were quarrels and the petitioner had deferred his marriage with the victim. It is also stated in the FIR that the victim had gone with the petitioner to different places and they had entered into physical relationship with each other. It is not seen that the petitioner, by using fraudulent means or by using deceitful means, or by making false promise of marriage, had forced her to enter into any physical relationship with him. It is a normal situation where promise to marry a person can change with time. And the decision to marry can change with certain occurrences. It is a different aspect that with the intention not to marry from the very first instance, a person deceiving the companion and establishing physical relationship. However, it seems that is not the case here.
Lordship, may I humbly submit? The intention is clear from the FIR itself because the FIR says that whenever the victim asks for the legal marriage, he denied.
That is after 3-4 years.
No, that is what the FIR says, that whenever. She does not say that after 3 or 4 years.
No, but then see, the accused with the it took me. It's a continuous.
Yes,
it's
yes, I understand.
thing. These are continuous facts.
But she never said that after 3 years I asked the petitioner to get me.
She never said. But then see the way the FIR has been lodged. 10-10, 5-4-25, such and such thing happened. 25-6-25, such and such happened. 3-9. So it's a continuous actions.
Lordship.
It cannot be said that it was from the beginning. Full stop. Indeed, you have given me another point. Yes, and it is also noticed in the FIR that the victim had chronologically stated the facts, and wherein it is seen that after 10-10-2022, there was no allegation against the petitioner leveled by the victim, and that subsequent to 5-4-2025, she had leveled allegations against him. And later on, she said that when she initiated the topic of marriage, the petitioner used to threaten and assault her. This particular statement cannot be considered to have happened before 5-4-2025, when she first alleged misdeeds by the petitioner. Give me a decision. The Honorable Supreme Court. There were so many decisions. The Honorable Supreme Court. Mhm.
My humble
Lordship may
submission,
call
my lord,
for the
even the,
records
my
at
lord,
least.
that part is also goes, my lord. The other part will remain, my lord. So my humble submission, my lord.
No, rape will not come. Because
the other
69
part, my
is.
lord, the cheating, my lord, deception, that will come, my lord. So my lord, let the notice be since he has already appeared, my lord.
No, notice.
Lordship may
It's a
stay the
useless
proceeding.
thing.
Lordship may
It's a useless thing, issuing notice, wait, and then the case gets interrupted.
Without examining the, my lord,
records.
PCR, my lord, without PCR, my lord.
Not required, not required.
Lordship may stay the proceeding, Lordship. I do not have anything to say, Lordship.
The Honorable Supreme Court.
But at least your Lordship may examine 183 statement.
No, these cases can be disposed of, no issues.
Because the FIR is not an encyclopedia, Lordship.
No, and the FIR I'm not holding, yeah, when the charge sheet is not in the.
The charge sheet has only 4 lines, Lordship. The charge sheet is also not an
Charge sheet also doesn't have give materials.
But
Okay, the Honorable.
in the 183, Lordship.
The Honorable, further, the charge sheet submitted in the instant case also did not. Why these cases? These cases should not be law. She should have gone and married someone else. Why this? Unnecessary. Too many cases for nothing. In the charge sheet also, it is seen that it was in the charge sheet also it is seen that the investigating officer had recorded the statements of the witnesses, and it is found that the petitioner had eloped with the victim from her residence with a promise to marry, and that they were living together and maintain physical relationship, and that after living for 7 months, when the victim requested him for legal marriage, the petitioner is stated to get angry and started quarreling with the victim. Full stop. This statement itself shows that it was later in the point of time that the petitioner had refused. Not refusal, no. Later in the point of time that the petitioner had quarreled with her over the subject of legal marriage. Even the statement of refusing the marriage is not there, either in the FIR or in the charge sheet. The Honorable Supreme Court, which case is the good case?
Lordship,
The Honorable
Suryaban Power started it. This 2019 case is discussed in both the other cases. So
Which
Lordship
one?
may rely on, the latest one is, Lordship may rely on this one. This was passed by Honorable Justice Koteshwar Singh.
No, whether this order has been passed, my lord, without perusing the, my lord, TCR, my lord. If it is bar in the motion instance, my lord, I do not have any objection, my lord. Let my understanding.
I'm dictating the order, you please sit. I'm not going to hear anything more. I have said I'll dispose it of. You file an application before the Supreme Court, okay? Against this order. Don't keep on interrupting.
2024-11 SCC 398.
Para?
Lordship may, the paras, the 11 paras start from. Lordship may, it starts from 25. Para.
The Honorable Supreme Court in Mahesh Damu Khare versus State of Maharashtra and another, reported in 2024-11 SCC 398, had held the Honorable Supreme Court in a number of cases, one being one being so and so, had held that which is the relevant?
25, Lordship, this judgment discusses other judgment that promotes. Lordship may go in 27. The findings are there. In our view.
Yes, has held.
Yes.
Of making a
27, Lordship, 28.
Physical will not be traceable directly to the physical honest made and are not qualified.
27 onwards, it has been like, a lot of factors have been
It has
decided.
held that the promise, that the false promise of marriage should exist from the very first instance. And only on that count, Section 69 would be attracted. In view of the findings narrated above, this court finds it fit to quash the first information report lodged on 1/3/2026 before the Khairani Police Station. Registered as Khairani Police Station case number 10 of 2026, as well as the charge sheet being charge sheet number 24 of 2026, filed on 24/7/2026, as well as the PRC case number
57 of 26.
57 of 2026, along with the orders passed therein,
Pending in the court of JMFC.
or pending in the court of JMFC,
Hamrin, West Karbi.
Hamrin, West Karbi Anglong, as well as the subsequent orders passed therein. Petition is disposed of.
Lordship, may I make a humble prayer, if your Lordship allows. Your Lordship may kindly make an observation that the petition is disposed of at motion stage itself.
No, I'll make it in the first stage. Why? Is it the first time that I'm disposing of motion stage?
I'm not
What
saying
is the-
this order will help me in other cases, Lordship. That is what I'm.
What is the big
That
deal
is what I'm
about it?
saying. Because I have some other cases that will help me in other my cases.
You have all appeared sometimes through even motion stays, even without appearance of
Yes,
the
yes.
informant is disposed of. What is the big deal?
We also don't object, my lord, if something Lordship is.
No, in between the order, you should not give, and for the sake of
My lord,
objecting, what is this?
Because my lord, whatever
You
my
know
learned
that
friend is,
you,
my lord, cited
you,
some
you are a lawyer for so many years. I was a lawyer for so, don't we know that it can be disposed of in motion stage?
It can
Where
be,
is the
but
bar?
my lord, when my learned friend, my lord, he is citing some ruling, my lord. They should, my lord.
Doesn't
they
matter.
serve
He's
a copy,
citing
my
on those, that motion
They
stage
should
it can
start
be.
serving some copy to us so that we can also go through and we can also submit, my lord.
Arey,
It's also our duty, my lord.
in each and every case, if those judgments are exchanged, one or two cases can be disposed of in a day. Yes. Hey, you take the, now it's 5:30. I cannot.
My lord, item 56, my lord.
They will give you the dates.
Motion matter, my lord, may Monday, my lord. Earlier August, my lord, already left over.
Okay. Motion matters next week.
Monday.
Lordship, in item number
Item
37.
55, my lordship, yeah. It is
Lordship,
very
next
urgent.
trial court date is 8/9/2026, Lordship.
Okay,
Any
tell
date
Mr. Courtmaster, he'll fix it before 8/9.
Yes.
Okay?
Item 55 on Monday, my lord. It is very urgent matter because this is the NAC matter and the accused person.
Let this Saturday, Sunday go. It's okay. He'll give you the date. Okay.